There are amendments that are out of order. 362, 364, 366, 360, 357, 452, 418, 466, 419, 456, 401, 455, 416, 394, 414, 412, 411, 397, 413, 395, 449, 402, 457, 421, 487, 489, 486, 453, 485, 484, 483, 482, 481, 476, 403, 445, 477, 363, 451, 447, 417, 359, 491. Hearing no objections, 447, 470. With the consent of the House, the following amendments are withdrawn. 468, 469, 470, 488, 474, 463, 467, 461, 464, 475, 353, 374, 430, 426, 424, 415, 423, 400, 465, 478, 473, 378, 379, 407, 406, 398, 409, 370, 438, 427, 431, 432, 433, 434, 425, 399, 422, 376, and 479. Hearing no objections, so ordered. There are further amendments to the substitute. Amendment number 393, clerk will read.
On page 9, beginning on line 22, internal references accordingly.
Representative Couture to move the amendment.
Thank you, Madam Speaker. Please move Amendment 393.
It's been moved and seconded that Amendment 393 be adopted. Remarks, Representative Couture.
Thank you, Madam Speaker. This amendment recognizes the timeline to receive and obtain a parent's child's education records that were established in Initiative 2081, the Parents' Bill of Rights. Essentially, what the underlying bill does is it says that you can have up to 45 days to provide access to parents their child's education records. And what this amendment would do is bring it back to what the Initiative 2081 previously stated in its current law right now, which is 10 days. I think, Madam Speaker, that 10 days is a reasonable amount of time to be able to get your child's records from the school, and that 45 days, essentially a month and a half, is far too long potentially to wait under the underlying bill. I think what parents want in the state of Washington is to be able to obtain their child's records as fast as possible, urging its adoption.
Further remarks, the good member from the 37th District, Representative Santos.
Thank you, Madam Speaker. While we do believe that the language does not prohibit school districts from being more responsive, this amendment is acceptable, and I ask you to support it.
Further remarks? Oh yes, thank you for reminding me, both of you. The good member from the 35th District, Representative Griffey, to excuse members.
Yeah, thank you, Madam Speaker. I apologize. Could you excuse Representative Dent?
Representative Dent is excused. The good member from the 40th District, Representative Ramo.
Thank you, Madam Speaker. Please excuse Representative Fye and Representative Rule.
Members excused. Further remarks? Seeing none, the question before the House is adoption of Amendment 393. All those in favor say aye. Aye. Opposed say nay. The amendment is adopted. Amendment number 472, clerk will read.
On page 11, beginning on line 21.
Last line.
Insert or as otherwise prohibited in.
The good member from the 35th District, Representative Couture, to move the amendment.
Thank you, Madam Speaker. Please move Amendment 472.
It's been moved and seconded that Amendment 472 be adopted. Remarks, Representative Couture.
Thank you, Madam Speaker. Permission to read.
Please proceed if it's relevant.
Thank you. This amendment restores the right of parents and guardians to receive assurance that their child's public school will not discriminate against their child based upon sincerely held religious beliefs of the child's family. Madam Speaker, it's my belief that Washington State is filled with a good-hearted people that do not wish to have discrimination in any space, including our public schools. And the underlying bill does talk about some levels of discrimination it wants to protect students from. However, what is missing from the bill and what was present in the initiative 2081 is the protection against discrimination for the parents and the families and the child's religious beliefs. And I feel that it's important that the state, including school staff and teachers or any school administration, does not get in between the parents and the child and their deeply held religious beliefs. We heard a few nights ago about religious exemptions for vaccine mandates, for example. We don't want schools or any public entity to get in the way between parents and children when they have deeply held religious convictions. That is their First Amendment free right to express their religion and practice their religion. We should be protecting those First Amendment rights as enumerated in our U.S. Constitution, our state constitution, and I urge its adoption.
Further remarks, the good member from the 37th District, Representative Santos.
Thank you, Madam Speaker. Asking you to vote no against this amendment, not because we don't believe that students should receive every protection against discrimination, but we already have in statute, and if I may read, Madam Speaker.
Please proceed if it's relevant.
Thank you, Madam Speaker. RCW 28A 642010 already prohibits discrimination. It says discrimination in Washington public schools on the basis of race, creed, religion, color, national origin, honorably discharged veteran or military status, sexual orientation, including gender expression or identity, the presence of any sensory, mental, or physical disability, or the use of a trained dog guide or service animal by a person with a disability is prohibited. Madam Speaker, this is the definitive anti-discrimination statement for our public schools. This other amendment is not necessary. I ask that you turn it down.
Further remarks, the member from the 2nd District, Representative Marshall.
Thank you, Madam Speaker. I would urge yes on this. Parents under the Constitution and natural law have a fundamental right to raise their children according to their religious as well as their personal beliefs. This has been upheld by the U.S. Constitution as well as the U.S. Supreme Court. The Supreme Court has said in multiple cases that this is a fundamental parental right under the 1st and 14th Amendments, and I urge we adopt this amendment.
The member from the 19th District, Representative Walsh.
Thank you, Madam Speaker. A good amendment. Please vote yes. Madam Speaker, to the particulars of the policy at hand, when we were developing the Washington Parents' Bill of Rights, it was a specific concern that parents mentioned that their children, their families, and they themselves as parents were and would be discriminated against because of their religious beliefs, particularly if they were strongly held and strongly articulated religious beliefs. Madam Speaker, it was a defining part of the process of building the Washington Parents' Bill of Rights. This is particularly important to the conversation that we're having tonight about what it means to have parents' rights in the state of Washington. And it goes beyond just a general conversation about First Amendment. It goes to the particulars of what parents and families and children want and need in this state at this time. Please vote yes.
Further remarks? Seeing none, the question before the House is adoption of Amendment 472. All those in favor say aye. Aye. Opposed say nay. No. The amendment is not adopted. There are further amendments. Amendment number 204. Clerk will read.
Strike everything after the enacting clause and insert the following.
Last line.
Correct the title.
Representative Stonier to move the amendment.
Thank you, Madam Speaker. I move adoption of Amendment 204.
It's been moved and seconded that Amendment 204 be adopted. There are amendments to the amendment. There are amendments that have been withdrawn. Amendment number 388, Amendment number 372, and Amendment number 443. Hearing no objections, those amendments are withdrawn. Amendments to the striking amendment. Amendment number 392, clerk will read.
On page 1, beginning on line 25 of the striking
Last
amendment.
line.
And may place.
The good member from the 25th District, Representative Keaton, to move the amendment.
Thank you, Madam Speaker. I move Amendment 392.
It's been moved and seconded that Amendment 292 be adopted. 392 be adopted. Remarks, Representative Keaton.
Thank you, Madam Speaker. This amendment removes the authority for OSPI to sanction our school districts. What this will do is it'll put us in alignment with our state constitution. Article 9, Section 2 of our state constitution requires uniform funding for all districts with no exceptions. The other thing it'll help with our state constitution is it'll put the school districts, the elected school districts, on equal footing with OSPI, which they are in our state constitution. Our locally elected school boards know the local issues better than anybody else. They're elected and accountable to the people within that district, and they know how to make things work for the best possible outcomes for the future of their students. Please vote yes.
Further remarks, the good member from the 49th District, Representative Stonier.
Thank you, Madam Speaker. I'm asking you to turn this amendment down. I do appreciate the conversation I had a chance to have with the previous speaker. I do know how important it is to fund our schools to deliver education services to our students and do so in a uniform manner. However, in a case where school districts are not teaching what the state has determined ought to be learned in schools, we would then be funding schools uniformly that are providing instruction that is not uniform. And so in order to be consistent, I'm going to ask you to turn this amendment down. I do believe there are some changes in the underlying striking amendment to help address this issue. When OSPI is contacted about a district that may be out of compliance, the underlying striker has new language in it that requires multiple touches from OSPI to consult and ensure that that school district gets the support that they need in order to come into compliance so that they understand the law and how to follow it. Please vote no.
Further remarks, the good member from the 25th District, Representative Jacobson.
Thank you, Madam Speaker. I trust, Madam Speaker, our local school board, and I think that politics should be local. And I think that by removing this ability of the OSPI to sanction school districts in this way, that's harming our localities. We have in this state a bit of a divide going on right now. We've got really rural areas like my seatmate with in the northeast corner where things are quite different than some of the urban areas, and they have quite different things that they need to do and things that they need to teach. So, Madam Speaker, I would accept this amendment on behalf of our local school boards and trust them. Thank you, Madam Speaker.
Further remarks, the good member from the 15th District, Representative Defoe.
Madam Speaker, please vote yes on this amendment. It should not be up to the state to determine who gets money at the local level and who doesn't. There are kids all over the state who deserve to learn. They're entitled to learn under the state constitution. Our own superintendent of public instruction recently said, may I read, Madam Speaker?
Please proceed if it's relevant.
A president unilaterally deciding to cut access to funds unless the programs are in alignment with his political ideology is unprecedented and dangerous. Madam Speaker, if we don't accept this amendment, we'll be doing the exact same thing that the superintendent of public instruction said was unprecedented and dangerous. Please vote yes on this amendment.
Further remarks? Representative Keaton.
Thank you, Madam Speaker.
You have a little bit over 2 minutes remaining.
Thank you, Madam Speaker. This amendment still allows OSPI to put a probationary status on school districts, so that can still take place without violating our state constitution. Please vote yes.
Further remarks? The member from the 16th District, Representative Rood.
Thank you, Madam Speaker. This provision of the underlying bill is troubling to me. We're all familiar with the McCleary decision. Many of us have memorized portions of the state constitution related to the paramount duty of the state to provide ample provision to the education of all children. The people that are hurt by depriving constitutional funding to schools is the children, not the administration. Any kind of disputes that are happening about implementing policies need to be taken elsewhere. Depriving them of funding is not the right way, and it only hurts the students.
Further remarks? Representative Walsh.
Thank you, Madam Speaker. Good amendment. Please vote yes. Madam Speaker, in our Constitution, as you've heard, there is the requirement that funding of our public schools be done in a uniform way to all. To selectively withhold apportionment money or other funds from one school district as opposed to another violates the state constitution. Madam Speaker, it also breaks other language and tradition in our laws, including constitutional and statutory law, that locally elected school boards have what's called broad discretionary power to set their curricula, to choose their textbooks, to hire the teachers and principals in their districts. And that broad discretionary power is equal to the power that the state level executives have, the governor or the state superintendent of schools. There is a false impression that the governor or the state superintendent somehow have a superior power or superior position to determine what a school district does in terms of its policies and curricula and other essential choices. It's not true. They have an equal standing. And really, the spirit, in my opinion, of the Constitution and the statute is that the locally elected school board really has a superior position. Equal at least, and in practice superior to the authority that the state superintendent or the governor has, or really any of us involved in state government. Madam Speaker, this amendment is essential and urgent because the current superintendent of schools has, in the past, mentioned withholding essential money from school districts in order to punish them for not complying with his edicts. Madam Speaker, that is an inappropriate tactic for the state superintendent to use. And without this amendment, the underlying proposal seems to give him some cover to make such threats against school districts. Please, Madam Speaker, it is essential that we continue and strengthen and clarify the traditions of this state, which are that locally elected school directors are the ones who set policy about the schools in their districts. They know what's best for the children, for the kids in their schools, in their area. The state government provides them resources. They make the decisions. Please vote yes.
Further remarks? Seeing none, the question before the body is adoption of Amendment 392. All those in favor say aye. Yes! All those opposed say nay. No! The amendment is not adopted. There are further amendments. Amendment number 404. Clerk will read.
On page 5, after line 9
Last
of the
line.
striking, insert expressions as defined, internal references accordingly.
The member from the 19th District to move the amendment.
Thank you, Madam Speaker. Please move Amendment 404 to be adopted.
It's been moved and seconded that Amendment 404 be adopted. Remarks, Representative Walsh.
Thank you, Madam Speaker. This amendment addresses some language in the underlying proposal which describes, uses a phrase, gender expansive expression or gender expansive students or gender expansive identity. Madam Speaker, our law has no clear definition of what gender expansive means. And we know, having heard from parents and families and school administrators, that in some places, some children consider their gender identity to include non-human characteristics, that their notion of gender includes animal characteristics, a dog or a cat, or mythological creatures, I don't know, mythological creatures. Unicorns, thank you. Madam Speaker, it sounds absurd, but it's not. In our public policy, if we are going to honor that there is gender diversity among people, among humans, that it should be a gender expansiveness that is limited to human gender expression. And so what this amendment does is it narrows this definition of gender expansive expression to human gender. I think this is important for how school districts would handle a child who may be deeply confused about what he or she or they is, and help them grow into a more human notion of their own identity. Please vote yes on the amendment.
Further remarks? The good member from the 22nd District, Representative Parsley.
Thank you, Madam Speaker. I'm going to urge a no because this amendment is just going to further increase our confusion and conflict that this bill is trying to undo.
Further remarks? Seeing none, the question before the House is adoption. The member from the 19th District, Representative Walsh, you have 1 minute remaining.
Thank you, Madam Speaker. I'd like to rebut that con argument, but I'm not really sure how. Narrowing and making more clear an undefined notion in law isn't confusing, it's clarifying. What we're saying is a gender expansiveness can be expansive, but it needs to be human and not non-human or other than human. I don't believe that this is confusing in the slightest. I believe it's clarifying. Please vote yes.
Further remarks? Representative Couture.
Thank you, Madam Speaker. In the previous amendment, there was a threat potentially from the superintendent of public instruction that if there isn't widespread compliance in school districts, that funding could be removed. And if we don't clearly identify and define all the definitions within the bill and make sure that we're all talking about the same thing, it creates a liability trap for schools where people can sue based on certain things that are not well defined in the underlying bill or in the law. And that's not a risk our school districts can take right now, especially with liability insurance being so high, and especially with a lot of liability payouts being so high from schools because of problematic things that are happening in schools. This is a common sense amendment. It's not meant to essentially change anything about protecting against discrimination of anyone with a certain gender identity. However, it's very important that we make sure we clearly define things in the law, because if we don't define things clearly in the law, we heard about McCleary earlier, and there's plenty of other lawsuits, Madam Speaker. Those things end up in the courtroom and they get litigated to death, and I don't think that our state right now with our budget deficit, and I don't think that our schools with their massive deficits, many of which my schools are in the hole, can really afford to not have clearly defined law and then enter the courtroom and get litigated forever. Please vote yes.
Further remarks? The good member from the 44th District, Representative Donaghy.
Thank you, Madam Speaker. I think we've talked before about my son. He is autistic with selective mutism, and communication is really hard for him. One of the things that makes it a lot easier is when he doesn't have to use words. And when he's happy and he greets me, sometimes he'll be wagging his imaginary tail. Or he'll growl when he's unhappy. It's because he has selective mutism. This amendment seems to be based on a fabricated story about litter boxes in schools for children. It wasn't real. It's not an issue. This is not something that is happening in our schools, and so it's really unnecessary to take this amendment. I'd urge you to vote no.
The member from the 19th District, Representative McIntyre.
If it truly isn't an issue, Madam Speaker, then this amendment should be voted yes on. Please vote yes.
Further remarks? Seeing none, the question before the House is adoption of Amendment 404. All those in favor say aye. Aye. Opposed say nay. No. The amendment is not adopted. There are further amendments. Amendment number 446. Clerk will read.
On page 5, after line
Last
7,
line.
insert use as of January 1st, 2025, remain designated for single-sex use.
The member from the 9th District, Representative Dye, to move the amendment.
Thank you, Madam Speaker. I move Amendment 446.
It's been moved and seconded that Amendment 446 be adopted. Remarks, Representative Dye.
Thank you, Madam Speaker. Just a moment, please, while I rip my page out. Thank you. Okay, this one's pretty easy, pretty simple. It just allows the schools to maintain same-sex restrooms, and I think it's an important element, especially as children are through their growth and maturation, have different needs, and keeping children able to use the restroom, the appropriate restroom, is important, and it's very important to me as well as a parent that I want to keep my children safe and keep them able to use the restroom of their biological sex. So I urge a yes vote.
Further remarks, the good member from the 37th District, Representative Santos.
Thank you, Madam Speaker. Asking for your no vote, not only would this amendment be a violation of the statute I previously cited, but it's also very impractical. I'm very proud that SeaTac Airport has moved towards having genderless restrooms. And they have found a way to protect people's privacy. And anyone who's gone through the airport, particularly if you're traveling with small children, you cannot predict when that child is going to tell you, or say traveling with an elder parent like I must on occasion, when that person needs to go to the restroom. You want to go to the nearest restroom. And so as long as the privacy of the persons who are using those facilities are protected, I don't think that there should be any problem. So I ask you to turn this down, both because it's a violation of existing law, but also because it's very impractical.
The member from the 35th District, Representative Griffey.
Well, thank you, Madam Speaker. I have to disagree with the good gentlelady that just spoke. In an airport, they actually have doors on the stalls. In our schools, they do not have doors on the stalls. Madam Speaker, I recently had a meeting with a dad and his very distraught daughter. His dad wanted to know why she came home and had to run to the bathroom really quick. And she said that because there was a man in the bathroom with her, she was scared to be in the bathroom, and she told both of us that she wasn't ready to see that anatomy yet. She was 14 years old, and she was really concerned that she wasn't ready to see the male anatomy. And unfortunately, Madam Speaker, if we don't pass this, if we don't say to our young ladies that we are not going to force you to see what you don't want to see, we're not going to force you to mature any faster, Madam Speaker, than they have to. Madam Speaker, the same young lady stopped showering after her soccer practice also because there was a male showering with her whole team. Madam Speaker, we should not do that to our young ladies. We should let them mature at the rate that they wish to. I urge adoption of this amendment. Thank you, Madam Speaker.
Further remarks, the member from the 39th District, Representative Eslick.
Thank you, Madam Speaker. I stand today in agreement with this amendment. I don't know about you, but when I was in grade school, high school, I remember how embarrassing even same-sex showers were. I mean, it is, these kids need to have their privacy. And this bill doesn't say we don't allow for a restroom for both sexes, because I myself in my life have to go into the handicapped ones with my husband several times. We need those separate, but we need separate ones for our genders, girls and boys. So please vote yes on this amendment. Thank you.
Representative Walsh.
Speaker, good amendment. Please vote yes. Not only do our bathrooms in our elementary schools and middle schools and high schools not often have discrete doors to each stall to use the bathroom, they also don't have family members escorting the children to the bathroom. And in several of these instances we've heard of using more open bathroom planning. We've heard of family members taking the child or the family member into the restroom. One of the things that we need to establish and confirm with the Washington Parents' Bill of Rights is the ability of parents to not be there with their child, to trust and know that not just a 14-year-old girl, but an 8-year-old girl can go into the bathroom and not be confronted with a man present while she's using the loo. This is an important thing, Madam Speaker. It's an important point in policy to maintain the trust that families have that their little children can use the bathroom and not be traumatized or upset by the other people using the bathroom with them. This will allow our schools to provide to those families a value proposition of the education, the high quality basic education they're providing to their children. Madam Speaker, we're seeing a decline in enrollments in our public schools in this state. Part of that is because of the broken trust between parents and the school system. If we vote yes on this amendment, it is a small step toward reestablishing that trust. Please vote yes.
Representative Defoe.
Thank you, Madam Speaker. I'd like to ask you to support this amendment, and I'll tell you why. Right before this debate started, I had the privilege of FaceTiming with my 3 little girls, and I asked them, I said, I might be talking about your schools a little bit here this evening, and I said, is it okay if I talk about you? And my middle daughter said, yes, Dad, will you please tell them that I'm good at most things but not all things? That her older sister likes books and her younger sister is fun to play with. So I'm delivering that message on behalf of my middle child. But the reason I bring this back to the amendment, Madam Speaker, because I think about those girls being in middle school and in high school and playing sports. And honestly, as a dad, the prospect of boys sharing those facilities with them, especially teenage boys, is terrifying. My daughter is in 3rd grade. My oldest daughter's in 3rd grade, and a teacher found her in there playing with another girl, skipping class, coloring on pages on the floor. That's in 3rd grade. Could you imagine what boys and girls in middle school and high school years are capable of in a restroom? It's not a good fit. It's not a good mix, Madam Speaker. Let's be smart about this. We can have multiple bathroom types, one for boys, one for girls, and we can have one for people who want to be all by themselves when they're using the restroom. That's appropriate too. But we should not be combining them all together. And this amendment will make sure that school districts are able to keep that separation that I think is important to almost all the parents in our state. Thank you.
Further remarks? The member from the 12th District, Representative Burnett.
Thank you, Madam Speaker. I too ask for your support for this. A lot of this session, we've been talking about a lot of different policy that has talked about supervision and unsupervised and background checks and making sure that we have people in different positions that are not going to offend and take advantage of the vulnerable. And we know that the statistics out there are really high for people that have been sexually abused, whether you're a male or female, and that potentially those are also persons that have, through that abuse, would go on to abuse through learned behavior other persons. And I think this is a good exception and for us to look at to say, and I would agree from our good member here that just brought up that I think there's room for all of these to be here with the family-style bathroom, with the separation. But specifically, because in a lot of different schools that I've been in, is that there's a lot of unsupervised activity that may go from a junior high facility across the hallway to a high school facility when you have different, development stages from a younger grade to the upper grades. And I think that we're just asking to make our vulnerable kids at a different age, the younger age, more acceptable to this type of abuse. And I think we need to do a better job of protecting them from that. And I think there's room, again, like I said, to do all of the above, and I ask for your support for this amendment.
Further remarks? Representative Penner.
Thank you, Madam Speaker, and good evening. Rising in support of this amendment, earlier in this discussion has brought up the practicality of implementing this amendment. Madam Speaker, for as long as I've been alive, which is not as long as some, granted, single-sex bathrooms have been commonplace. In fact, I think this is a problem that is well established and fixed by societies all over the world to this point. So there is no question about the practicality of using single-sex bathrooms. This is a good amendment simply because it reinforces the fact that these things exist when you go to the mall, they exist when you go to the store, they exist when you go to a restaurant, they exist when you go to many schools, they exist when you go to City Hall, they exist when you go to the park, they exist all around us. Single-sex bathrooms exist all around us. There's no impracticality in implementing this. This is something that we know how to do at this point. And the amendment clearly states it doesn't exclude anyone from using a bathroom of their comfort, including students of any gender identity. So thank you, Madam Speaker.
Further remarks? Seeing none, the question, the good member from the 11th District, Representative Berquist.
Thank you, Speaker Jenkins. Speaker Jenkins, I'm a teacher, I'm a father of a 5th grade daughter, 3rd grade son, I'm also a coach. I also understand that it's Washington state law that protects, it's a protected class, gender identity. And schools need to provide opportunities for the person to go to the restroom of their choice. They also need to provide options for all students to use an additional restroom if they so choose. I do also know that when I'm coaching a sport, the tennis team, golf, usually tennis would be on the school campus, you never know what restroom options you're going to have. And half the time, you're just finding whatever you can that's not locked. Could be girls' bathroom, could be a multi-gender bathroom, could be a boys' bathroom. You're going to take advantage of whatever you can use. This is the type of opportunity that if we don't give them to our students, it affects their mental health. We've had students that didn't feel comfortable using one of the restrooms that would go without drinking water for the whole day just so they wouldn't have to use the restroom. We need to give them the choices that follow Washington state law, and I urge you not to adopt this amendment.
The member from the 25th District, Representative Keaton.
Thank you, Madam Speaker. During the entire 8 years I was on the Puyallup School Board, we were able to manage this and take care of everybody's needs and do it in a way that we gave privacy when privacy was requested, and we were able to manage it. It's very possible to do this because we did it for 8 years. Please vote yes.
Representative Rood.
Thank you, Madam Speaker. I just want to be really clear that this amendment has nothing to do with gender identity. As the ranking member on the Education Committee, I've had the chance to visit quite a few schools. One of those was Avanti High School in Olympia. And to my surprise, this school had actually been built designed around a two-sex bathroom system, which I realize creates challenges, and I absolutely support accommodating all students and the bathroom use that they need. But those two bathrooms had been converted to both be gender neutral. And so I'm 38 years old. I would not feel comfortable going into a high school bathroom with high school girls in the same bathroom. And so I think without that experience touring the Avanti High School, maybe this wouldn't resonate with me the same way. But that created a lot of discomfort for me. And I imagine that for the high school boys and girls, that creates discomfort for them. One of the placards on one of the bathrooms, because the bathrooms hadn't been changed, like physically, one of the identifiers was just a urinal symbol on the bathroom door, and then the other one didn't have a urinal symbol. So I just want to make sure that we're clear that this is not about gender identity. This is just about having those designations. So asking for your support as well.
Representative Couture.
Thank you, Madam Speaker. You know, I have 4 kids, and one of them, unfortunately, has 3 brothers, and she's 15 years old, Stella, and you know, what I realize about being a dad is that she's, you know, she's smart, she's funny, but she's also more vulnerable, soft, sensitive, and shy. And over the years, you know, as all my kids attend public schools up in North Mason County, she has expressed a lot of different concerns about the bathroom policies of the North Mason School District, and also sometimes related to who can come into what is traditionally a girl's space, which is one of my deepest concerns, Madam Speaker, is because we fought so hard as a country to protect women's rights, but now it seems like women's spaces are being invaded, including their bathrooms. And she's expressed to me over time that she doesn't feel always comfortable or safe, and whether that be someone of a different gender or whether that be someone vaping in the bathroom, there's a lot of different bathroom policies and that are concerning, but also, you know, sometimes the school has reacted in the past by literally taking off the stall doors in the girls' bathroom because of other actions. And so typically, you know, a women's bathroom has multiple stalls with doors on them. But can you imagine, Madam Speaker, in a middle school environment when a young girl like my daughter is going through puberty along with other girls in the school, and the school has responded to something like drug abuse or vaping or other, you know, vandalism by stripping the doors off of the bathroom stalls, and then also saying that this is a multi-gendered bathroom. You probably, even if it was a same-sex bathroom, probably wouldn't feel too good about having people watch you. It's not boot camp in the United States Navy, Madam Speaker. I really do hear from my constituents that this is a problem for them. They want to protect their daughters. It's that protective nature. And I'm deeply afraid that we are setting, without taking this amendment, we're sending a signal to parents who are already wanting to disenroll their kids. Homeschool is up, private school is up, and our public school enrollments are down, and it's causing financial hardships. And I just think that we need to adopt this amendment and protect girls' spaces. Please vote yes.
Further remarks? The good member from the 8th District, Representative Connors.
Thanks, Madam Speaker. I hadn't planned on talking about this particular amendment tonight, but I think that bathrooms can be safe spaces and they can be scary spaces. They can be safe spaces for people who are having a hard time. There's a lot of people who have locked themselves in the bathroom stall to cry before. There are sometimes scary spaces because you go into a bathroom and someone might have written something about you on a bathroom wall that you don't want to read. But going back to what the good member from the 16th District said, I remember going recently, it wasn't that long ago, when my kids had a grade school game, and the schools had changed a little bit since I'd been in high school. You had the boys' bathroom and the girls' bathroom. And I remember even being nervous as a parent walking into this brand new school where there wasn't a door on the entrance to the bathroom. There now in our district, there's shared sinks, so you walk out from the stall area and you come out to a shared sink, but there's no actual door into the bathroom, but they were on the stalls. And I remember as a parent, just at that moment, that made me nervous. And maybe it's just because that's the way I grew up, Madam Speaker, that it made me nervous because it was different. But I have 3 daughters and a son. And I can tell you the one daughter that I had that just graduated from high school and the son that I have in high school right now, my last daughter that graduated from high school would not go to the bathroom at school. So she held it every day until she came home. So that made it for me, it was not a safe space for her. So in summation, if we're going to make this a safe space or a scary space, we should do that for everyone. I'm encouraging a yes vote on this.
Further remarks, the good member from the 14th District, Representative Mendoza.
Thank you, Madam Speaker. I'm also the mother of 3 children. I have a 16-year-old, a 14-year-old, and a 13-year-old. So I have a daughter and 2 boys. So I'm going to talk to you on behalf of my boys. I think that a lot of rights have been taken not only from the girls, but from the boys. I can tell you that my sons would love to share spaces with girls, but not in the bathroom. They would not enjoy going into a bathroom, especially my middle school boys. And so for that reason, I think it's important for us to look at, just like the representative before me said about, making it a place where girls and boys can go and feel safe in the school and absolutely safe being able to go and have some privacy in the bathroom. So for that reason, I ask you to vote yes.
Further remarks? Seeing none, the question before the House is adoption of Amendment 446. All those in favor say aye. Aye. All those opposed say nay. No. The amendment is not adopted. There are further amendments. Amendment number 480, clerk will read.
On page 5, after line 7,
line.
Insert use.
The good member from the 9th District, Representative Dye, to move the amendment.
Thank you, Madam Speaker. I move Amendment 480.
It's been moved and seconded that Amendment 480 be adopted. Remarks, Representative Dye.
Thank you, Madam Speaker. I know that we all have memories, maybe you and I both share memories of when we were in school. And 7th grade was when we had to change for sports, for PE, and we had the locker room. And what an awkward age, right? You're awkward in your body, you don't know, things are changing, and then you have kids that tease and bully, mostly tease, but I was a very shy kid, and that was really painful. I came into the school district from a country school, and so then we had to go to the big town to join with all the other schools in the country schools came to the town for high school and junior high. And I think about the idea, it was hard enough to be teased by people that you didn't know when you're in 7th grade and you're awkward and you're a country kid and you know how it is. And so I can't even imagine what the complications must be for the children today with all of this going on. So I would say that it would be important to consider the idea of the locker room being another place that we should protect the safety of all children, and that to be able to make those transitions into a healthy adult with confidence and good memories of your times when you became first opportunities to play sports in a team, to do your PE classes and enjoy the time doing the different games and things, but know that the locker room isn't a terrifying space for shy children like myself. And, you know, there was a lot of places that I was scared of in school. The school bus was one, but locker room was scary. I still have those memories of how scary the locker room was. And so I think that it's important to recognize that the children deserve a safe space where they can be not embarrassed, not humiliated, not teased, not ridiculed, and not build these scarring memories. But I think it's appropriate that we keep those separated for our little boys and our little girls. Thank you.
Further remarks? Seeing none, the question before the House is adoption of amendment. You did rise late, but I will call on you, Representative Walsh.
Thank you, Madam Speaker. We did both stand up at the same moment, but thank you.
You were both late.
Madam Speaker, this is a good amendment. Please vote yes. All three of my daughters played sports in Aberdeen. And a shout out to Miller Junior High School and Aberdeen High School. Go Bobcats. One of the things that two of the three of them told me in sort of close alliance was they enjoyed the few moments after a game. One was a soccer player primarily, one was a basketball player primarily, that they didn't have to think about anything but the game. They could finish the game, or maybe the practice too, and just go into the locker room, have a shower, clean up, maybe don't have a shower, I don't know. I don't go in the girls' locker room. But you know, basically decompress from the game. Think only about the game, go through in their minds what had happened, how they'd played, how the other team had played, and kind of clear their head after playing in a basketball game or a soccer game. And Madam Speaker, I think if we change the simplicity and sanctity of the place, if we open that locker room to anyone, I think that athletes of any gender, of either sex, would become more aware of themselves and what their sex is. And it would take away that simplicity, that sort of Zen-like quality, to be able to just not worry about the shape of your body, not worry about breaking up with your boyfriend, not worry about the fight with your mom, and just be you in the moment and decompress from the game you just played or the practice you just had. And we need to give kids that kind of system, that kind of infrastructure in this case, to be able to grow, to be able to learn about themselves. I mean, that's what sports is for. And that locker room should be a place where a young athlete, either a boy or a girl, doesn't have to think I'm a boy or a girl. They just are. And they can think about the game, and they can think about winning and losing, and they can think about scoring or defending in peace and clarity. I think if we open these things up, if we make it complicated, we take away that ability, that element of their growth. Please vote yes on the amendment.
The other good member from the 19th District, Representative McIntyre.
Thank you so much, Madam Speaker. I'm going to be voting yes on this amendment. I'm going to be doing so to make a very strong statement that I hope that you will share with me, and that is males and females are different and deserve their own spaces. When I was studying biology, I learned a concept called sexual dimorphism. It's a way to describe in species how to tell the difference between males and females. Sometimes it could be hard. If a cat walked across the street, you might not know. But yet, if you saw an elk, you may tell from the antlers which one is the male and female. In certain species, it can be easy, and some it can be difficult. these differences show up in humans around the age of puberty, which is where we would normally see locker rooms at the high school level or the middle school level. This is important, Madam Speaker. Males and females are not the same, and part of this has been for the protection, especially of our females. How do I know this so well? Because I have 3 daughters. My oldest one you so graciously welcomed on the floor last year when I was called away. Her name is Lillian. It was her senior year when she came here. She had just finished her wrestling season. She loved wrestling so much and was in very good shape and was using her own time to further her wrestling capabilities. She made it to state as a junior and wanted to go back as a senior. She had an undefeated record, 22-0, and then she went against a male in a female league. And that taught me something. Males and females deserve their own spaces. We used to have categories, male and female in sports, but in this case, my daughter wrestled a male who was wrestling in the female category, and she was injured. She hurt her shoulder. That gives her pain to this day. And from then on, she had hit wins and losses throughout the season and wasn't able to have the same run in state that she did as a junior. But I tell you something, Madam Speaker, when you're a father and you see how much time and effort she put into that, and then to just have it taken away, you know that males and females are different. They should have their own spaces. That's why I'm supporting this amendment. Madam Speaker, we all, I imagine, have girls that we love and care about, daughters, nieces, granddaughters. When it happens to you, Madam Speaker, it will change your perspective. And you'll know, like I know, we have to have these separate spaces. We have to have these 2 categories. Males and females are different. Let's keep these locker rooms separate to protect our girls. Because if my daughter was alone in a locker room with a male, I'm afraid to say it, as good a shape as she was, she's not able to fight off a male who has ill intentions. It wouldn't happen. To protect our girls.
Further remarks, the member from the 26th District, Representative Caldier.
Thank you, Madam Speaker. Before session started, I had a phone call from a friend of mine, and she was crying. And she said that a couple months prior, her daughter had been very violently raped and wound up getting severe PTSD and wound up having to go to an inpatient because the PTSD was so bad. Then she went back to school, and she was told that they would provide her with a shower curtain that she could isolate herself, to take a shower during the gym. However, she still had to walk through back and forth, and there was another student who had male genitalia, and she was traumatized once again. And my friend said, why are there no protections for my daughter? Why is it that she has to be re-traumatized every time she takes a shower? And she stopped taking a shower. And the hard part is I completely understand that when it comes to kids, we have to be sensitive to all different types of kids, but it seems as though there has been such a focus for one child and we've forgotten about other kids. And I'm just saying we need to think about young women and men who have been sexually abused and are traumatized because they're not ready to deal with seeing other genitalia. And for those reasons, I urge adoption of this amendment.
Further remarks, the good member from the 21st District, Representative Ortiz-Self.
Thank you, Madam Speaker. Madam Speaker, we've heard on the House floor today about the trauma in bathrooms and in locker rooms that many of us experienced growing up, middle school, elementary school. this amendment isn't going to take that trauma away. I'm a school counselor. I guarantee you that kids fight in the bathrooms and they say things and all that stuff happens. Whether you have a single-sex locker room or not, it will continue to happen. So this doesn't take care of any of those issues. Discriminating against a protected class in order to avoid those issues doesn't make sense. I have students from that protected class, Madam Speaker, who come into my office and cry, and they do the same thing. They hold their bathroom needs. They cry in a corner because they're afraid of being called abusers. People are afraid of them because they think they're perpetrators. They're afraid because they can't not think about their gender. It's all consuming. They are afraid, Madam Speaker, and things like this does not help. Discriminating and breaking our Washington state laws does not help in any of the other trauma that other students bring to school. And believe me, I know that is there as well. We can't make the problem worse by discriminating against some in hopes that it won't happen to others. What we can do is become welcoming, affirming, loving, safe, protective school environment. Have loving adults that are going to protect everybody in that building. That every child that shows up that can be loved and appreciated for who they are. That is what our children are asking us for us to do. That's what I'm asking you to do, Madam Speaker, by turning down this amendment. Thank you, Madam Speaker.
Further remarks, the member from the 15th District, Representative Defoe.
Thank you, Madam Speaker. I agree with almost everything the good lady who spoke before me said. We need to have welcoming, loving spaces for all the children in our public school system. That's very important. This amendment does not block that, doesn't discriminate. All it does is it creates a safe space for our young men and our young women and folks who maybe want a third option, and I think that would be terrific. This amendment doesn't preclude that from being an option. But what's really important to me, Madam Speaker, is that we don't impose different criteria on our school children than we expect for ourselves. Here in the Capitol, Madam Speaker, we have a men's locker room and we have a women's locker room over in JLOB. I intended to be there a lot more than I made it this year, but that's the way that it's set up. And we have one for the men and one for the women, and we can get dressed there in the morning if we drive in from our districts. We also have a women's lounge here just off the Capitol wings, 100 feet, 200 feet from where I'm standing right now. And we have a men's lounge, Madam Speaker. And so we are here in the Capitol where we are talking about this very thing tonight, exhibiting a different standard than the one that we are imposing on our schools, where our kids are. We're all leaders. We can all take care of ourselves in this building, Madam Speaker. These are vulnerable young people who are developing their ideas, their bodies, their life experiences, their outlook on things, and we are asking them to share a locker room when we are not willing to share a locker room ourselves. And that's for very good reasons, Madam Speaker. It doesn't have anything to do with discrimination. It's about opportunities for everyone. We also have here in the Capitol a bathroom where someone can go on their own and change without being around men or women. And in my daughter's schools, public schools, they have those same options as well. No one is discriminated against. We're just asking to treat these young people like we expect to be treated and be safe like we want to be safe. Please vote yes.
Representative Jacobson.
Thank you, Madam Speaker. We need same-sex locker rooms. Madam Speaker, I have 5 daughters, and I don't want them to be fearful, but I want them to be on guard. And I have taught them that, and they're now adults, and they went through life learning that. And I wouldn't want them to be, as happened at our YMCA in Pierce County, in a locker room with a person who had biological male genitalia. And that's what happened at our YMCA in Pierce County around 2014. They had to walk, they allowed transgender individuals to go to the locker room of their choice, And this was locker rooms where we're having toddlers coming to swimming classes, and there were people who protested. There was a gal who was fired. Her own daughter took swimming classes there and was in that locker room. So, Madam Speaker, we have to look at both sides of this. The YMCA had to walk that policy back. They later had to tell those individuals, that the transgender individuals that were in the locker rooms, that they needed to go to a more private space, and they ended up having to have more encouragement of private spaces for each individual. The same-sex locker room is essential. It's essential for our kids in schools. It's essential for women, Madam Speaker. So I urge adoption of this amendment. Thank you.
Representative Griffey.
Well, thank you, Madam Speaker. If people really truly know me, they would know that I don't want to offend anyone. There's never a chance in a time in my life that I would feel comfortable offending someone. But when it comes to this topic and my 11-year work with sexual assault survivors, Madam Speaker, it nearly breaks my heart that we could be talking and debating this on this floor. Think about how many ladies, young ladies in that locker room could be survivors of sexual assault or domestic violence. We can do this better, Madam Speaker. I suggested to my local school district, who had a forum, where they wanted to know what to do about the bathroom issue, and every parent said, we want to be respectful of everyone, and we want to make sure that everyone's safe. And Madam Speaker, the collective thought process by 70% or 80% in the room was, why don't we establish another shower room? We have one. We have a staff shower room, so we can do this. And the school district told all of us that were in the room that that would violate the transgenders' rights, Madam Speaker, and that if one of the young ladies felt uncomfortable showering with somebody with male genitalia, that they could shower, Madam Speaker, in the staff lounge. I think we can be better than we are, Madam Speaker. We can understand that we, by not adopting this amendment and having the policies that we have in our schools, we could be re-traumatizing those that are trying to recover from sexual assault and sexual violence.
Please speak to the policy.
Madam Speaker, having someone with male genitalia and having someone with female genitalia in the same shower room is unacceptable. Please vote yes for this amendment.
Further remarks? Seeing none, the question before the House is adoption of Amendment 480. All those in favor say aye. Aye. Opposed say nay. The amendment is not adopted. There are further amendments. Amendment number 344. Clerk will read.
On page 5, after line 22, insert on school property or that.
The good member from the 49th District, Representative Stonier, to move the amendment.
Thank you, Madam Speaker. I move adoption of Amendment 344.
It's been moved and seconded that Amendment 344 be adopted. Remarks, Representative Stonier.
Thank you, Madam Speaker. Asking you to consider voting for this amendment. We certainly heard some discussion around notification in the House Education Committee and saw some amendments that were definitely difficult to implement. And so we are coming to you now with an amendment that was well worked with the agencies that would respond in a number of these instances, with educators who run the schools and with first responders who may respond to some of these instances. So we hope that, or I hope that you will consider voting for this amendment. Thank you.
Further remarks? The member from the 35th District, Representative Couture.
Thank you, Madam Speaker. Respectfully asking for a no on this amendment. I do appreciate some of the hard work that was put into this amendment. I've frankly, I've seen some of this language before. We do absolutely want immediate notification of our parents and guardians when something bad happens to a child in schools. However, Madam Speaker, there's some fatal flaws written into this amendment. Of course, you heard the last line, and that last line says on school property. And that's the only place that this particular amendment recognizes. The problem, Madam Speaker, is if there is some kind of sexual or other criminal misconduct by school staff off of school grounds onto a student, this amendment doesn't cover that. And that's the fatal flaw, Madam Speaker. And one more fatal flaw is that it enumerates, it lists and defines certain crimes, but not all crimes. And that, for me, is a huge problem. If there is any criminal misconduct, including sexual misconduct, of a child in our schools, parents should be immediately notified. And I do respect that this tries to drive at that immediate notification. It's a lot better than up to 48 hours later. But what's even worse, Madam Speaker, than 48 hours later is never at all, because it didn't happen on school grounds. This happened actually in my district, Madam Speaker, where a Shelton school district counselor was grooming and having sexual relations with his students in his care. But he was taking them off campus, and not only to have sexual relations with young girls who were minors, people he was supposed to be protecting and defending in loco parentis, Madam Speaker, in place of parents. But he violated those girls, and then he even fed them drugs at his house. Madam Speaker, with this amendment would not even recognize that as a problem. It would not immediately notify in that particular circumstance, and I think that's the fatal flaw. I think we could do a little bit better on a future amendment here. Please vote no.
Further remarks? The good member from the 49th, Representative Stonier.
Thank you, Madam Speaker. I just want to stand and ask you to not vote for, or to vote for this amendment for a couple of reasons. Number one, it's growing frustrating as a teacher certified to be a professional in my profession for 25 years and hear of these instances where people in my profession have made incredibly bad decisions disrupting trust. However, in the instances that we have heard on the floor tonight, I want to point out that the laws of this state protect and require reporting. The reason we are here, as you know, Madam Speaker, is because the passage of an initiative has made it confusing for the people of this state about what the laws are. This bill seeks to do that, and accepting this amendment would further that clarity. Please vote yes.
Representative Walsh.
Thank you, Madam Speaker. Well-meaning but imperfect amendment, please vote no. Madam Speaker, the existing law put in place by Initiative 2081 that created the Washington Parents' Bill of Rights is crystal clear that the parents must be notified, or guardians, Madam Speaker. The parents must be notified when a child is victimized, whether on school campus or off school campus. There's nothing confusing in the existing law, Madam Speaker. In fact, a King County state judge ruled that the existing law is good law, and the attempted challenge of that law in court was put aside. The existing law is clear. The existing law is not confusing. It's good law. Please vote no on this failed effort to further clarify.
Representative Couture.
Thank you, Madam Speaker.
30 seconds remaining.
I just wanted to have a point of clarification that this amendment would drive away from just merely an allegation of wrongdoing and go towards a higher standard of reasonable cause. And that is a higher standard that will prevent more notifications of parents when bad things happen to their kids in schools. Please vote yes. No.
Representative Corey.
Thank you, Madam Speaker. Also urging a no on this because I do think it further complicates the notification requirements. As a parent, if something happens to my child, I want to be notified. I want to be notified immediately. I don't think we should have a rubric of when, where, or how it happened. But if my child is in the supervision or custody of the school district, any time of the day, whether it's in school or during extracurricular activities, I should be notified. Please vote no.
Further remarks? Seeing none, the question before the House is adoption of Amendment 344. All those in favor say aye. Aye. All those opposed say nay. No. The Speaker is in question. The Speaker's about to, we will divide the House. The Speaker's about to open the roll call machine. The Speaker has opened the roll call machine. Has every member wishing to vote voted? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Will the clerk please take the record?
Madam Speaker, there are 52 yeas, 38 nays, 4 excused.
And with that, this amendment is adopted. There are further amendments. Amendment 355, clerk will read.
On page 5, after line 22 of the striking amendment.
Last line.
Fees for obtaining the fingerprints.
The good member from the 49th District for Representative Stonier, for what purpose do you rise?
Thank you, Madam Speaker. Rising to request ruling on the scope and object of this amendment from you, please.
Scope and object ruling has been requested on Amendment 355. The title of the substitute bill 1296 is an act relating to promoting a safe and supportive public education system through student rights, parental and guardian rights, employee protections, and requirements for state and local education entities and declaring an emergency. The bill establishes a state policy that policies and procedures adopted by school districts, charter schools, and state tribal education compacts must prioritize every student's safety, access to a free public education, and privacy. The bill makes changes to delineated rights of parents and legal guardians of public school children, establishes a statement of student rights and related duties for the state and local education entities, and establishes anti-retaliation protections for public school employees. Amendment 355 adds a new section to the bill concerning certain school volunteers. It requires educational entities to conduct criminal history record checks on such volunteers and prohibits them from working with certain minors. The Speaker therefore finds and rules that the amendment is outside the scope and object of the bill. The point of order is well taken. There are further amendments. Amendment number 356, clerk will read.
On page 5, after line 22 of the striking amendment, insert "or guardian pursuant to section 104 sub 1 of this act."
The good member from the 31st District, Representative Penner, to move the amendment.
Thank you, Madam Speaker. I move Amendment 356, giving parents the right to record IEP meetings.
It's been moved and seconded that amendment number 356 be adopted. Representative Stonier, for what purpose do you rise?
Point of order, Madam Speaker. I'm concerned that Amendment 356 incorporates the provisions of House Bill 1051 into the substitute this bill, and that is a violation of one of our House rules.
The Speaker has reviewed Amendment 356 and compared it to House Bill 1051 that was introduced and referred to the Education Committee earlier this session. Amendment 356 incorporates the provisions of House Bill 1051 into substitute House Bill 1296 in violation of House Rule 12D. Therefore, the amendment is out of order and the point of order is well taken. There are further amendments. Amendment number 369, clerk will read.
On page 5, after line 22 of the striking amendment.
Last line.
2, a student's social security number, name, or address.
The good member from the 17th District, Representative Stevie, to move the amendment.
Good evening, Madam Speaker. I move Amendment 369.
It's been moved and seconded that Amendment 369 be adopted. Remarks, Representative Stevie.
Thank you, Madam Speaker. Madam Speaker, I hope at the end of this you're going to agree with me that this is an important amendment. This amendment is talking about a safe environment for our kids. When we send them to schools, we want them to be in an environment where they're going to be able to feel safe, to be in an environment where they can learn, they can grow, they can express themselves, and they can become young adults. I want to say this, that as mayor, I've been able to tour a lot of my schools. I'm really proud of our teachers. I'm really proud of our youth. I've done a lot of coaching. I've had a lot of kids come to the city with civics. I've had a lot of kids come here to the Capitol, and I'm really impressed with them. And I want to make sure that we continue to provide that environment for them. This bill talks about a rare occasion where that doesn't happen. There can be a disruption in a classroom, multiple disruptions. I have a lot of friends that are teachers. I hear from a lot of parents. And when this does occur, when a situation in a classroom occurs, I want to make sure that our teachers are empowered, that they have the right to keep the respect, earn the respect, keep the discipline in the classroom to maintain that safe environment. It's not fair for the kids that don't feel safe in a classroom. So what this bill is doing is giving that to the teachers to be able to maintain their own classrooms. If a student disrupts, and I think this is probably the most important thing, they need to learn that there are consequences. Consequences for bad behavior. This bill talks about multiple acts of bad behavior. If they learn that their actions have consequences at an early age, maybe we can prevent that in a later stage in their life. Thank you, Madam Speaker. I hope you approve this amendment.
Further remarks? The good member from the 47th District, Representative Entenmann.
Thank you, Madam Speaker. I would ask that you vote no on this amendment. May I refer to my notes, Madam Speaker?
Please proceed if they're
relevant. Thank you, ma'am. OSPI has created the Educational Opportunity Gap and Oversight Accountability Committee. It was created because of RCW, I want to make sure I get it right, RCW 28A.60.010. This RCW basically said that students could be removed from the classroom because of disrupting the classroom and because of poor behavior. But evidence showed that it disproportionately impacted African American students, particularly African American boys. They were being denied their educational opportunity. A number of things occurred. They created the Oversight and Accountability Committee. They gave teachers more training on classroom management. And in my community, Madam Speaker, parents created the South King County Discipline Coalition. Parents in my community said, although we want our classrooms to be safe, we think it's unfair that the suspensions are being disproportionately handed out to African American male students. We want better training for the teachers. We want to be more involved in the classroom. And through this work, we have found that we are improving the educational opportunities for all students in our school district. I would ask you to vote no on this amendment because I am concerned that we will be returned to past wrongs. Thank you, Madam Speaker.
Further remarks? Representative Defoe.
Thank you, Madam Speaker, and I agree with the good lady from the 47th that it is a problem when certain individuals, certain classes of individuals are suspended or punished at a higher rate than others. That is a problem that needs to be addressed. What we're talking about with this amendment is a different problem, and that is the opportunity for students, every student, to have a learning environment free from disruption. Madam Speaker, I have the privilege of volunteering in my daughter's elementary school classes when the legislature is not in session, and I see the frustration on the teachers' faces when there are 16, 17 students who are trying to learn and begging for their attention, and it is fully consumed by one or two individuals day after day after day. They are so relieved to have an extra set of hands in the room to help manage those situations, especially when the individual is a male, because a lot of times the disruptions are from younger boys. That's the way God made boys. And so when we can't address the situation by having an extra set of hands in every classroom, it would be wonderful if we could do that, if parents had the opportunity, the wonderful opportunities that I have to do that. We need to make sure that the other children who are losing their learning opportunities are not being punished, and that the teachers who are trying to do their job, wonderful teachers trying to help out the children of our state, improve their math scores, improve their reading scores, which are languishing, Madam Speaker, because of these disruptions in large part. We have to come up with a system that provides consequences. And the work group that the good lady referenced and the Office of Superintendent of Public Instruction has failed in their efforts to manage that situation. What we have brought forward with, Madam Speaker, what the sponsor has brought forward with this amendment is a proposal to try something different. We cannot lose sight of any whiff of discrimination in the implementation of this policy, but we do need a policy. We do need a solution. The status quo is unacceptable, and it is failing our schools, and it is failing our children, and it is failing our teachers. Please support this amendment. Let's try something new and move forward in a good direction. Thank you, Madam Speaker.
Further remarks? Good member from the 20th District, Representative Orcutt.
Thank you, Madam Speaker. Also rising in support of this amendment. We heard first from the gentleman from the 17th District that people need to learn when they're misbehaving, that there are consequences. We've also heard that from the gentleman from the 15th. And they're right. May I read from the actual amendment?
Please proceed.
Thank you, Madam Speaker. So the principal can consider, doesn't say they shall do this, but they must consider, when somebody repeatedly engages in behavior that diminishes or impedes the educational opportunity of another student. Now, let me emphasize, repeatedly engages in. Not the first time they engage in, not even the second time they engage in, but when they repeatedly engage in. So very clearly, any disciplinary action that has happened on those previous incidents, the student did not learn that there are consequences. It did not change behavior. Therefore, the consequences have to become a little more severe. And as they continue to repeat and repeat and repeat, the consequences need to become a little more severe. If we don't, then they're going to continue to repeat. They're going to continue to impede the educational opportunity of another student. Our students deserve a safe place to learn. When they're being bullied, they are living in fear. And when you're living in fear, that is not a good educational opportunity for them. It does not give them the ability to focus on their studies because they have to worry about what that bully is going to do to them. And the more that bully does it, the more scared they become. Madam Speaker, when people repeatedly do this, the consequences need to be stronger. That's why this amendment is critically important. Please adopt it.
Further remarks? The good member from the 21st District, Representative Ortiz-Self.
Thank you, Madam Speaker. Madam Speaker, I happen to be one of the co-chairs of the Education Opportunity Gap and Accountability Committee. I have been so for 12 years. I have been an educator for over 25 years. Going back to methods that we used 25 years ago where a child acted out and we kicked them out of school and affected their future gave us some really bad outcomes. If we think the outcomes are bad now, you should see the statistics from 25 years ago. Madam Speaker, here's what I learned in 25 years. Here's what I've learned as the Opportunity Gap and Accountability Committee co-chair. Students who repeatedly, although I'm not quite sure how many times repeatedly is, children who repeatedly act out come in all sorts of sizes, colors, and issues. I have students with ADHD. I have students with autism. I have students who act out because they're hungry. I have students who act out because they've been bullied. I have students who have social and emotional and trauma. I have students whose parents beat them the day before they walk into school. I have students on and on and on. And their cry to us is they act out. And by limiting them as an educator, I do not have the right to choose which child gets an education and which child doesn't. I don't have the right, Madam Speaker, to say you're acting out and you're inconveniencing me, get out. Limit your future, fail your test, fail school, be held back. Forget a future because education system doesn't want you. I don't get that choice, Madam Speaker, nor should I ever. No educator should have the choice to limit the educational rights of our children, and I am glad to say, Madam Speaker, that our law says so. So when a child has to be removed from school, we must provide alternative education. We must meet together and do restorative practices. We must make sure that we can bring them back into the fold and love them and find alternative ways to educate them in our schools. Because, Madam Speaker, every child deserves that. I don't care what disability, what race, what background, what poverty or level they come from, what experiences they've encountered. They deserve our very best, and they deserve a future. And the message we must not ever give them, Madam Speaker, is to say that you're worthless and you don't belong here. The message we should be telling every child is this is your place, and we're going to make you successful, and we're going to work at it.
You have 8 seconds remaining.
For all children. Thank you, Madam Speaker.
Further remarks? The good member from the 8th District, Representative Barnard.
Thank you, Madam Speaker. I agree with much of what was just said. Those children that hurt other children and those children that hurt other people, even adults, even their teachers sometimes, they deserve our love and they deserve our compassion. And they deserve to be treated with sensitivity and understanding. However, I do have a short story to tell. And one time I went to my children's middle school back in the day. This was before COVID. And they had the chart up on the wall of their scores that the school was really proud of. And they had them up, and one of the scores that I had noticed took a major dip between the 7th and the 8th grade. This was middle school, so only 7th and 8th grade there at the time. And I asked the math teacher, I said, because he was a friend of mine and our families, and I said, what happened? Why are the grades so so bad? And he gave me a very quick quip and said, oh, you know, between 7th and 8th grade, the boys and the girls, they start to like each other. And so they get distracted. And I said, I don't buy that necessarily. This is a sharp decrease, really sharp decrease in our scores. What happened for these kids between the 7th and the 8th grade? So I did a little more digging, and the school principal is also a friend of mine. And I asked him, I said, what is the deal with these scores? And his answer to me was, we changed our disciplinary policy, and we can no longer control the classrooms because of this limiting factor. And the kids were having a really hard time focusing and concentrating because there were several kids who we love and we have compassion for and we want to help deeply. We don't want to lose them. We don't want to say we don't want you, but there has to be accountability. We have to teach them. It's our responsibility to teach them what is and is not okay, what behavior is and is not acceptable. And if there aren't those consequences, and sometimes this meant teachers were actually assaulted. And so being sensitive to that, I feel it's in our best interest to accept this amendment, and I would urge you to vote yes. Thank you.
Further remarks, Representative Walsh.
Thank you, Madam Speaker. I want to talk about Amendment 369 here, but I can't help but think, Madam Speaker, most of the parents in the state would like to get back to where our public schools were 25 years ago, when the results of basic education in this state ranked among the highest in the nation, rather than the low end of middle where they rank now. Madam Speaker, I think most parents would like to get back to where most kids are proficient at reading and math, rather than most kids not being proficient. That said, Madam Speaker, let's get to the point of this amendment. When I was working on the Parents' Bill of Rights, talking to parents and talking to teachers all around the state, what both parents and teachers said was that if parents were better informed and notified about what was going on in the classroom, the teachers would be more effective at teaching the kids, because there would be accountability both on the teacher and the parent to make sure that the classroom was kept in good order. What a number of the classroom teachers told me was the disconnect between what's going on in the classroom and what parents and guardians know about what's going on in the classroom is one of the reasons it's hard to keep order in the classroom. So what the Parents' Bill of Rights does is it assures that parents are notified in timely order, often immediately, what's going on with their kids in many contexts, including disciplinary contexts, and how they're behaving in the classroom. What this amendment is trying to get back to is that element of the Parents' Bill of Rights. Again, Madam Speaker, it's been ruled good law in this state that assures that the notification of parents quickly about what's going on with their kids helps the teachers keep better order in the classroom. The underlying bill obviates that. The amendment puts that accountability, that notification, that communication between teachers in the classrooms and parents of the kids back in law. And that's what we need to help good order in the classroom and get those proficiency tests back to where they were 25 years ago, when this state's public schools were the envy of the nation. Please vote yes.
Further remarks? Seeing none, the question before the House is adoption. The good member from the 30th District, Representative Reeves.
Thank you, Madam Speaker. I've heard a lot tonight about getting our schools back to 25 years ago. I'll do you one better, Madam Speaker. I want to talk about our schools 30 years ago. As many of you know, I am the daughter of a single mom. My mom was a drug addict and an alcoholic. I spent the first 10 years of my life in and out of foster homes, Madam Speaker. Many of you probably know that I had an occasion to act out because of the abuse that I received at the hands of my mother, because of the abuse that I received at the hands of her various boyfriends. I want to talk about the school system I went through, Madam Speaker, 30 years ago. Had this amendment been adopted, my educators wouldn't have had the opportunity, Madam Speaker, to support me through trauma-informed care. My educators would have had to use the same style of discipline that my mom wielded in the form of spatulas, electrical cords, lack of food, and the withholding of affection. Madam Speaker, I want to talk about the schools and the educators that I had the opportunity to experience absent this amendment. Because it's because of those educators, Madam Speaker, that I'm standing on this House floor today. It is because of the love and affection and the opportunity to meet me where I was in the trauma that I experienced every single day that I am able to stand here today. Because instead of choosing discipline, Madam Speaker, those educators chose compassion. They chose love. They chose caring. And they chose to recognize that I was a hurt little kid seeking love and affection, seeking care and compassion. And instead of choosing discipline and putting me on a path to failing out of high school or out of elementary school or out of middle school, they put me on a path to become the first in my family to graduate from high school. They put me on a path to become the first in my family to graduate from college. They put me on a path to serve the people of my state in the House of Representatives, Madam Speaker. I am asking you to put down this amendment to ensure that we can encourage educators to continue providing love and compassion.
Further remarks? The good member from the 26th District, Representative Caldier.
Thank you, Madam Speaker. I also was in a very abusive environment growing up, and I know that this may come as a surprise to you, but I also acted out as a young child. And there were times where I was also very disruptive. At the same time, it wasn't okay for me to be disruptive. And I did not have that guidance at home. And my teachers, I wouldn't be here today without them either. And there's different ways that you can discipline but still be able to maintain control of the classroom. And I was down at the principal's office all the time. I know this also may come as a surprise to you, but I had a very vocal voice when I was a teenager. But they would discipline me, and it was care and compassion, and it was the right steps to do. And because of that, I was able to go on to college and earn my doctorate. And I think if I had not have learned those behaviors, because I was not learning those at home, I wouldn't have been able to be successful in college. So for those reasons, I urge adoption of the amendment. Thank you.
Further remarks? Representative Stevie.
Thank you, Madam Speaker.
You have 34 seconds remaining.
I think that this amendment isn't going to the extremes. Anybody that goes through that, my heart goes out to them. You know, I came at a time where if I went to the principal's office, I actually was hit with a paddle. You know, when I did something wrong, I'm sorry, Madam Speaker, I'm just saying that this is to teach people, kids, that there are consequences for bad behavior.
Further remarks? Seeing none, the question before the House is adoption of Amendment 369. All those in favor say aye. Aye. All those opposed say nay. No. The amendment is not adopted. There are further amendments. Amendment number 371, clerk will read.
On page 5, after line 22 of the striking amendment, insert schools subject to Chapter 28A.715 RCW.
The very good member from the 9th District, Representative Schmick.
Thank you, Madam Speaker. I move Amendment 371.
It's been moved and seconded that Amendment 371 be adopted. Representative Stonier, for what purpose do you rise?
Thank you, Madam Speaker. Rising to request a ruling on the scope and object of Amendment 371, please.
A request for a scope and object ruling on Amendment 371 has been made. The title of the Substitute House Bill 1296 is an act relating to promoting safe and supportive public education system through student rights, parental and guardian rights, employee protections and requirements for state and local education entities, and declaring a state of emergency. The bill establishes a state policy that policies and procedures adopted by school districts, charter schools, and state tribal education compact schools must prioritize every student's safety, access to free public education, and privacy. The bill makes changes to delineated rights of parents and legal guardians of public school children, establishes a statement of student rights and related duties for state and local education entities, and establishes anti-retaliation protections for public school employees. Amendment 371 adds a new section to the bill concerning school volunteers that prohibits districts and charter and state tribal compact schools from permitting persons to volunteer in certain positions if convicted of certain crimes. The Speaker therefore finds and rules that the amendment is outside the scope and object of the bill. The point of order is well taken. There are further amendments. Amendment number 375. Clerk will read.
On page 5, after line 22
Last
of the
line.
striking, or less.
The good member from the 25th District, Representative Jacobson, to move the amendment.
Thank you, Madam Speaker. I move Amendment 375.
It's been moved and seconded that Amendment 375 be adopted. Representative Stonier, for what purpose do you rise?
Well, thank you, Madam Speaker. I rise to just request a ruling on the scope and object of Amendment 375.
A scope and object ruling on Amendment 375 has been requested. The title of Substitute House Bill 1296 is an act relating to promoting a safe and supportive public education system through student rights, parental and guardian rights, employee protections, and requirements for state and local education entities, and declaring an emergency. The bill establishes a state policy that policies and procedures adopted by school districts, charter schools, and state tribal education compact schools must prioritize every student's safety, access to a free public education, and privacy. The bill makes changes to delineated rights of parents and legal guardians of public school children, establishes a statement of student rights and related duties for state and local education entities, and establishes anti-retaliation protections for public school employees. Amendment 375 adds a new section to the bill and establishes a capital grant program for school safety projects that make physical improvements intended to advance the safety and security of schools, such as metal detectors, panic buttons, and fencing. The Speaker therefore finds and rules that the amendment is outside the scope and object of the bill. The point of order is well taken. There are further amendments. Amendment number 385. Clerk will read.
On page 5, after line 22 of the
Last
striking
line.
amendment, years.
The good member from the 35th District, Representative Couture, to move the amendment.
Thank you, Madam Speaker. Please move Amendment 385.
Amendment 385 has been moved and seconded. Representative Stonier, for what purpose do you rise?
Thank you, Madam Speaker. Requesting a ruling on the scope and object of this amendment as well.
A scope and object ruling on Amendment 385 has been requested. The title of Substitute House Bill 1296 is an act relating to promoting a safe and supportive public education system through student rights, parental guardian rights, employee protections, and requirements for state and local education entities, and declaring an emergency. The bill establishes a state policy that policies and procedures adopted by school districts, charter schools, and state tribal education compact schools must prioritize every student's safety, access to a free public education, and privacy. The bill makes changes to delineated rights of parents and legal guardians of public school children, establishes establishes a statement of student rights and related duties for state and local education entities and establishes anti-retaliation protections for public school employees. Amendment 385 adds new sections to the bill and directs the Office of the Superintendent of Public Instruction to allocate funding for school resource officers and provides that such funding is part of the state statutory program of basic education. The Speaker therefore finds and rules that the amendment is outside the scope and object of the bill. The point of order is well taken. There are further amendments. Amendment 405, clerk will read.
On page 5, after line 22 of the striking
Last
amendment,
line.
vulnerable students and staff under section 104 of this act.
The good member from the 18th District, Representative McClintock, to move the amendment.
Good evening, Madam Speaker. I move Amendment 405.
It's been moved and seconded that Amendment 405 be adopted. Remarks, Representative McClintock.
Thank you, Madam Speaker. I would like a yes vote on this amendment that would create a safety data dashboard where OSPI would collect safety data from all of our schools across the state. Currently, there is no mechanism or process for doing this, but this would give us an opportunity to find out where the safety issues are, how our schools rate, and OSBI could set up a rating system, and we can allocate funds that are prioritized on need and address those issues. Right now, 18% of our students report feeling unsafe at school, and about 30% of those, let me just double check that, yes, 30% of our students report not attending school because they feel unsafe. But what's most alarming is that 70% of our teachers feel unsafe, and about 67% of our teachers are considering leaving teaching because they feel unsafe. There's violence in our schools against our students and teachers that we need to get a handle on. And I think this amendment would collect that data and help us address those issues. So I respectfully request a yes vote from you. Thank you.
Further remarks, the good member from the 3rd District, Representative Ormsby.
Thank you, Madam Speaker, and good evening. I'm rising in opposition to this amendment, and not because I have any philosophical objections. It is not an awful idea if money were no object. Turns out it is, particularly this year. This is an amendment that was basically a bill that, in the judgment of the good chair of the Education Committee, was not a priority, and we in appropriations really defer to the judgment of committee members and the things that pass out of committee. And in the good judgment of the chair, this was not among the priorities for the Basic Ed Committee. It requires an extensive data dashboard to be established. Having read fiscal notes involving information technology projects, they're expensive. And while this would be nice, this is not the year to do it. Happy to work on a concept about this next year. And another thing that we do in appropriations is not turn failed bills into provisos. This is novel. I will give the good member credit for using it as an amendment, but this is not the year to do an expensive IT data dashboard. Asking for a no vote.
Further remarks, Representative Couture.
Thank you, Madam Speaker. I think it's sad that it's not a priority of our state that we're going to help out and just simply collect data when such a large majority of our students and teachers feel unsafe in our schools. And when you look at some of the dashboards that OSPI already conducts, we have some of the lowest amount of hope. Hope is actually something that the OSPI measures. And we have some of the lowest amount of hope for our 12th graders in a very long time. I just think it's sad that we can't even collect data, and that's not a priority. We can't even collect data on how unsafe our schools are, and that's not a priority. Madam Speaker, we have a $72 billion budget and growing. And just simply asking the question, Do you feel safe in schools? And then finding out where people don't feel safe in schools so that we can actually do something about it and have some accountability so that people actually can feel safe where they exist and where they learn? Please vote yes on the amendment, Madam Speaker, because priorities of government means that our paramount duty of education should be a safe place to be.
Representative Walsh.
Thank you, Madam Speaker. I want to bring this back to the Washington Parents' Bill of Rights, the focus of our policy discussion here. The underlying bill, of course, would gut the Parents' Bill of Rights, and these amendments are attempting to restore pieces of the Parents' Bill of Rights. The relevance of this amendment to that process is that the underlying goal and overall purpose of the Washington Parents' Bill of Rights is information. It's that parents and guardians and families are notified and have, in as close to real time as we can provide it, knowledge and information about what their children are experiencing in school and in school-related activities. This proposal, this amendment, which would put this dashboard in place, is a good tool to achieving the long-term purpose of the Parents' Bill of Rights. It would give both educators and parents the ability to see critical information in, if not real time, something close to real time. And as I've said before, this kind of sharing of information benefits both the educators and the families. I strongly believe, and it's implicit in the Parents' Bill of Rights, that improving those channels of communication between educators and families benefits both, and most importantly, Madam Speaker, benefits the students. This is a good tool. This is a good suggestion. Please vote yes.
Further remarks? Seeing none, the question before the House is final adoption of Amendment 405. All those in favor say aye. Yes. Opposed say nay. No. The amendment is not adopted. There are further amendments. Amendment number 441. Clerk will read.
On page 5, after line 22 of the striking amendment, internal references accordingly.
A good member from the 6th District, Representative Voles, to move the amendment.
Thank you, Madam Speaker. I move Amendment 441.
It's been moved and seconded that Amendment 441 be adopted. The good member from the 49th District, for what purpose do you rise?
Thank you, Madam Speaker. Rising for a point of order.
Please proceed.
The Amendment 441 incorporates provisions of House Bill 1699 into the substitute, and I believe that is violation of one of our House rules.
The Speaker has reviewed Amendment 441 and compared it to House Bill 699 that was introduced and referred to the Education Committee earlier this session. Amendment 441 incorporates the provisions of House Bill 1699 into substitute House Bill 1296 in violation of House Rule 12D. Therefore, the amendment is out of order. The point of order is well taken. The House will be at ease for a moment.
The House will be in order. There are further amendments. Amendment 381, the clerk will read.
On page 5, line 35 of the striking amendment.
Last line.
Relationships in contributing to a positive school culture.
The good member from the 14th District, Representative Benjares, to move the amendment.
Thank you, Mr. Speaker. I move Amendment 381.
It has been moved and seconded that Amendment 381 be adopted. Remarks.
Thank you, Mr. Speaker. So in the underlying bill, there is a student Bill of Rights. This amendment actually adds a student list of responsibilities. And I think that's true of all of us. We have a lot of rights in this society. We have a lot of rights in this country and in this state. But we also have responsibilities that go along with that. So I'm not going to read all of them, but if some of the rights that are in this amendment that should be right along, if we're going to print the Student Bill of Rights, I think the Student Bill of Responsibilities should be next to it. It is like respecting your teachers, respecting your school property. It's like your house. When kids go to school, it is their second home. It's where they are during the day. Respect the diversity of all the students and the teachers that are there. Be held responsible for your actions. Those are the kind of responsibilities I think should be listed there too. I think it's very important that we teach our kids that with our rights in our society, we also have responsibilities to the other people we live with. So I'm asking for a yes vote on this amendment.
Further remarks. The good member from the 46th District, Representative Paulette.
Thank you, Mr. Speaker. Mr. Speaker, indeed, with rights come responsibilities. But this is a piece of legislation, and civil rights are enforceable things. Responsibilities are the things that we ask our educators to inculcate into our children, to learn about cleaning up after yourself, and to sign up for those as norms. And I love going into a elementary school or kindergarten classroom and seeing a list of the agreed upon responsibilities that the students and the educator have worked on together and hold themselves to. Doesn't belong in a law. Please vote no.
Further remarks. The good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. I think this is a great amendment. Can I quickly read to you what the 17 responsibilities in the proposal are?
Please proceed.
Follow school rules and policies. Respect others. Maintain a positive learning environment. Follow the dress code. Be punctual and attend school regularly. Complete assignments on time. Respect school property. Maintain academic integrity. Take responsibility for actions. Communicate appropriately. We could use that one here sometimes, Mr. Speaker. Engage in learning. Respect teachers and staff. Be prepared. Practice good hygiene and personal care. Participate in group activities. Use technology appropriately. And respect diversity. Sounds pretty good to me, Mr. Speaker. Please vote yes.
Further remarks. The good member from the 15th District, Representative Corey.
Yeah, thank you, Mr. Speaker. Urge a yes on this amendment. With all due respect to the good gentleman, I disagree. I think we do ascribe rights, but we also ascribe responsibilities in law. We do that all the time. It's rules and regulations that we pass off. Those are responsibilities. We do them on business entities. We do them on nonprofits, individuals. Even our own rules and responsibilities are in law, both in the Constitution and in our CW. This is a good amendment. It sets clear guidelines and boundaries for students that while, yes, they have underlying rights, they also have underlying responsibilities. These are good ideas that would actually probably solve a lot of the problems that we're seeing in our schools if they were followed through by a majority of the students. So I think adopting this sets a good precedent that while, yes, you have rights, you also have important responsibilities, and those are to be taken just as seriously. Please vote yes.
Further remarks. Seeing none, the question before the House is the adoption of Amendment 381. All of those in favor, say aye. Aye. All of those opposed, say nay. Nay. The amendment is not adopted. There are further amendments. Amendment 387. The clerk will read.
On page 6, line 22 of the striking amendment.
Last line.
Among these are.
The good member from the 7th District, Representative Abel, to move the amendment.
Thank you, Mr. Speaker. I move Amendment 387.
It has been moved and seconded that Amendment 387 be adopted. Remarks?
Thank you, Mr. Speaker. Mr. Speaker, this is one of my favorite amendments out of a series of what I believe are good amendments, and I want to tell you why. This amendment does something both seemingly minor and narrow, and at the same time, in my opinion, exemplifying our entire debate tonight. So at the micro level, what this amendment does is that it provides that in the Statement of Student Rights, that our students are beneficiaries of our founding documents rather than subject to our founding documents. And our founding documents are described in the underlying bill as our U.S. Constitution and our Declaration of Independence. Why is that appropriate? Well, being beneficiaries of our founding documents, Mr. Speaker, is a much more accurate depiction of the proper relationship between those documents and our students today. In the legal profession, beneficiary has a certain definition, typically meaning to be an inheritor of some sort of a wealth or a treasure. A more common definition would be somebody who receives a benefit, and that's exactly what our students, and indeed all of us in this chamber, you and me, Mr. Speaker, are as it relates to the freedoms that are encapsulated in our founding documents. Now that's what it does at the micro level. Again, it replaces the phrase subject to with beneficiaries of. But in a broader perspective, Mr. Speaker, I think it really illustrates part of the dynamic of what we're talking about tonight, because subject to can be used not only in the bill as it is, meaning a negative or checked connotation or an adjective, but subject can also be a noun. It can be a person. And a subject is typically somebody who is a subject of a foreign country, typically with a monarch, which, you know, on July 3rd, 1776, we were subjects of the British Crown. If somebody talks about an individual being a subject of a foreign country, it typically has connotations of being a strong central power, potentially with the ability to reach far down into the affairs of the family and into civil society. And Mr. Speaker, that's exactly what we're debating here tonight. What is the proper relationship between you and me and the people who sent us here and the government? The individuals that are elected and appointed into positions of power as it pertains to our children and our students. And so we have a choice, Mr. Speaker. Are we beneficiaries or are we subjects? There are a number of words or phrases that could be used to describe the people of Washington, in my opinion, Mr. Speaker. Beneficiaries, yes, certainly, of our foundational documents. Citizens of a proud, free country, yes. Ornery, rebellious, and jealously protective of our children? Yes, yes, yes. And subjects? No. I ask your support. Thank you.
Further remarks? The good member from the 49th District, Representative Stonehill.
Well, thank you, Speaker Stearns. I disagree on a number of the other amendments we're discussing this evening, but not this one. I agree with the good gentleman. Please vote yes.
Further remarks? Seeing none, the question before the House is the adoption of Amendment 387. All of those in favor, say aye. Aye. All of those opposed, say nay. The Speaker is in doubt. The Speaker calls for division. The Speaker is about to start the roll call machine. The Speaker has started the roll call machine. Has every member voted who wishes to vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. The amendment, the clerk will take the record.
Mr. Speaker, there are 80 yeas, 6 nays, 4 excused.
The amendment is adopted. There are further amendments. Amendment 408, the clerk will read.
On page 8, line 10 of the striking amendment, after rights,
last line.
Insert or the associated legal limits.
The good member from the 6th District, Representative Volz, to move the amendment.
Thank you, Mr. Speaker. I move Amendment 408.
It has been moved and seconded that Amendment 408 be adopted. Remarks?
Thank you, Mr. Speaker. This is kind of in line with the fantastic amendment that we heard from the good member from the 14th a couple of amendments ago. It just kind of narrowed down in scope rather than a delineated list of these responsibilities. All it says is all rights are not unlimited, and a lot of that depends on the situation. I will use the floor, for example. I have to follow a very strict decorum. I can't get up and speak whenever I feel like it. I have to address you with the respect the position deserves and that you deserve when addressing you. If I go up up there in the balcony, I'm forgetting the word, but anyway, I can take a video where I can express my views a little bit more freely if I'm doing an update for my constituents, but I still can't stand up there and yell and scream and shout at you. Although out on the campus grounds, I have more free speech. So we have to look at these rights, especially when we're looking at school students, that these rights are constrained heavily by their environment and their rights, because they have a certain right, they don't have a right to infringe on others, and they must follow the decorum. So all this is saying is we need a disclaimer saying, hey, be careful, your rights, though exist, are not unlimited. So urge the adoption of this amendment. Thank you.
Further remarks, the good member from the 49th District, Representative Stonier.
Thank you, Speaker Stearns. I ask you to vote for the amendment. I agree with the good gentleman. He and I have a right to free speech, but neither of us are allowed to yell fire in a movie theater. Please vote yes.
Further remarks? Seeing none, the question before the House is the adoption of Amendment 408. All those in favor, say aye. Aye. All of those opposed, say nay. The amendment is adopted. There are further amendments. Amendment 373. The clerk will read.
On page 8, after line 19 of the striking amendment.
Last line.
Internal references accordingly.
The good member from the 25th District, Representative Keaton, to move the amendment.
Thank you, Mr. Speaker. I move Amendment 373.
It has been moved and seconded that Amendment 373 be adopted. Remarks?
Thank you, Mr. Speaker. This movement adds language to the intent section. May I read from the amendment?
Please proceed.
The legislature finds that parental involvement is a crucial factor in shaping the educational outcomes of students and contributing to the well-being of society. Parents are the primary stakeholders in their children's upbringing. When parents actively engage in their child's education, it enhances the student's academic performance, motivation, and overall development. Strong parental involvement also fosters a supportive learning environment, both at home and school, helping students develop confidence, resilience, and a sense of responsibility. Moreover, active participation from parents in their child's education builds a stronger school community, promotes positive behavior, and supports the creation of a more equitable learning opportunities. Ultimately, when parents and schools work together, it benefits the individual student and strengthens society by nurtured, educated, responsible, and engaged citizens. Mr. Speaker, there's an overwhelming body of evidence in studies involving parental involvement where the student outcomes are much, much higher. The entire 8 years I was on the Puyallup School Board, the best performing students, it didn't matter what they looked like, what color they were, didn't matter. What mattered was the ability of the family to promote education within that family. And having parents involved time and time again shows the best outcome. That should be the intent of this bill. Thank you.
Further remarks, the good member from the 49th District, Representative Stonier.
Thank you, Speaker Stearns. I agree with much of what I just heard, but in an earlier amendment, the good gentleman from the 19th acknowledged the importance of including guardians. And so, unfortunately, because this amendment has missed that minor detail, I'm going to have to ask you to vote it down. We want to make sure that we acknowledge all of the different ways that our kids come to us in school, Mr. Speaker. I've been teaching for years, and I know that students come from homes with a variety of sets of parents. Sometimes those who are in charge of children at home are considered guardians. We want to make sure those families are also acknowledged. Please vote no.
Further remarks. The good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. When we talk about the school environment, the education environment, you'll often heard the term hear the term in loco parentis used, parents in place. Generally, when we talk about education issues, we use the idea of being a parent in a broad sense. In some senses, it can be the teacher, and that's the most common notion of in loco parentis, especially when children are young. But I think we can use the same broad notion of what the word parent means here. Throughout our discussion, both in the Washington State Parents' Bill of Rights and in this underlying bill which attempts to gut the Washington State Parents' Bill of Rights, and in this amendment which attempts to suture up the gutting a little bit so that some of the good policy stays in place, the notion of parent is used broadly. Parent can be a biological parent, parent can be a legal guardian, and parent can be what it is in many cases, is really a family. Sometimes the parental figure in a child's life is a grandparent, an uncle or aunt, an older sibling. So let's not be peevish, Mr. Speaker. Let's agree that parents, broadly defined, are the primary stakeholders in raising children. I believe that that's the spirit of this amendment, and it is an important principle for us to have in our public policy. Parents, not the state, not the government, are the primary stakeholders in raising children. This is important, Mr. Speaker. Please vote yes.
Further remarks? Seeing none, the question before the House is the adoption of Amendment 373. All of those in favor say aye. All of those opposed say nay. No! The amendment is not adopted. With the consent of the House, House Rule 14C will be suspended to continue working past 10 p.m. Hearing no objection, so ordered. It is permissible for members to remove their jackets at this time. Further amendments. Amendment 382, the clerk will read.
On page 8, line 31 of the striking amendment, after
last line,
insert instructional materials during weekend and evening hours.
The good member from the 12th District, Representative Burnett, to move adoption of the amendment.
Thank you, Mr. Speaker. Please move 382.
It has been moved and seconded that Amendment 382 be adopted. Remarks?
Thank you, Mr. Speaker. This is just a simple amendment that just is going to require the school districts to afford new opportunities on a monthly basis to go outside of your regular working hours and weekends. I think you can think back at all the different things and activities that you have going on in school districts and the amount of money both the school, the state, local groups, and even the parents, grandparents, guardians invest in outside curriculum, outside sports activities, and on and on and on. I think this would be a great way to, one, it's going to afford opportunity for working families. It's going to allow them to come in. We have a huge diversity of what the family looks like today. We have divorced parents. We have, sharing those kids, going back and forth. We have grandparents raising kids. You have on and on and on different types of multicultural within the family structure itself. And a lot of times you have both parents working at different scheduled shifts. Could be working nights, could be working days, could be working weekends. But affording them the opportunity, this is going to promote transparency, and it's just going to be a good thing for the parents to be as much involved as they want to be, because I think we all know and agree that the more the parents or the legal guardians are involved in the child, the student's education, the better chance they have at being productive. One, it keeps the parent engaged to know, is your child actually doing what they're supposed to be doing? And so being able to go in and be able to have the opportunity to look at the curriculum, the textbooks, all of the different things that's coming up the classroom, I think this is a great amendment, and I would ask that you would join me in a yes vote.
Further remarks? The good member from the 22nd District, Representative Parsley.
Thank you, Mr. Speaker. Existing laws already are there in the books that establish instructional materials committees. in the school districts, and these include the parents. Current law also has school boards adopting when reviews are happening on curriculum and textbooks. So it's no secret to the parents. We could ask the school districts to look at this, but it would be an unfunded mandate. The other thing I want to point out, and this is coming from a daughter of a school teacher. Mr. Speaker, I remember my childhood with my mother working until midnight, working on her lesson plans, changing them a little bit because her class didn't quite get through the times tables or didn't understand a biology question and she had to slow things down. Or conversely, she had to speed things up because her class got it right and they were way ahead. Asking teachers to have this kind of thing on a monthly or shorter would limit their dynamic ability to teach students well. And this is what this bill is all about. So I would urge a no. We already have mechanisms in place and we have highly qualified teachers that should be able to have some flexibility in the classrooms to adapt to each class.
Further remarks, the good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. This is a very good amendment. Please vote yes. Mr. Speaker, again, the Parents' Bill of Rights is about communication and information. It's about notifying parents, in the broad sense, about what their kids are experiencing, primarily at school, but also in some other contexts. And this amendment is something that definitely is in the spirit and the mechanics of that communication, of that notification. As the member offering the amendment said, this is aimed primarily at working families who aren't always available during normal business hours to do things like look over curricula, look over textbooks. And when you talk to those parents and those families, Mr. Speaker, they want to do that kind of thing, they just don't have the time. So what this would do is say once a month or so, the school district has to make those learning materials, that information, the classroom material, available for review. Now, that doesn't mean that every teacher has to be in the classroom to do that. Those districts which already do this, and there are some that do, usually do it at a central location, maybe the principal's office or an administrative office, and or sometimes the district office itself, and make the information, the material, the content available to the families. And there's often an administrator or a principal or someone like that, maybe one teacher there, who's available to answer questions or talk to the family about the material the kid's learning at school. This is a good thing. And again, for emphasis, Mr. Speaker, the purpose of the Parents' Bill of Rights, that the underlying bill is really overturning, is open communication between schools and other people who care for kids and the families. It's a healthy thing, Mr. Speaker. It's a good thing. There's not enough of it, and this amendment helps make it happen. Please vote yes.
Further remarks, the good member from the 35th District, Representative Couture.
Thank you, Mr. Speaker. The good gentleman from the 19th makes some good points about working families. But circling this back around to Initiative 2081, the Parents' Bill of Rights, I think what's critical to understand is that hundreds of thousands of people in the state of Washington signed on the dotted line this initiative, which was then by a vast majority passed by this legislature, Mr. Speaker, because we have seen a stunning disenrollment in our schools, and parents are sick and tired of feeling like school districts and their child's schools are hiding things from them, like what they are learning in school, their curriculum, their textbooks, and other things. Mr. Speaker, when we lose trust, when parents lose trust in school districts, what we see with that disenrollment is a lack of funding to our schools. It means lost levies. It means lost bonds. And it means that our school districts are going into the red. It means that as we see right now, we've never spent more than we've ever had before. 3 times that of inflation, but we have the lowest scores in 3 decades. Mr. Speaker, this amendment is a critical trust building tool. It might be hard, but Mr. Speaker, when you've hidden things from parents, it is hard to rebuild trust. It should be hard to rebuild trust, and it's that hard work that schools and school districts and everyone involved must do in order to rebuild the trust so that we can make our schools whole again. We should not be hiding curriculum. We should not be hiding textbooks in the classroom or in a school library. We should be open and honest with parents. And this does not force anyone. It just says by request. And it doesn't say the individual teacher necessarily has to do it. It says the school district has to do it. Mr. Speaker, it might be hard work to do. And especially in a time where the state of Washington has put so many unfunded mandates into schools that we lost count of them already. This at least would help actually fund our schools when people send their kids back to them because they can finally trust their schools again. Please vote yes.
The Speaker would remind the member to address the body in a respectful tone. Further remarks, the good member from the 49th District, Representative Stonier.
Well, thank you, Speaker Stearns. I'm going to ask you to vote no on the amendment. School districts and schools are already required to make sure that information is available to parents. There are multiple processes for this to already happen. Not too long ago on this House floor, we debated exactly how a materials instruction committee would be put together. And the gentleman from the 19th offered a good amendment, which said if there's difficulty in finding parents to participate, rather than requiring, the district should have to go out and seek that parental participation. I agreed with that. Now, as a middle school teacher who taught language arts and social studies for years, and as an instructional coach who walks through the high schools of middle schools and high schools every day when I'm not here in Olympia, I struggle to accept that my colleagues have any reason to hide from parents what we are teaching. Our standards are available online. The Instructional Materials Committee can be gathered to adopt curriculum. Now, Mr. Speaker Stearns, I don't know if you've ever experienced this, but I know when as a teacher and even as a student, one of my assignments was frequently to do an assignment on current events. Now, you can't predict what's going to happen in the news next week or what might be of importance to your community a month later. But effective teachers pay attention to the world that kids are experiencing and listen to the things that kids are curious about to build it into their lessons, which is a far more engaging school experience than reading the same canon of books that my parents read years ago. Now, those texts may have something to offer, but the world is changing. And amendments like this restrict the ability for good, responsive educators to make the classroom reflective of the kids who are in that classroom. I'm getting frustrated with implications of nefarious actions when all I want is for kids in my classroom to see themselves in the stories that we read and tell so that their reading scores will improve. I've seen this happen year after year. It works. Vote this down.
Further remarks, the good member from the 16th District, Representative Rude.
Thank you, Mr. Speaker. First, I've seen material that is alarming to me, and I can imagine why some may want to hide it. Secondly, this amendment has nothing to do with future material and providing future material that doesn't exist yet. And thirdly, this is completely an equity issue. The people that are working multiple jobs that can't show up between 8 and 5 or 9 and 3 during the day are people most often that are probably low income, working 2 jobs, have busy schedules. This is completely about access for parents to review material for their student. And again, I've seen the material. It is concerning. Please vote yes.
Further remarks, the good member from the 13th District, Representative Ibarra.
Thank you, Mr. Speaker. And prior to coming to Olympia and being a member of this House, I used to be a school board member in my hometown, and I got lucky enough to sit on probably 4 or 5 curriculum committees that OSPI put together, social emotional learning, and others like that. And the reason I bring that up is because we were making new curriculum for the school districts. We were making social study curriculums, social emotional learning curriculums, and other curriculums for different parts of education across the state from K to 12. And so one of the things that I was really proud of this, we were sitting with 25 other people creating that new curriculum for the schools. And so when as a school board member, when I got done with the committee, we got the curriculum out, it was going to come out, and I got home as a school board member, and I'm waiting for that curriculum to hit the books so I could see what happened and see how it would work. But what happened over time, and I was waiting as a school board member, just waiting, and as a parent, waiting for that curriculum to hit the school districts, but it never did. Well, I never saw it coming through, even though I was waiting for it. It did come through after I really did a big investigation into those changes that we made later. But it took me, as a school board member, knowing how the system worked, to find that change in the curriculum at the school district. So I want to vote yes on this particular amendment, just because not all school districts do a great job of letting the parents know what that curriculum, the new curriculum is for kids and for parents. And as you can tell, I think that many parents want to know what that curriculum is, and I think that they're entitled to know what their kids are going to be taught in the future. So please vote yes.
Further remarks, the good member from the 41st District, Representative Tai.
Thank you, Mr. Speaker. I have an opportunity to serve as school board director at the same time as my colleague who just spoke on the floor. We have the privilege to not only ensure that our students are being served, but certainly ensure that our parents, the parents in our school district, and I myself was a parent of 2 school-age kids, to be engaged deeply in what being taught at school. And as the speaker speaking ahead of me, stating that school districts do have process of adopting curriculum, and they have very different in terms of when that is going to happen, because we have school board director as elected members of the school district. This amendment is prescriptive. It does not allow school board directors who closer to their school district, who understand the dynamic of their students and how to engage their community. It doesn't understand what the parents and their right within their school district. It is about ensuring local power and local support is being elevated. And really, I also wanted to add, I was a school board director for the Bellevue School District, Mr. Speaker. When our schools engaging with parents, they do so in the evening hours when parents come home. And when a parent who has to work 2 or 3 jobs, they can always request that meeting with the teachers, with their school and their principals at any time that's convenient for them. And I have seen firsthand how our school staff and educators go out of their way to ensure that engagement happen for the benefit of our students. Asking a no vote on this amendment.
Further remarks, the good member from the 20th District, Representative Orcutt.
Thank you, Mr. Speaker. Rising in support of the amendment. I appreciate what the gentlelady from the 41st is saying about our locally elected school boards. Unfortunately, what's really happening with the underlying bill and with our current superintendent of public instruction, our locally elected school boards are not getting a chance to make decisions for their community, for their school. They are being forced by law to provide certain kinds of materials, even when those school boards are opposed to them, when community members are opposed to them. Those school boards cannot make the decision on their own, because they are right now under the threat from the superintendent of public instruction of having some of their funding canceled. That is not putting the power in the hands of the locally elected school boards. Mr. Speaker, I understand the frustrations of the gentlelady from the 49th. Imagine the frustration of the parents when they see their kid come home with a comic book. On page 282 of that comic book, there's a graphic of a woman who is naked, and it's showing her from about the ribs down, lying down, her legs in the air, and another person's face between her legs.
Please refrain from such graphic descriptions, and please confine your remarks to the policy. Please proceed.
Thank you, Mr. Speaker. I will return my remarks to the policy at hand, in that if it's too graphic for me to talk about here on the floor of the House, is it not too graphic for a teenager to be taking home? Is it not too graphic for the teenager to see this before the parents even get to see it? I'm not exaggerating, Mr. Speaker. This is something a constituent of mine in my school district sent to me, enraged. The gentlelady from the 49th thinks she's enraged. Let me tell you, the parents are. Please adopt this amendment.
Further remarks. The good member from the 2nd District, Representative Marshall.
Thank you, Mr. Speaker, and I echo the sentiments from the gentleman from the 20th. I'd speak right now as a former school board member myself, a father of 3 daughters, 2 of them still in our public schools here in the state. I know that we can find the curriculum online, a great majority of it. But I also know that when I was on school board and we were going through curriculum adoption, and after curriculum adoption, I was routinely sidelined by parents showing me examples of objectionable material that was being taught to the students. I elevated this concern to principals, to the superintendent, and I always received the same response. That while we have certain curriculum that's adopted, there are supplementary materials that are used that do not go through the same review process. What we're asking for on this amendment is that all materials being taught to the children are available for review, and that the parents have the time to come review it. And the schools must comply, and not just with a link to a website from what comes from OSPI that we're mandated to adopt, but all of the materials that are being put in front of our children. I urge this adoption.
Further remarks. The good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker.
The member has 57 seconds.
Thank you, Mr. Speaker. I just want to add here, we're talking a lot about objectionable material. Mr. Speaker, the parents reviewing the material may love the material. It may not be that they find it objectionable. They may find a book on basic math a great math book. They may be encouraged and enthusiastic about what they see. The point, Mr. Speaker, is not whether they like it or dislike it. The point is we need to make the material available for the parents to see. I mean, it doesn't have to be these horror stories. It might be they're really happy with the biology textbook their kids are using. Let's give them the opportunity to be either really happy or really upset. And let's make the information available to them on terms they can use it. Please vote yes.
Further remarks. The good member from the 21st District, Representative Ortiz-Self.
Thank you, Mr. Speaker. Mr. Speaker, I think it's unrealistic to think that one teacher can inform parents about curriculum that they don't teach. In high school, an AP Calculus teacher needs to explain AP Calculus. An art teacher needs to explain art. We cannot have one person be in charge and satisfactorily answer the questions of all the teachers. So what does that mean? That means that all the teachers need to be present once a month. That means that we violate their contracts, and that means that it's an unfunded mandate. It also means, Mr. Speaker, that I'm willing to accept this if we fund it. If we give them the money to work extra hours and to be able to extend their contracts, that might be a different story. But first, Mr. Speaker, I would like to give them money for professional development. I would like to get translation services so that all parents can have access. Mr. Speaker, I'm frankly quite sick and tired of hearing about parent access when 40%.
Please state your point.
The member should refrain from impugning members of this body and keep her remarks to the issue at hand.
The Speaker does not find that the member was impugning other members, but would request that members keep their remarks at a respectful tone. Please proceed.
Thank you, Mr. Speaker. I am frustrated, Mr. Speaker, at the fact that we continue to talk, that across the state of Washington, continue to talk about parent access, but leave out about 50% of our parents that speak other languages. It isn't access to extend hours on weekends and nights alone. Translation services is something I have not seen us fund. Translation services is something I have asked for years. So it's not just enough to think that access will come by opening those doors. We have to make sure that we fund the teachers there. We need to make sure that the teachers have all their needs met, including translation services so they can adequately speak to the parents, professional development, smaller class sizes so that communication can take place. So it's a holistic approach that we need to take if we truly want that engagement with parents. Thank you.
Further remarks, the good member from the 25th District, Representative Jacobson.
Thank you, Mr. Speaker. Let's bring this back to the amendment. The amendment is allowing further hours for parents to view curriculum. And I think that parents are smart enough to see an AP Calculus book and see, oh, that's math, and think it's okay. I think that they don't need special explanations. And I think that there's a lot of things that we could do in our schools that would be good and that we should talk about. Perhaps more, I don't know, translations of things, I don't know. But this amendment is just about having parents being given the right for more hours to see the curriculum. And I think that if there are things in our curriculum that are too graphic to be spoken of on the House floor, I think that if we have some of those things in some of our curricula, that parents should be allowed broad authority to look at the curriculum, and that's all we're asking for. Thank you, Mr. Speaker.
Further remarks. The good member from the 14th District, Representative Mendoza.
Thank you, Mr. Speaker. Mr. Speaker, I used to be a parental involvement specialist many years ago, and the reason that I was hired is because I was bilingual. And one of the tasks that I had was to find ways to engage parents. I'm going to focus on the city of Grandview where I live. It's an agriculture community, 85% Hispanic, and a large population of monolingual Spanish-only parents. It's very easy to engage parents when you give them the opportunity to do it in a time that they can come in. I was very effective at getting parents in, but we had to do it at 6 p.m. We know that agriculture workers work long hours, but if you give them the opportunity and you provide it in languages in Spanish and English, they will show up, and I see that parents want to be involved, but we have to make the effort. And I see this as a very easy task. I'm going to ask you to vote yes on this amendment. It's an easy way for us to allow them to just review the material and ask questions. You don't need to do anything more than hire the right person to do it. So for that reason, I ask that you vote with me, Mr. Speaker. Thank you.
Further remarks. The good member from the 31st District, Representative Penner.
Thank you, Mr. Speaker. Rising in support of this amendment. I don't have any particular education expertise. I did not serve on a school board, but I am the parent of 4 children, and there are many children in my community and constituents in my district. Permission to refer to my notes as I make this point?
Please proceed.
Thank you, Mr. Speaker. As I look at the amendment and what it intends to do, I try to think about what's the opposite without this amendment. What is the status quo where we are today? Today, school districts need not provide opportunities outside of business hours and weekends for parents or guardians to examine textbooks, curriculum, and supplemental materials. School districts don't have to do this. Is that where we want to be, Mr. Speaker? School districts don't have to do this. Collectively, we agree, and the Constitution of the state says, that education is the paramount duty of the state. Mr. Speaker, we spend $40 billion a year right now on education. $40 billion a year, and school districts don't have to provide this opportunity for parents? $40 billion. Mr. Speaker, that's $40,000 million. 40,000 times a million. I took AP Calculus once upon a time. Mr. Speaker, this is well within our ability. This is right for parents. It's not too complex for us to do. Surely we have enough money to do it. School district by school district. Had an amendment been introduced to do it, to enshrine translation services, I would have been in support of that too. Please support me in supporting this amendment, Mr. Speaker.
Further remarks? Seeing none, the question before the House is the adoption of Amendment 382. A roll call has been requested. The Speaker is about to start the roll call machine. The Speaker has started the roll call machine. Has every member voted who wishes to vote? No, sorry. Has every member voted? Representative Entman, how do you vote? Does any member wish to change their vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. The clerk will take the record.
Mr. Speaker, there are 42 yeas, 52 nays, 4 excused.
The amendment is not adopted. There are further amendments. Amendment 435, the clerk will read.
On page 10, line 1 of the striking amendment, after insert medical or health records to the extent permitted by federal law.
The good member from the 2nd District, Representative Marshall, to move adoption of the amendment.
Thank you, Mr. Speaker. I move Amendment 435.
It has been moved and seconded that Amendment 435 be adopted. Remarks?
Thank you, Mr. Speaker. So what this amendment would do is put back into place what is in statute now after Initiative 2081. It put it back into this bill. What it would allow is parents to request health information, medical records that are obtained by schools when they request it. You know, I'm hoping there's not a whole lot of medical treatment going on in our schools without parents knowing about it, but if there is, and there's nothing to hide, I don't see an issue why parents cannot access that material. One of the arguments that I know may be brought up tonight is going to be the mature minor doctrine. That's something that was already litigated in our courts here in Washington, and in January of this year, the courts have now held that all of Initiative 2081 are in effect and are valid. So, with that said, if there's nothing to hide from the parents or the guardians, which is also in this amendment, we should adopt this amendment and make sure that parents or guardians have access to records for when their children are treated in the schools. Thank you.
Further remarks? The good member from the 41st District, Representative Tai.
Thank you, Mr. Speaker. I'm asking you to join me voting no on this amendment. In general, when it is a medical record, it is being regulated under HIPAA. When it is an academic record, it is regulated under FERPA. This amendment would create the kind of confusion, especially for staff who work in our school district. Follow what the sponsor of the amendment. Currently, we do have school nurses providing services for our students. Those information are regularly communicated and ensure that our parents know when our kids are running around and scratch their knees and if a Band-Aid or ice pack was being applied. For students who have the IEP or the 504, the parents are regularly being communicated during the beginning of the year and throughout the year, making sure those plans are being followed for, once again, the benefit of the students. And because of that, the confusion of this particular amendment, as the language is written, would create confusion for our staff to figure out which of these medical records should be in the student academic record and which medical record should be staying in the medical record, which regulated by two very different acts at the federal, asking for a no vote.
Further remarks? The good member from the 2nd District, Representative Marshall.
Thank you, Mr. Speaker. Permission to read?
Permission granted.
All right, so this is the effect statement for the amendment. Adds medical or health records to the extent permitted by federal law to the definition of education records. So the HIPAA and FERPA argument, I understand that. That was taken into consideration when drafting of this amendment. Also, if my child is injured at school, scrapes their knee, don't feel well, go see a nurse at school. I do want to know about that. And if I don't know about it and something's going on and I see that my child was injured, scraped, scratched, fell, hurt wrist, if any of this happens at school and I ask the school about it and they were treated, I would want them to tell me what happened. And I do not see why this is a concern to provide this type of a record to the parents. I urge we adopt this and make sure that we honor parents' rights and guardians' rights. Thank you.
Further remarks? The good member from the 25th District, Representative Keaton.
Thank you, Mr. Speaker. Having been on the school board for 8 years, you can imagine the constituents in my district talk to me a lot about educational issues still. And when it comes up about this bill, on this particular topic of medical records, they all have the same message. Why are medical records suddenly being taken away from the group of educational records? Why are they being segregated? What are they trying to hide? It breaks trust from the parents. The parents tell me, it's like, if they're trying to hide something, how can I trust the district that I love with my kids that I love? We have to make this right. Vote yes on this amendment.
Further remarks? The good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. Good amendment. Vote yes. This amendment restores the language that's in current law in the Washington State Parents' Bill of Rights that the underlying bill would seek to overturn. Mr. Speaker, when we drafted the Parents' Bill of Rights, we calibrated the language about releasing documents and information about kids to the existing standards in both FERPA, which applies, that's the federal law that applies primarily to school-related documents, and HIPAA, which is the federal law that applies primarily to health-related documents. Now, the truth is, Mr. Speaker, that FERPA actually controls most of those documents, and where there's any overlap, FERPA would apply. And FERPA actually protects the rights of parents and students to access their information. So it's really not restrictive on sharing this information, on notifying parents. It opens clear channels to how parents, families, and guardians can get information relevant to their children at school. So it is a misguided argument to say that this would create confusion. On the contrary, it aligns state law with federal law, both FERPA and HIPAA. Mr. Speaker, again, the object of the Parents' Bill of Rights is information. It's about notification about what children are experiencing. It's not confusing, Mr. Speaker. It's clear. And that's the great virtue of it. And when there is clear communication, when there is clear notification, I believe there will be better education outcomes. Vote yes on this amendment, Mr. Speaker. It is good for clarity and good outcomes for children. Vote yes.
Further remarks, the good member from the 49th District, Representative Stonier.
Thank you, Speaker Stearns. I'm voting no on this amendment for a couple of times. We are here tonight because of the confusion that has occurred as a result of passing the initiative. And we were concerned about that. On this very floor, members of this chamber communicated their concern about the confusion that may come because of exactly what we just heard. We asked the question whether or not medical records were impacted and laws related to medical records were impacted by the initiative. When we heard it in the committee, we asked again before we brought it to the floor. Council was clear. The answer was no. The fact that this amendment seeks to do the very same thing that we said the initiative didn't do in the first place is the problem. Medical records are medical records, and those are changed in another chapter of our state law. They are not changed with education policies. The answer is clear. The confusion is the problem. Vote no.
Further remarks, Representative Defoe.
Thank you, Mr. Speaker. I respectfully disagree with the good lady from the 49th. We are not here because of confusion or any misunderstanding by any court. To the contrary, a court has upheld this particular initiative and put it into effect. We are here because the Washington State Legislature decided to undo the will of the people.
Members should speak to the policy and not impugn other members. Please proceed.
Point of inquiry, Mr. Speaker.
The House will be at ease.
Get to know your state legislators with TVW's Legislator Profiles. Washington has 49 state senators and 98 state representatives. They hail from every corner of our state. They come to the Capitol with their own resumes and policy priorities. Go to tvw.org and click on Legislator Profiles 2023. Every profile has a link to the statewide legislative district map. Get to know your state legislators on TVW.
We're hoping we can get a sizable population in each area within 3 years.
We're always on edge, hoping that whenever the next storm rolls through, that lightning doesn't strike in our area to burn down more habitat.
A sizable
behind
population
all
in
that
each
fog
area within
is the
3
Pacific
years.
Ocean.
We're
Somewhere
always
50, 60
on edge,
miles
hoping that
away
whenever the next storm
could
rolls through, that
potentially be an
lightning doesn't strike in our
installation of
area
offshore
to burn down
wind
more
off the coast of
habitat.
Washington. The energy generation
sizable
behind the
population
well
in each area within 3
profiles
years.
and matches the
We're
demand
always
profile
50, 60
on
miles,
the
hoping that
stateway,
whenever the next
especially
storm rolls through,
potentially
that
be an
lightning doesn't
installation
strike in
other
our area
like
to burn down
off
more
the coast of
habitat.
wind are not as good. The energy generation behind the well profiles and matches the demand 50, 60 miles
hoping that whenever the next storm rolls through, that lightning doesn't strike in our area to burn down more habitat.
wind are not as the energy generation behind the well profiles and matches the demand 50, 60 miles
hoping that whenever the next storm rolls through, that lightning doesn't strike in our area to burn down more habitat.
wind are not as the energy generation behind the well profiles and matches the demand 50, 60 miles
hoping that whenever the next storm rolls through, that lightning doesn't strike in our area to burn down more habitat.
the energy generation behind the
Washington State gets its energy overwhelmingly from hydropower, which makes up more than half of the energy output of the state. Washington is also a leading producer of hydroelectricity in the United States, which is often hailed as a clean energy source. But despite all it provides, hydropower is not without significant controversy amid the ongoing debate over dams and their impact on salmon.
Thank you, Mr. Chairman. Good morning, everyone. The Columbia River system is the beating heart of the Pacific Northwest. The U.S. Capitol invoked strong emotions in the conflict over dams and salmon in the Northwest. Led by Eastern Washington Congresswoman Catherine Morris Rogers, it was triggered by a leaked Biden administration U.S. Capitol agreement between the U.S. government and 4 Northwest tribes regarding their treaty rights, led by Columbia River fish from the lower Snake River in Washington. This process was never about getting results for endangered salmon. It was a reckless pursuit of an activist agenda and misguided mission to wear out our neighbors with no scientific data to back it up. The agreement announced by the Biden administration in December 2023 did not authorize the breaching of the lower Snake River dams. Only Congress can do that. But it does include federal funds to help build new energy projects, offset hydropower, and transportation on the Snake River. Only Congress can do that. But it does include federal funds to help build new energy projects, offset hydropower, and transportation on the Snake River and steelhead. Today, 4 are extinct and 7 are listed under the Endangered Species Act. The tribes and environmentalists have sued the federal government over the dams, claiming the feds haven't done enough to save struggling fish in the Columbia River Basin. The Biden agreement halts the litigation for 10 years and puts the federal government on a path toward working with the tribes. To those who help negotiate, it represents a chance to end years of litigation and begin to write an agreement with salmon and dams.
We're right here in the center part of our state, in a little place called Beverly, Washington, where the mighty Columbia River flows below the dam advantage, and it's a beautiful, beautiful day. You know, in 1981, the legislature had a unique opportunity
The House will be in order. Representative Defoe to withdraw the parliamentary inquiry.
Thank you, Mr. Speaker. I'd like to withdraw my point of inquiry.
The point is withdrawn. Please proceed. The House will be in
Mr.
order.
Speaker, I'd like to do two things with my remaining time. First of all, I'd like to speak directly to the
Defoe
amendment.
to withdraw
And after that, I would like to
parliamentary
respond to
inquiry.
the good lady who Thank you, spoke Mr. Speaker. before I'd like me to withdraw my about point of why inquiry. we're here tonight. First of all, on this medical records, the ability to look at medical records. Mr. Speaker, as I mentioned earlier on in this debate, I'm a dad of 3 young girls. God gave me those girls to take care of and to their mother to take care of. It's a fundamental human right to be able to take care of your children and be the primary caretakers of your children and their health and their well-being. And that is a responsibility that I take, and I know that most parents in this state take very, very seriously. When a child is ill, when a child is hurt, when a child has anything significant in their lives happen under the watch of someone other than their parents, the responsible thing to do, especially when the government is their custodian, is to inform the parents right away and to allow the parents to understand the issue with their child. The purpose of this amendment is to allow a parent to inform the parents right away, access the complete medical records that a school might have in their possession about their child. I ask you to support this amendment. And now, in response and engendering debate with the good lady from the 49th, who mentioned that, the good lady mentioned that we are here because of confusion in the underlying policy, the Parents' Bill of Rights. My response to that, Mr. Speaker, is that that is not confusing. A judge has ruled it's not confusing and has given guidance on how to implement it. What happened, in fact, Mr. Speaker, is that a supermajority of this body and 100% of the chamber across the rotunda passed this policy that we are now gutting, Mr. Speaker. That is why we are here. In an attempt to gut a policy that almost 500,000 people in the state of Washington signed off on saying they wanted, and a supermajority of this body and 100% of the chamber across the rotunda said they wanted. And now we're trying to gut it, to take away rights from parents to be the primary caretakers of their children.
Further remarks? Seeing none, the question before the House. The good member from the 18th District, Representative Lee.
Good evening, Mr. Speaker. I speak in favor of the amendment. May I read?
Please proceed.
Thank you, Mr. Speaker. WSSDA's model procedure includes the following language. Students 14 years old or older who are absent from school due to testing or treatment for an STD will notify the school of their absence with a note of explanation which will be kept confidential. Students 13 years old and older may do the same for mental health, drug, or alcohol treatment, and all students have that right for family planning and abortion. Mr. Speaker, this is the information I believe parents want to be informed about. It is the information that they who lovingly want to care for their children, and yet the underlying policy here indicates it would keep that information from those loving parents. This amendment would make that information available to the parents. I ask you vote in favor of the amendment.
Further remarks? Seeing none, the question before the House is the adoption of Amendment 435. A roll call has been requested. The Speaker is about to start the roll call machine. The Speaker has started the roll call machine. Has every member voted? Representative Birnbaum, how do you vote? Representative Bronowski, how do you vote? Representative Birnbaum. Does any member wish to change their vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. The clerk will take the record.
Mr. Speaker, there are 42 yeas, 52 nays, 4 excused.
The amendment is not adopted.
There are further amendments. Amendment number 442, clerk will read.
On page 10, line 1 of the strike, insert federal law.
The good amendment from the second, Representative Marshall.
Thank you, Mr. Speaker. I move amendment 442.
It has been moved and seconded that amendment number 442 be adopted. Remarks.
Thank you, Mr. Speaker. This amendment is similar to the one that was just debated on this floor. What this one does that is different is it allows parents access to mental health records. This is important. Mental health records and knowing, well, mental health records, yeah, okay. I'm hoping schools aren't keeping them. The real concern here, though, is parents should know, guardians should know what is going on with their children. If they're suffering, if there's a mental health illness, if there's mental health concerns, if they need treatment, if they need counseling, this is something the parents should be involved in the decision making. In fact, the parent and the child should be the ones making the decision, not the schools. My concern is that children in our schools are receiving mental health treatment and it's being not just not communicated with parents, but actively hidden. That's a concern that I have, and many of my constituents have the same concern. Something that I'm concerned may be happening in our state is children are receiving not just counseling in the school from school counselors, but actually being transported off campus for mental health treatment, mental health counseling, potentially even medications being introduced into the children without the parents knowing about it. What this amendment's going to do is ensure that if a parent asks, they will receive the mental health records for their child that are being held and obtained at the school. So I urge that you join me in adopting this amendment. Thank you.
Are there further remarks? The member from the 41st, Representative Tai.
Thank you, Mr. Speaker. Mental health record is health record, which is regulated under HIPAA. This particular amendment asks to add any record related to mental health to the educational record. The education record is regulated under FERPA. And similar to the previous amendment, I'm asking to vote no on this amendment. At the same time, Mr. Speaker, my heart breaks for those young individuals who are experiencing mental health conditions and their parents don't know anything about it. I sincerely hope that these young individuals who are experiencing these conditions could share with their parents who love them enough to ensure that they get the services outside of our school system. As a member in this chamber, I have been serving as a healthcare and wellness member since I got to this place. The confusion comes when our health system or health services are expected to serve our students while they're in school. That is an education system, and it is frustrating to see how we continue to put layers upon layers on our educators, our education system, provide these services that should be done outside of school environment. Once again, I'm asking to put down this amendment.
Are there further remarks? The member from the second, Representative Marshall.
Thank you, Mr. Speaker. So I'm just going to respond Quickly, to two things that were said. First, this amendment would only be applicable to the maximum extent allowed by federal law, so that includes HIPAA and FERPA, federal laws. Secondly, I wholeheartedly agree, and it's a larger policy discussion. The mental health and medical interventions that are happening in our schools are not something that should be happening under the Department of Education or OSPI. This is a DSHS issue, and our schools have no business being involved in it. It needs to be separated, but that's a larger issue. Thank you.
Are there further remarks? Good member from the 25th, Representative Jacobson.
Thank you, Mr. Speaker. This amendment is important because it is very important that parents keep tabs on mental health records for their children. In my district, there was a gal who was a counselor who last year was fired from a major medical group because she was given the standard of care for counseling, and she was told that students who had suicidal ideation, students who had been abused, students who had other problems should be fast-tracked into gender-affirming care, and that would be the solution. And this counselor was uncomfortable with that. It's in the media, you can Google it. This counselor was uncomfortable with that, and she eventually was fired from her job as a counselor because she wasn't following the standard of care that involved fast tracking to gender-affirming care. Mr. Speaker, mental health records should be available to parents. Schools should not be as involved in the mental health of the children as they are. It should be something that is cooperative with the parents, and it should be something that they're very careful with. Thank you, Mr. Speaker.
Are there further remarks? The good member from the 39th, Representative Eslick.
Thank you, Mr. Speaker. Here's an example of records being held. May I read?
Please proceed.
Thank you, Mr. Speaker. This is from a mom from Pierce County. She wrote, "My son was in elementary school in the 3rd grade in 2019. His older brother was struggling with drug addiction and had been arrested. Our family had many resources for the challenges we were working through. My son loved school and loved his friends and his teacher. After his older son had been in jail for a bit, home life was settling down, but I noticed some major changes in my younger son's behavior at home. I assumed they were related to the struggles with his older brother, but he started wetting the bed and didn't want to go to school. And when he would finally get to school, he'd cover his head with his hoodie and hang his head and droop his shoulders. He fought me daily about going to school. That was going on for weeks, and then we had his student-led teacher conference. Around the corner came his school counselor, and she asked if she could join us. I saw my son's countenance completely change before my eyes as we all sat down. She took over the entire meeting and told us she was very concerned about our son and some changes she had seen, and that they had brought in outside counseling for our son. He was refusing to do his work. I asked why. I hadn't been told this before. And I asked how long had he been seeing this outside counselor. Her answer was 6 weeks. I asked her why they hadn't let us know or contact us if they were so concerned. I pulled him out of school immediately and started homeschooling him. But I also requested information on his discipline and counseling. It was a difficult process that took weeks with all the right wording, only to be told that they didn't keep those records. I asked who saw him and what the initial reasons were. They couldn't tell me. I have never received any further information or details on how he was disciplined. Why was he disciplined? Who was the counselor? Or why had a counselor come in? When the Parents Initiative was passed last year, I asked for it again and went through the same process. They refused. I have saved all my emails. Mr. Speaker, it is so important for our parents to have access to our mental health counseling records. Thank you.
Are there further remarks? Seeing none. Correction. The good member from the 19th, Representative Walsh.
Thank you, Mr. Speaker. Again, for clarity's purpose, there is nothing in FERPA or HIPAA that prevent a custodial parent from knowing the medical history or medical records of a minor child. There is nothing in the Washington Parents' Bill of Rights that in any way runs against or conflicts with the language of either FERPA or HIPAA. To the point, Mr. Speaker, there is no reason in law to hide a minor child's mental health care experiences from custodial parents or guardians. That's one of the critical points of the Washington State Parents' Bill of Rights. And for emphasis, Mr. Speaker, state courts have reviewed it. There was a lawsuit, and the state court concluded that the Parents' Bill of Rights is good law in this state. The underlying bill would gut the parents' rights as described in the Parents' Bill of Rights. This amendment protects the parent or guardian's right to know that the minor child has been receiving mental health counseling and the details of that counseling. Parents and guardians are the primary stakeholders in raising children, Mr. Speaker, not the state government. Please vote yes on this amendment.
Are there further remarks? The good member from the 21st, Representative Ortiz-Self.
Thank you, Mr. Speaker. Mr. Speaker, I could stand up here and tell you that I believe that HIPAA does prohibit the sharing of that information. That is what I was taught as a mental health counselor. I was told I could lose my license if I disclose any of that. We have a whole profession that lives under those rules and guidelines unless what has been disclosed is a danger to self or others. And so we abide by those laws. But that's not what I really want to say. I want to say that counseling and mental health services is built on trust. And as a school counselor, I can tell you that about 75 to 80% of the students that come and talk to me, out of their mouths, the first thing they say is, "Are you going to tell my parents?" And I have to say to them, if you're a danger to yourself or if someone's harming you, I must by law tell or report to CPS. And I'm honest with them and I tell them. And they proceed. And I want to tell you the story of a young lady who proceeded to tell me, who came and asked me the same question and then kept meeting with me. And it seemed innocuous. She kept talking about, oh, I got in a fight with a friend. I'm not sleeping. I didn't sleep well last night. Oh, I don't like this teacher. I get a lot of those as well. But after building some trust with her, that if I would have called the parents immediately and broken her trust and said, she came to me, I would have never found out. And after about 4 weeks of meeting with her, 5, she disclosed that her father's brother is molesting her. As she broke down and told me that, Mr. Speaker. Mr. Speaker, I would have never known. And worse, her parents would have never known. Because once I got that information, I was able to get her help. I was able to call her parents. I was able to get things in motion for her and keep her safe from any future harm. I don't know about you, Mr. Speaker, but if for whatever reason, my child cannot come and talk to me and they are in danger, I sure wish they will talk to another trusted adult that will contact me. I sure wish that they would have someone in many cases that could save their lives. Thank you, Mr. Speaker.
Are there further remarks? The member from the 35th, Representative Couture.
Well, thank you, Mr. Speaker. It's kind of funny. I think if that story could be shared on the floor, then it probably could be shared with parents. Mr. Speaker, the amendment says to the extent of federal law, there is nothing in this amendment that precludes that would go against any violation of HIPAA or FERPA. The problem with mental health in Washington State, which has had some ability for 40 years, since the 1980s, to be able, what once used to be for talk therapy and substance abuse counseling, has now radically shifted. It's radically shifted the goalpost year over year, and parents can sense the ever-eroding rights that they have under the 14th Amendment of the U.S. Constitution. Mr. Speaker, parents have the ultimate right for the education and upbringing of their children unless there is abuse and neglect. So unless there is abuse and neglect, and as the amendment says, unless it violates some federal law like HIPAA or FERPA, which already a court has said the Parents' Bill of Rights, Initiative 2081 has not, then this amendment is well in order, and we should, as a state, say that parents have access to their kids' mental health records for not only parents' rights, but also for the safety of our children in this state. Please vote yes.
Are there further remarks? Representative Defoe.
Thank you, Mr. Speaker. My heart goes out to the young person who the good lady from the 21st described, and I'm so glad that that young person had a counselor like the good lady from the 21st to confide in. There's trusted adults are wonderful, wonderful assets to have in our community and in our schools, but this amendment just makes sure that the parents are involved in any decision. Those initial counselings, those initial conversations, that doesn't generate a medical record. But once there's actually something of substance, once there's a diagnosis, once there's a referral, once there's something beyond that that generates a medical record, a parent needs to know. And I have no doubt that the good lady from the 21st would be able to pick that moment with her experience and her discretion and her expertise. But there are some folks who maybe won't do that. And we need to make sure that they are doing that because our parents have a right to know.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 442. A roll call vote has been requested. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted? Representative Birnbaum, Representative Dolio, Representative Paul, how do you vote? Does any member wish to change their vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will take the record.
Mr. Speaker, there are 42 yeas, 52 nays, 4 excused.
The amendment is not adopted. There are further amendments. Amendment number 396. Clerk will read.
On page 10, line 13 of the striking, internal references accordingly.
The good member from the 19th, Representative Walsh.
Thank you, Mr. Speaker. I'd like to move Amendment 396 for adoption.
It has been moved and seconded that Amendment number 396 be adopted. Remarks.
Thank you, Mr. Speaker. One of the bizarre results of our state's public policy on health care and mental health care that's provided to children is that in some circumstances, a parent or guardian can receive a bill for medical services or mental health care services rendered to the minor child with no notification of what services were rendered. And that parent can be held financially responsible, financially liable for services not only that the parent never approved of, but the parent was never even notified of. Now, Mr. Speaker, here we come up alongside the state's mature minor doctrine, which we've heard discussed on the floor earlier tonight. What this amendment does is it does not touch the mature minor doctrine, which is about parental permission or the lack of parental permission when a minor child receives medical care or other kinds of health care. But what it does say is that if the parent or guardian can be held financially liable for services rendered to the minor child, the parent or guardian at least has to be notified that the services are being provided. Now, that doesn't mean that the parent has the ability to give permission or not, or withhold permission for the services. It merely says that the parent or guardian will be notified that the services were rendered. Now, Mr. Speaker, this was an essential and important part of the Washington State Parents' Bill of Rights, which is current law right now. It, in fact, was one of the most heated elements of the lawsuit that challenged the Parents' Bill of Rights. And it was one of the most significant conclusions of the state court that the Parents' Bill of Rights is good law, that it was okay for the parent to be notified that some services had been rendered if they were bound to pay for the services, even if they weren't required to give permission So let's be clear what this amendment does. It restates that the parent must be notified if he or she is financially responsible for services rendered to the minor child. Please vote yes on the amendment.
Are there further remarks? The member from the 41st, Representative Tai.
Thank you, Mr. Speaker. Asking for a no vote on the amendment. Understanding the concern that parents should be notified, especially when it's come to financial responsibility. Here's the situation. When there is a young person in the school ground, within the responsibility of the adult in school, something happened to that young individual, the first reaction is to save this person. And also, this amendment speaking to the assumption that the staff in school know what this is about. So the scenario would be when there is a situation in front of a front desk staff, they would then call for emergency. An ambulance came, took this young person to an emergency care. And then that is when they would scramble to notice the parents and families. However, the care for this individual is first and foremost. And so this amendment does not take into consideration of the emergency situations, and therefore I'm asking for a no vote.
Are there further remarks? Seeing none, the question before the member from the 25th, Representative Jacobson.
Thank you, Mr. Speaker. So looking at the amendment, this amendment does take into account emergencies. Thank you.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 396. A roll call vote has been requested. The Speaker is about to open a roll call machine. The Speaker will open the roll call machine. Has every member voted? Representative Brodsky, Representative Donaghy, Representative Hunt, Representative Santos. Does any member wish to change their vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will take the record.
Mr. Speaker, there are 42 yeas, 52 nays, 4 excused.
The amendment is not adopted. There are further amendments. Amendment number 420. Clerk will read.
On page 10, beginning
last line.
Internal references accordingly.
The member from the 12th, Representative Steele.
Thank you, Mr. Speaker. I move amendment 420.
It has been moved and seconded that amendment number 420 be adopted. Remarks.
Thank you, Mr. Speaker. I rise tonight with what I hope is a pretty pragmatic and straightforward amendment. Mr. Speaker, I think it should be the practice of all of our schools, and I believe it largely is, that they notify parents before their children receive some sort of medical procedure. This amendment also says that before you give the child some sort of new medication, you're going to let that parent know that that child might be receiving that medication for the first time. And again, I think this is a huge liability if we're not already doing this. And I think this is largely the practice of most schools and school districts across our state. We should be concerned about that liability. I also think, Mr. Speaker, that parents know their children, know what their children are facing in terms of health issues, and they should be the ones that have the ultimate say in what their children receive in terms of medical support, and medication. And so I really think that this, to me, Mr. Speaker, is really a no-brainer. Again, it keeps us from having what I think it keeps us from assuming a large liability, and I think that's very prudent on our part. So I hope that you will at least consider this as a pragmatic amendment to what I think is pretty important and should be retained on the list of parental rights that we grant our parents in this state, because I believe most parents who are trying to do well by their children want to be involved in these crucial decisions. And I should mention too, this of course precludes emergencies. So if a child is going to have some sort of emergency procedure, the parent may not be notified, and that is certainly included in this amendment. Again, I feel like this is a no-brainer and something we should pursue. So I hope that you'll join me in adopting this amendment, Mr. Speaker.
Are there further remarks? The member from the 49th, Representative Stonier.
Thank you, Speaker Shavers. Asking for a no vote. I do agree with the good gentleman. This is practice in schools, but as I've said this evening a couple of times, the statutes related to providing medical services and prescriptions or non-prescription drugs are changed and governed in a different part of our state statute. So when we're talking about what schools do, these are not relevant. The law needs to be clarified because, as I mentioned earlier, the confusion as a result of the passage of the initiative is getting to be a real problem for our schools. On February 28th of last year at 8 a.m., the chairs of both the House and the Senate Education Committees joined to ask these questions. Those questions were answered. One of them had to do with whether or not medical access and medical records were impacted and those statutes impacted by the passage of the initiative. The answer was no. The initiative did not change that. This bill is clarifying that the initiative did not change that. To be clear to schools so they can implement the work of teachers and caring for children, please vote no.
Are there further remarks? The good member from the 25th, Representative Jacobson.
Thank you, Mr. Speaker. There's no confusion. We are lawmakers, and our statute should reflect that parents have a right to know if their child is being offered medical services or medicines. If there is a problem in what area of the law we need to place that in, we need to figure that out. Parents have a right to know. I would want to know if my children were being offered medical services or medicine, because I'd want to be there to help them. Thank you, Mr. Speaker.
Are there further remarks? The good member from the 35th, Representative Griffey.
Thank you, Mr. Speaker. Please excuse Representative Aslick.
The member is excused. Are there further remarks? Seeing none, the question before the House, adoption of amendment number 420. A roll call vote has been requested. Speakers have to open the roll call machine. Speakers, open the roll call machine. Has every member voted? Does any member wish to change their vote? The speakers have to lock the roll call machine. The speakers lock the roll call machine. Clerk will take the record.
Mr. Speaker, there are 41 yeas, 52 nays, 5 excused.
Amendment is not adopted. There are further amendments. Amendment number 448. Clerk will read.
On page 10, line 13.
Last line.
Internal references accordingly.
The amendment from the 26th, Representative Caldier.
Thank you, Mr. Speaker. I move adoption of Amendment 448.
It has been moved and seconded that amendment number 448 be adopted. Remarks?
Thank you, Mr. Speaker. So this amendment simply states that in the event that the school either directly or indirectly arranges for medical treatment, that if the child requires any follow-up care, meaning they're taking medication and need to be monitored, or there's some potential adverse issues, or they need to have a follow-up appointment for their medical provider, that at least in those instances, the parent should be notified. This is a very simple amendment. To me, it is also another no-brainer, and it also helps protect the schools from any liability issues if anything were to happen to that child, and I urge adoption of that amendment.
Are there further remarks? Seeing none, the member from the 49th, Representative Stonier.
Thank you, Mr. Speaker. Once again, standing to ask you to turn this amendment down. Schools do not prescribe medication. Schools do not do medical procedures, and it's important to be very clear about that. And I'm asking you to turn this amendment down for that reason. Now, when my kids were at Harmony Elementary School in Vancouver, my friend Erin and I would laugh because when something went wrong at school, one of the kids were hurt, something happened, Mallory had a fever, we would say, no emergency, Michelle is calling, because we could see the number on our phone. This was a school nurse that would call and say, "Hi, honey, it's Michelle, no emergency, everything is fine," but was giving me an update on what was happening with my kiddo at school. Information is provided in real time to parents when kids need support, a Band-Aid, something happened, there's a conflict. Turn this amendment down. These are amendments about medical issues and policies that are not in school statute.
Are there further remarks? The good member from the 26th, Representative Caldeira.
Thank you, Mr. Speaker. Well, it's great to hear that there's another Michelle out there that's very responsible. I love that. However, if schools are already doing this, why not adopt the amendment? Why protest thou? So please urge adoption.
Are there further remarks? The good member from the 19th, Representative Walsh.
Thank you, Mr. Speaker. Please vote yes on the amendment. It clearly states in the amendment that this could be a matter of arranging medical services or care either directly or indirectly. So it may not be that it's the school nurse administering a service. It could be that it, speaking hypothetically, is a counselor or teacher who, out of an abundance of concern, thinks they're doing the right thing by advising or helping arrange some kind of counseling or treatment for a child elsewhere. So, Mr. Speaker, we need to be careful to make sure that parents are notified when any such thing occurs. It could be innocuous. It could be a good thing that all parties agree would be helpful. But we can't know that it's a good thing where all parties agree would be helpful unless all parties know it's happening. Vote yes on the amendment and make sure that parents understand what's happening, either directly or indirectly, to their children. Please vote yes.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 448. A roll call vote has been requested. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted? Does any member wish to change their vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will take the record.
Mr. Speaker, there are 41 yeas, 52 nays, 5 excused.
The amendment is not adopted. There are further amendments. Amendment number 428. Clerk will read.
On page 10,
Last
line
line.
34, insert "and legal guardians on an annual basis."
The good member from the 35th, Representative Couture.
Thank you, Mr. Speaker. Please move amendment 428.
It has been moved and seconded that amendment number 428 be adopted. Remarks?
Thank you, Mr. Speaker. This amendment is similar to a previous amendment that we heard earlier in the debate. This is about the immediate notification of parents when there is any kind of criminal activity or sexual assault or sexual misconduct by school employees, staff, teachers, anybody within the school, including if those staff lure or groom or take a child outside of school grounds in order to do them harm, that when it is even alleged and not just a reasonable cause, that parents should be notified immediately. Mr. Speaker, as a father of 4 kids, I would be absolutely disgusted to know that one of my kids had some kind of sexual misconduct placed upon them in our schools, and I didn't know, not for 1 day, but 2, possibly 2 days, 48 hours later. That, Mr. Speaker, is unacceptable to me, and I know it is unacceptable to the vast majority of Washingtonians. We want immediate notification when bad things happen to our kids in schools. We do not want to wait. Please vote yes on the amendment.
Are there further remarks? The good member from the 37th, Representative Santos.
Thank you, Mr. Speaker. We agree. Please vote yes.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 428. A roll call vote has been requested. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted? Representative Bronowski, how do you vote? Does any member wish to change their vote? The Speaker has locked the roll call machine. The Speaker has locked the roll call machine. Clerk will take the record.
Mr. Speaker, there are 93 yeas, 0 nays, 5 excused.
The nays have it, or correction, the ayes have it. The amendment is adopted. There are further amendments. Amendment number 448. Clerk will read.
On page 10, beginning
Last line.
internal references accordingly.
The good member from the 35th, Representative Couture.
Thank you, Mr. Speaker. Please move amendment 444.
It has been moved and seconded that amendment number 444 be adopted. Remarks?
Thank you, Mr. Speaker. This would essentially include when in the underlying bill that we don't want, we want parents to have immediate notification if their children are removed from school grounds, but this amendment would include if that was a host home or a youth shelter. Now, permission to read, Mr. Speaker.
Please proceed.
I want to share a story from a parent here in Washington State. I work in a pediatrics office. Recently, I received a phone call from a frantic mother who had sent her child to school, and that child was now missing. Her 13-year-old daughter had been dropped off at school on Thursday morning, just like every morning. Somewhere along the lines, the principal and nurse held a Zoom video appointment with our pediatric provider due to the 13-year-old feeling depressed. The school and pediatrician decided to help keep the child safe. She would be taken to Sacred Heart Hospital for inpatient services. This child never came home. Sacred Heart agreed to keep the child for a 72-hour hold. It was now a Monday morning. This mother had spent all weekend trying to locate her 13-year-old, only knowing that she had sent her child to school and now nobody could tell her anything, including me. Mr. Speaker, the story goes on, but I think you get the point. Back in 2023, this chamber passed Senate Bill 5599, which allowed the state to hide from parents the whereabouts of their children if they were to seek go to a youth shelter or a host home. Mr. Speaker, to me, that is state-sponsored kidnapping. We should not be hiding children from their loving parents, and the state doesn't own our kids. The state, we do not co-parent with the state, and there should be no circumstance ever where the state of Washington steps in between loving parents and hides their children from them, so parents like this have to go around and searching for their children, wondering if they have been murdered on the streets or not. Please vote yes on this critical amendment.
Are there further remarks? The good member from the 49th, Representative Stonier.
Thank you, Speaker Shavers. Asking for a no vote on this amendment. I stood right here on this very spot when that bill was passed in 2023, and I remember the debate very clearly. The statute was changed, and the law is now current law because we heard stories of children who had parents or home lives or who were homeless, needing a place to go that was safe and secure and warm. And should notification be needed, the bill that we passed and current law clearly states that CPS will immediately contact the parents and let them know that their child is safe. So when we talk about the state hiding from children, it's the state agency that calls the parents. We passed that bill to make sure that children who needed a safe place where they were not going to get beaten, abused, starved. We heard personal stories about this kind of stuff already tonight. That bill was passed to save lives. Overturning that now would be a problem. Yes, parents have a right to know. Absolutely. That's why we ensured that the state would call them to make sure they knew their kids were safe. There's not an inconsistency here. Vote this down.
Are there further remarks? Representative Defoe.
Thank you, Mr. Speaker. The government doesn't get to decide where your kids are and whether or not they're safe. I have 3 daughters. I want to see them with my own 2 eyes. I want to determine if they're safe. I'm not going to take an assurance from somebody else. Mr. Speaker, it's so important that under these circumstances, we have a child in distress, that the parent can help them. Most of the parents in this state are good parents who love their kids. And those kids may go through difficult times, but it's especially in those times when they need their parents. And it's not up to a state agency, it's not up to a school district, it's not up to any government actor to make that determination. It's up to the parent.
Are there further remarks? The good member from the 19th, Representative Walsh.
Good amendment, Mr. Speaker. Please vote yes. Mr. Speaker, this whole concept of the state government determining what constitutes safe for a minor child, including the minor child being sent to or located in a so-called host home, a thing with very little legal meaning and very little regulatory definition, is troubling in the extreme. Mr. Speaker, there is existing law, and it's good law, for dealing with families where there is abuse or neglect of minor children. What this amendment does is it makes sure that parents and guardians are involved and informed of anything that relocates their minor child to a host home or shelter. Mr. Speaker, it is not sufficient that a bureaucratic agency may at its discretion notify the parents where their child is. Mr. Speaker, it is essential to good public policy that we are not confused and that we recognize that parents are the primary stakeholders in the raising of their children. We are in extremely troubling ground when the state presumes to decide what constitutes safe for a minor child. In extraordinary circumstances, it may be required, and normally there has to be some level of court adjudication. This amendment protects the standard, and the standard, Mr. Speaker, is that parents are the primary stakeholders in the raising of their children. Please vote yes on the amendment.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 444. A roll call vote has been requested. The Speaker has opened a roll call machine. The Speaker has opened the roll call machine. Has every member voted? Does any member wish to change their vote? The Speaker has locked the roll call machine. The Speaker has locked the roll call machine. The clerk will take a record.
Mr. Speaker, there are 41 yeas, 52 nays, 5 excused.
The amendment is not adopted. There are further amendments. Amendment number 437, clerk will read.
On page 11, line 11, internal references accordingly.
The member from the 18th, Representative Lee.
Good evening, Mr. Speaker. I move Amendment 437.
It has been moved and seconded that amendment number 437 be adopted. Remarks?
Thank you, Mr. Speaker. I encourage you to join me in voting yes for this amendment. The underlying amendment requires that students under age 18 cannot excuse themselves from school. Mr. Speaker, we have a huge problem with truancy in our state. Far too many students are not in the classroom, and if they're not in the classroom, they cannot learn. And if the parents don't know that their children are not in the classroom, the parents cannot get involved and try and remedy that situation. I think about why do we have excused absences to begin with? I think the underlying message of that is responsibility. A parent expects that when they drop their children off at school or when they put their children on the school bus, that the school is now responsible for the care and the education of their children, and that the school and the teachers and administrators will look after their children all day, and that responsibility ends when the student gets off the school bus or the parent picks them up in the afternoon. An excused absence indicates that the school is no longer responsible, letting the parents know that their child, and that giving the parents the opportunity and the requirement to issue that excused requirement lets the parents know they are now responsible for their children's care and safety and relieves the school of that burden. So I would think the schools would welcome having parents involved in that excused amendment or not. Unbelievably, as I researched more about this bill, current policy says that a majority of our school districts will allow children as young as 9 years old to walk out the doors of the school without notifying the parents. To me, Mr. Speaker, that is unacceptable. Bottom line is we should let parents be the ones issuing an excused absence or not and being informed when their children are not in our schools. Thank you, Mr. Speaker.
Are there further remarks? The member from the 5th, Representative Callan.
Thank you, Speaker Stivers. I am respectfully asking for a no vote, and may I refer to my notes, please?
Please proceed.
In 2022, the legislature unanimously passed 1834, which gave students the authority to take an excused absence to care for their well-being. It was a mental health bill. That bill and that excused absence clarified in the RCWs that exist today what qualifies as an excused absence. Today, absence notification and excusal is all reliant on local school district policy. That policy is guided by, let me make sure I've got it in my notes, RCW 28A.225.010. In the case of the legislation that we passed before, school districts can have a policy that says, yes, a student can be excused for mental health reasons, but they can also have a policy that says the parent is the one that has to notify the school to authorize that excuse. If a student's not showing up, if they're absent, they're there one period, they're gone the next, I know in my school district, I'm being notified because that's an unusual behavior for a student to be there and then not be there. If a school is being missed, I'm being notified by my school that you either need to provide a excused notice application reminding me as a parent that I forgot to send in the excused notification, or I need to go figure out where my child went, right? And so we're working on it together as a school district. The school districts that I did a quick review of, several of them all have that same requirement, parent notification and waivers. So from my perspective, Mr. Speaker, and why I'm requesting your no, local school districts have the authority today to set the policy that does just what this amendment asks, and I ask for that local control to stay in place. Thank you.
Are there further remarks? The member from the 2nd, Representative Marshall.
Thank you, Mr. Speaker. I urge a yes on this amendment. While I agree, as a former school board member, school districts can and often do have stricter requirements. What troubles me is the WASDA, the Washington State School Directors Association. Their policy, their model policy, allows 13, 14-year-olds to excuse them, and even as young as 9 years old to excuse themselves and for it to remain confidential. That's the model policy from WASDA, and that's troubling. Not just that they're going to get this care without their parents knowing, but what's more troubling is with the rampant crime in a lot of our cities, with the human trafficking that's been going on up and down the I-5 corridor, we are allowing students to excuse themselves from school and go out into public without their parents even knowing about it. And it is dangerous out there. We are one of the most dangerous, if not the most dangerous state in the country. And we're excusing 9-year-olds to go out in public, no supervision for who knows how long and who knows how often. We have the ability to fix that with this amendment. I urge a yes.
Are there further remarks? The member from the 49th, Representative Stonier.
Thank you, Mr. Speaker. Asking for a no vote here. At about 3:40 every afternoon, if my daughter was not in second period or fourth period, I would get a notification that she was not at school. And that notification would come during the day when attendance was taken, and then another one later on in the afternoon to make sure that I was updated. Oftentimes it was just what I did all the time as a classroom teacher. I was a little late getting my attendance record in because I'm welcoming students and getting class started. So this notification is in place. Schools are responsible for knowing where students are. And sometimes in the mix of things, that may be a little bit delayed or even inaccurate. Most of the time she was in second period. Attendance just hadn't been taken yet. Kids aren't just running out of school. We know where they are. Vote this amendment down.
Are there further remarks? Representative Defoe.
Thank you, Mr. Speaker. Agree with the good lady from the 49th. Most schools do this right. The problem is that if this bill passes, they have the discretion to do it wrong and to do wrong by parents across our state. The good lady from the 5th said that a student can excuse themselves for mental health reasons, or can be excused for mental health reasons. That is very different. That unanimous vote is very different from excusing themselves or being excused without the parent knowing. That is the point, Mr. Speaker. The parent needs to know. And just because a lot of school districts, or most school districts, or almost all school districts are doing it right, doesn't mean that we shouldn't put in place protections for parents and kids who are not.
Are there further remarks? The good member from the 2nd, Representative Barkas.
Thank you, Mr. Speaker. You know, Mr. Speaker, as a parent, been through a lot with my children, and I just sitting here listening to this debate tonight, and so much of the stuff is just a little mind-boggling to me, Mr. Speaker. But this one, Mr. Speaker, we have the Becca law for a reason on truancy. We have measures in place. If it was not for the schools notifying me as a parent that my son was not in school, I can't imagine what might have happened. Mr. Speaker, there's a whole series of mechanisms that are in place that the school is responsible to notify parents when their student's not there. And I'm reading this, and I haven't said much tonight, but I've been thinking about this, and I looked at this and I went, students under 18 can excuse themselves from school? I mean, I'm not quite following this. Mr. Speaker, that particular piece that is so important to this has to be there for situations like I went through with my son. If that had not happened, I can't imagine what might have happened to my son. And if it weren't for the school notifying me, to give me the opportunity to correct things that were going on and also lead to a series of things that eventually helped correct certain behaviors and certain problems, not sure what I would have done. Had a lot of good amendments tonight, Mr. Speaker. Not many have hung. This is a good one. I recommend a yes vote on this tonight.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 437. A roll call vote has been requested. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted? Representative Vronsky. Does any member wish to change their vote? The Speaker has locked the roll call machine. The Speaker has locked the roll call machine. The clerk will take the record.
Mr. Speaker, there are 41 yeas, 52 nays, 5 excused.
The amendment is not adopted. There are further amendments. Amendment number 440. Clerk will read.
On page 11, line 11.
Last line.
Internal references accordingly.
The good member from the 26th, Representative Caldeira.
Thank you, Mr. Speaker. I move adoption of Amendment 440.
It has been moved and seconded that Amendment number 440 be adopted. Remarks.
Thank you, Mr. Speaker. So this is a very simple amendment that would basically just allow the schools to only do emergency medical care to provide the consent for that. As a little bit of background, there is in statute currently that we have a kid that we call a unaccompanied minor, and we've kind of defined that as somebody that they are having issues with their biological family, and they are either couch surfing, they're out on their own. I am very sympathetic to those kids. At the same time, I also believe that there are a lot of medications, a lot of treatments that kids are getting, and the parents still need to be involved. If there are issues with abuse, we should involve DCYF and make sure that those issues are reported. If, however, like for example, with the bill that passed a couple years ago, which would allow somebody to leave the home if there were verbal confrontations with their family members regarding what their gender identification is, and DCYF has them in custody and is not letting the parents know their whereabouts, that in those situations, the parents still need to be notified. They still have their parental rights. As a foster parent, there was a whole process that needed to be done, a whole legal process for DCYF to make sure that the parents' rights were terminated, and that DCYF would legally deem that child legally free, or the courts would deem that child legally free, and therefore then that child would be a ward of the state. These children are not a ward of the state, and I urge adoption of this amendment.
Are there further remarks? The member from the 37th, Representative Santos.
Thank you, Mr. Speaker. Asking you to vote no. This policy that's being proposed may run afoul of other statutes. I want to give you an example. One example is that under current law, the role of a school nurse is not to be under the direction of a school principal, but rather is under the direct supervision of a medical doctor. So that is outside of the purview of most of 28A. So we cannot tell a school nurse that she cannot provide informed consent without going afoul of other statutes. The other piece that I would like to just bring to your attention, Mr. Speaker, is that if you had a child who was perhaps stung by a bee and going into anaphylactic shock, I think you would want to have the school nurse or school counselor immediately provide epinephrine, or worse, if your child was overdosing on an opioid, I think you would want the school nurse to apply Narcan. I think under practical considerations, the schools do make every effort to notify parents and legal guardians as soon as practicable as this proposal suggests. But I do think that this proposal as written puts us in jeopardy of violating other statutes. So I ask you to turn this down, please.
Are there further remarks? The member from the 35th, Representative Griffey.
Thank you, Mr. Speaker. Then we should change the law. I have treated many people that were in anaphylactic reaction, anaphylactic shock. It doesn't take any time to treat them. There are many people that work in the schools. I have worked with nurses who treated anaphylaxis and treated other disorders. There are other people there that know the number of the parents. Other people at the school can call the parents and say, we have called 911 and we are treating your child. I reject the argument that the good gentle lady just made. I respect the good gentle lady, but it is absolutely possible to notify the parents who are responsible for those children. I know because I was there and I even did it. I called the parents right away, right after I administered epinephrine. I needed to know all the other medical conditions that the child had because I treated that child. And a lot of times the medical records that the school has does not have all the information in it. The parents have all the medical information because they raised the child from an infant. Mr. Speaker, I just implore you to adopt this amendment.
Are there further remarks? The good member for the 19th, Representative Walsh.
Thank you, Mr. Speaker. Good amendment, vote yes. Mr. Speaker, this focus on emergency treatments for anaphylaxis or other things like that is beside the point. The language of the amendment acknowledges that emergency treatment could be administered, and in that case, the parent should only be notified as soon as practical. The focus of the amendment is on non-emergency medical care. That's the purpose here. And in that case, what it says is that a school nurse or a counselor or a homeless liaison cannot act as the parent in place for a minor child to receive non-emergency medical care. Mr. Speaker, once again, the point of the Washington State Parents' Bill of Rights, which state courts have held is good law, is to inform parents when their child is receiving medical care or other activities at school and essential contexts of what minor children do in their children's lives. This is a good amendment. It clarifies that no one but a parent can agree with informed consent to a minor child receiving non-emergency health care. Let's not put the state between custodial parents and their minor children. Vote yes on the amendment.
Are there further remarks? The member for the 37th, Representative Santos.
Thank you, Mr. Speaker. I just want to clarify. The good gentleman perhaps misunderstood. The law that needs to be changed is not the law in 28A. The law that needs to be changed is in the laws governing medical attention, because the school nurse falls under the direct supervision of a medical personnel outside of the school process. So, Mr. Speaker, I do ask again that you vote no on this amendment.
Are there further remarks? The member from the 35th, Representative Griffey.
Mr. Speaker, I absolutely reject the possibility that the school can't notify a parent that their kid is experiencing a medical condition that is not a HIPAA violation. I've been trained on HIPAA my entire career for 30 years. We have had patient protections built into the work that I did for 30 years. Absolutely, the school has the right and responsibility to ask. Mr. Speaker, I urge this adoption.
Are there further remarks? The member from the 21st, Representative Ortiz-Self.
I just wanted to say that 99.999% of the time, every school counselor and nurse that I know, the first thing we do is we contact parents. But I'm going to vote no on this because we have children that have what's called CHIN petitions, children in need, where parents are not available to them, where they are not under the department's custody, and if they are, their caseworker cannot be found. And under those conditions, sometimes counselors are put in a position where they have to just let the provider know that the child is under a CHIN petition, and that authorizes their access to services. We're not giving them permission for the services, but we are verifying that they fall under that category that allows them to get that permission, and it puts us in a very gray situation. Part of the problem with some of these amendments is that there are few exceptions because it's not parents the way we think of parents. We have a lot of special circumstances, and these amendments can sometimes, and this amendment is an example of that, can sometimes limit And if it keeps services from one child that deserves it and should access it, then I can't be a yes. So I'm going to vote no.
Other further remarks? Representative Defoe.
Thank you, Mr. Speaker. If there's a chin petition or anything else, that's built into the process. We need to take that number from 99%, if that's what it is, up to 100%. Because anytime, Mr. Speaker, that a child needs non-emergency medical care, the parent needs to be involved.
Other further remarks? The member from the second, Representative Marshall.
Thank you, Mr. Speaker. Permission to read?
Proceed.
The parent or guardian must be notified as soon as practicable after the consent for health care is provided regarding to emergency medical treatment. This is the 0.0001, as the good lady said, that those people still matter. Parents still must be informed. There still must be consent. I urge the adoption.
Other further remarks? Seeing none, the question before the House is adoption of amendment number 440. A voice vote has been requested. For those in support, say aye. Aye. For those opposed, say nay. No. The nays have it. The amendment is not adopted. There are further amendments. Amendment number 454, clerk will read.
On page 11, line 11, RCW.
The good member from the 14th, Representative Mangeras.
Thank you, Mr. Speaker. I move Amendment 454.
It has been moved and seconded that amendment number 454 be adopted. Remarks. The good member from the 15th, Representative Corey.
Good morning, Mr. Speaker. Thank you very much. Urging the body's adoption of this amendment that simply provides some clarity and says that students should not be informed of personal recommendations or advice around several topics that we think are better left for parents, guardians, or any other of the situations being faced in Washington State today. This is a good clarifying amendment, I think, for one important reason. One, it's going to focus our kids back to our schools back to what's supposed to be going on, learning and educating and teaching kids. It provides some clarity for school administrators to know that these are things we're not supposed to do, so we're not going to do them. We're going to focus on education, and it provides parents the ability to redress those grievances if they're violated. Please vote yes.
Are there further remarks? The good member from the 3rd, Representative Hill.
Thank you, Mr. Speaker. We don't need this amendment. It's unnecessary. Under existing law, parents are allowed to opt out and not have their children participate in any comprehensive sexual health education. If they have these concerns, there's simply other ways to deal with it. No child's going to be forced to engage in these conversations, and parents absolutely have the right of inquiry and to opt out. So I would encourage a no on this one.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 454. We will proceed with a voice vote. For those in favor, say aye. Aye. For those opposed, say nay. No. The nays have it. The amendment is not adopted. There are further amendments. Amendment number 439, clerk will read.
On page 11,
Last
beginning
line.
of line 18, all materials through insert 2 on line 19 and insert G2.
The good member from the 14th, Representative Mangeras.
Thank you, Mr. Speaker. I move Amendment 439.
It's been moved and seconded that amendment number 439 be adopted. Remarks. The good member from the 15th, Representative Corey.
Thank you, Mr. Speaker. Urging the body's adoption of this. This would simply extend notification and opt-out provisions to a variety of surveys and evaluations that are not subject to the Federal Protection of Pupils' Rights Acts. So, Mr. Speaker, may ask yourself, what are some of those topics? If you mind, I'd like to read.
Please proceed.
Thank you. So these topics and surveys can cover things like political affiliations or beliefs of the students or the students' parents or legal guardians, religious practices, affiliations, beliefs of the students or the student's parental guardians, illegal, antisocial, self-incriminating, or demeaning behavior. These types of surveys, there's more. It's a pretty comprehensive list of things that may come up in a survey, and we believe that parents should have a right to know what kind of surveys their children are taking and allow for proper opt-out under state law. So please vote yes.
Are there further remarks? The good member from the 46th, Representative Paulette.
Thank you, Mr. Speaker. Contradictory amendment, please vote no. Mr. Speaker, the title of this act includes safe and supportive public education system through student rights. It is nothing more than ironic to me, Mr. Speaker, that we would strike from an act relating to protecting and advancing student rights the references with settled law on student rights from the Federal Protection of Pupil Rights Amendment. That's ironic. and I ask for no vote.
Are there further remarks? The member from the 15th, Representative Corey.
Thank you, Mr. Speaker. With all due respect, it's not ironic because the amendment specifically says it's not to surveys that are not subject to the Federal Protection of People's Rights Amendments. It's a little late at night. That's a long law, but this, thankfully for the good gentleman, he can vote yes because this underlying bill, or the amendment, does not violate that. Please vote yes.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 439. We'll proceed with a voice vote. For those in support, say aye. Aye. For those opposed, say nay. The nays have it. The amendment is not adopted. There are further amendments. Amendment number 450. Clerk will read.
On page 11, beginning line 20, insert or any.
The member from the 14th, Representative Mendoza.
Thank you, Madam Speaker. I would like to move Amendment 450.
It's been moved and seconded that amendment number 450 be adopted. Remarks. The member from the 15th, Representative Corey.
Thank you, Mr. Speaker. Urging the body's adoption of this amendment that would restore that has some underlying stuff from the Parental Bill of Rights that has been removed in the striker. It's important for us to have more parental involvement and rights to know when students are participating in different assignments, questionnaires, role-playing activities, or other things regarding a number of sensitive areas, Mr. Speaker. Some of those which can include political affiliations, sexual behaviors and attitudes, family, mental or physical, or other psychological discussions. Those things are important. Again, a lot of these tend to, stray away from what is the core function of our schools, which is the education of children for the betterment of their careers and futures in our state and around the world. So please adopt this amendment. Thank you.
Are there further remarks? The member from the 49th, Representative Stonier.
Thank you, Mr. Speaker. Asking for a no vote on this amendment. It expands under state law the types of instruments that are subject to federal Title 20, Section 1232, and we want to make sure that the adoption of this amendment does not get in the way of federal law. Please vote no.
Are there further remarks? Representative Defoe.
Thank you, Mr. Speaker. Again, we hear about these legal technicalities when it's very simple. If a school, if a government, if an agency is going to record someone's child, the parent needs to have the option to opt out or explicitly give consent. Common sense, Mr. Speaker. Vote yes.
Are there further remarks? The member from the 19th, Representative Walsh.
Thank you, Mr. Speaker. Good amendment. Please vote yes. We all want to make sure that Washington State honors federal law. That's very important, Mr. Speaker. But to the point in this amendment, when we drafted the Parents' Bill of Rights and spoke to parents around the state, we heard time and again concern about role-playing games, that parents were hearing from their kids long after the fact that the kids had been subjected to these role-playing games where they had to pretend to be something other than they were. I suppose the point was to create some sense of identification or empathy. But some of these role-playing games involve some very incendiary issues of race, of gender, of background. And they were clearly, I believe, meant to provoke in the child perhaps some higher consciousness or expansion of consciousness, but in some cases they were very troubling to the children. One might even say traumatic. So it was essential in those focus groups and those conversations we had that we include language that if there were these role-playing games that children were being forced to participate in at school, parents would be notified about role-playing games. Now, this is not an issue covered in a lot of existing statute, either at the federal or state level. As we understood it, at least as we articulate it in the Parents' Bill of Rights, it was kind of a new point. But we wanted the clarity that if there were these role-playing games and other sorts of non-traditional learning mechanisms, that parents would be notified it was happening. It was a matter of some urgency to multiple families and parents around the state, and that was the reason we included it in the Parents' Bill of Rights, which, again, for emphasis, has been upheld as good law by a state court here. So please vote yes on the amendment, Mr. Speaker, to restore that notification to parents and families.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 450. We will proceed with a voice vote. For those in support, say aye. Aye. For those opposed, say nay. No. The nays have it. The amendment is not adopted. There are further amendments. Amendment number 389. Clerk will read.
On page 11, line 34.
Last line.
Strike parent and insert family.
The good member from the 17th, Representative Waters.
Thank you, Mr. Speaker. Good evening. I'd like to move Amendment 389.
It has been moved and seconded that Amendment number 389 be adopted. Remarks?
Yeah, Mr. Speaker, this is just a friendly amendment looking to expand kind of the scope of students and people who can be involved with the students. So right now it says in the bill, student parent. We're looking to go to student family. I'd encourage you, yes, this would allow a guardian, a sibling, aunt and uncle, whoever's tied, or maybe perhaps a guardian for that person, signed up for them to be able to come and help their kids. So just looking for that. Thank you, Mr. Speaker.
Are there further remarks? The good member from the 46th, Representative Paulette.
Mr. Speaker, I rise in opposition to this, noting that this bill is, again, about student rights and parent and guardian rights. Those are well-defined and understood terms. And as the good gentleman presenting the amendment suggested, this would mean that there'd be rights to notification of undefined family members, perhaps a non-custodial parent, which could be quite frightening. And how do you know which family member receives and has these rights? It's totally undefined, and I ask for a no vote. Let's stick with what we know, parents and guardians who should have rights along with the students.
Are there further remarks? The good member from the 17th, Representative Waters.
Thank you, Mr. Speaker. Just to rebut the good gentleman just a little bit, I actually raised my cousin when I was in college. I was his parental guardian when I went to Eastern Washington University. He went to Cheney High School. Previously, went to Stevenson High School. I'd like to think that an amendment like this would actually help. When I was in that situation, if this bill were in place back then, I'd like to think that this very simple amendment would allow me to have the rights to be able to access my cousin's information while I was that person's guardian, while I was raising him in both middle school and high school. So I urge an amendment. I urge a yes.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 389. We will proceed to the voice vote. For those in support, say aye. Aye. For those opposed, say nay. No. The nays have it. The amendment is not adopted. There are further amendments. Amendment number 386. Clerk will read.
On page 13, line
Final
6,
line.
Internal references accordingly.
The amendment from the 31st, Representative Penner.
Thank you, Mr. Speaker. I move Amendment 386.
It has been moved and seconded that Amendment number 386 be adopted. Remarks?
Thank you again. Good morning, Mr. Speaker. This amendment, I urge your support of it, I believe strengthens one of the underlying tenets of the bill that we have before us tonight. The emphasis on safety and, in particular, districts prioritizing safety. We heard a lot of discussion earlier this evening about bullying, about the opportunity, or really the sad case of bullying for maybe students who are trying to understand where they fit in the gender conversation. And we heard a lot of other conversations about individual members' experiences with bullying. I was a little bit surprised in reading through this bill to find that there is no fundamental right for parents to request a safety plan that a district might put in place to address the bullying. Now, this amendment doesn't create a right for parents to have a safety plan, but it does create a right for parents to request that safety plan, and if denied, to know in writing why they were denied. I believe, as I said when I introduced this amendment a minute ago, that this is a good amendment because it strengthens the underlying focus on safety and support for our children. I urge your support of this amendment.
Are there further remarks? The good member from the 30th, Representative Taylor.
Thank you, Mr. Speaker.
A safety plan, as defined in this amendment, is very vague and very unclear. It is unclear because parents have the options of providing documents to the schools. I represent parents in family law matters, and if I want the parent to have an exchange with another parent and make sure that the non-custodial parent has the right to go pick up the kid, that means that I would advise my client to tell the school, give a copy of the parenting plan so that they can create the safety plan. This is something that's co-created with the parent. The parent has the option to participate with the school on how they want the child to engage. And so they can always add this in. And this is especially important when you're talking about domestic violence protection orders. You provide those documents. That is the safety plan. When kids are involved in bullying, schools have options, resources from OSPI to figure out how to create safety plans for kids, especially kids who are in conflict. So I urge a no. It's already in.
Are there further remarks? The member from the 31st, Representative Penner.
Thank you, Mr. Speaker, and with deep respect for my fellow member, the OSPI has safety plan templates. The OSPI on their website has, may I
please
cite this, has a template called Harassment, Intimidation, or Bullying Targeted Student Safety Plan Template. This is not a family plan. This is not a family safety plan. This is an OSPI safety plan. The amendment references the OSPI safety plan. Mr. Speaker, I urge a yes.
Are there further remarks? Seeing none, the question before the House is the adoption of amendment number 386. We will proceed with a voice vote. For those in support, say aye. Yay! For those opposed, say nay. Yay! The nays have it. The amendment is not adopted. There are further amendments. Amendment number 462. Clerk will read.
On page 13, line
Last
10,
line.
internal references accordingly.
The good member from the second, Representative Barkas.
Thank you, Mr. Speaker. I move Amendment 462.
It's been moved and seconded that amendment number 462 be adopted. Remarks?
Thank you, Mr. Speaker. Actually, it's a pretty simple amendment this morning. Mr. Speaker, with all that we've been hearing about our public schools, we have a shining spot, a shining star in our state, and that is our charter schools. You know, Mr. Speaker, over the last several years, we've seen the emergence of some amazing charter schools in the state of Washington that have provided just incredible opportunities for students from every corner of our state. What this amendment just says, Mr. Speaker, is that it adds the right for a parent to request enrollment of their child into a charter school. Simple. Request the ability to enroll in a charter school. And Mr. Speaker, I think that after maybe parents hear a little more about what we've been talking about tonight and think about what's been going on, I think that we might see even more of an emergence of our charter schools in the state of Washington and a little more high demand. So I think this is a great amendment to allow this process to go into place and let parents have that choice to select a charter school. I encourage its adoption.
Are there further remarks? The good member from the 49th, Representative Stone here.
Thank you, Speaker Shavers. Asking for a yes on this amendment. The amendment does not redefine anything in healthcare law. It does not touch protections in federal law. This amendment is a right that parents currently have, and it doesn't seem to me to be a problem to just restate it again. Please vote yes.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 462. A roll call vote has been requested. The Speaker will open the roll call machine. The Speaker has opened the roll call machine. Has every member voted? Does any member wish to change their vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will take the record.
Mr. Speaker, there are 92 yeas, 1 nays, 5 excused.
The ayes have it. The amendment is adopted. There are further amendments. Amendment number 383. Clerk will read.
On page 14, after line 9, discharge of any member of such teaching or administrative staff.
The good member from the 25th, Representative Keaton.
Thank you, Mr. Speaker. I move Amendment 383.
It has been moved and adopted that amendment number 383. Correction, it has been moved and seconded that amendment 383 be adopted. Remarks.
Thank you, Mr. Speaker. Just over a year ago, when Initiative 2081 was passed by the legislature, I received comments from parents in my district parents and guardians in my district that were very thankful that this initiative had been passed. They were thrilled. They were saying that they listen to us. They care what we think. Right soon after that, I started getting information and snapshots from something from OSPI before any court settlings or anything had happened, saying that OSPI was doing their own judicial interpretation of the laws made in this building. This initiative is set up to try to restore some of that trust. We've heard that on January 27th, the King County judge said this is good, safe law. Initiative 2081 is good law. I offer this amendment now so that this amendment requires that teachers and administration work with families to properly show that as a measure to try to build that trust back with the families. Thank you.
Are there further remarks? The member from the 37th, Representative Santos.
Thank you, Mr. Speaker. Asking respectfully that you vote no. The reason we are here so late, so early in the morning, is because the provisions of the initiative were not clear and did cause confusion in the field. The field is being asked to implement the provisions of the initiative, and this effort that we are spending on all these long hours is intended to help create the clarification so that people in the field can implement the provisions of both the initiative, but also, as we have balanced it tonight, with fidelity. So for this amendment, I ask you to please vote no.
Are there further remarks? Representative Defoe.
Thank you, Mr. Speaker. I respectfully disagree with the good lady. There's no confusion here. What has happened, in my view, Mr. Speaker, is there has been superintendent of public instruction obstruction of the implementation of this bill. I, as a parent, as a father, as a former state legislator, attempted to exercise 3 of my rights as a parent, very clearly delineated in the Parents' Bill of Rights, that was signed by almost 500,000 voters in the state of Washington, unanimously passed by the body across the rotunda, supermajority of this chamber, all experienced people in drafting, reading, reviewing, and passing laws. It was upheld by a state judge. There is no confusion here, Mr. Speaker. There is obstruction. And this amendment will stop that obstruction from being implemented at the individual level by individual teachers and administrators. There are plenty of great teachers and great administrators in this state, but there are some who are obstructing the implementation of this bill. And this amendment, Mr. Speaker, will say, you cannot do that anymore. If a parent like me wants to see the curriculum, you have to show it to them. If a parent wants to participate and observe a board meeting, the curriculum board meeting, you cannot keep the parent out of the room and say, this is a staff meeting. This needs to be implemented. This needs to be prioritized. We need to cut out this nonsense where we go around and we issue edicts and mandates and bureaucratic measures to stop the implementation of duly passed legislation by the Washington State Legislature. And then again, a second level of obstruction at the local school district level by defiant administrators and defiant teachers who do not want to follow the law. That is unacceptable. Let's have it end tonight by passing this amendment.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 383. A roll call vote has been requested. The speakers will open the roll call machine. The speakers open the roll call machine. Every member voted. Representative Fitzgibbon, how do you vote? Does any member wish to change their vote? The speakers put the lock the roll call machine. The speakers lock the roll call machine. Clerk will take the record.
Mr. Speaker, there are 40 yeas, 53 nays, 5 excused.
The amendment is not adopted. There are further amendments. Amendment number 436. Clerk will read.
On page 7, line
Last
4.
line.
Right strike all material through cultures on line 23.
The member from the 19th, Representative McIntyre.
Thank you, Mr. Speaker. I move Amendment 436.
It has been moved and seconded that Amendment number 436 be adopted. Remarks.
Mr. Speaker, you and I are both college graduates. And as college graduates, you and I know how to do our homework. And so this bill does something very, very simple. It's just a technical fix. Because you know how to do your homework, when you did a thorough read of the underlying bill, I am sure that when you got to page 8, line 21, you scratched your head in confusion when you realized that it described a right of students to have a learning environment with historic and scientific, I want to get my words right, historically and scientifically accurate information. And the reason for your confusion, Mr. Speaker, is that you said, wait a minute, I thought it said later on in the bill that there was no addition of any new rights. Correct you are, Mr. Speaker. There is no addition of any new rights, and yet this is something we don't have in statute. We don't have a list, an enumerated right for students to have an environment of historically and scientifically accurate information. So I would join you in your confusion. How can this be? This amendment, all it does is it simply removes that. So that there will be no problems. There's no addition of any new rights. So then everything is hunky-dory. And I think that is all the points I had to make on that. Anyway, if you vote yes, I'm sure this bill will be ever so slightly better than it is now. Thank you.
Are there further remarks? The member from the 22nd, Representative Parsley.
Thank you, Mr. Speaker. May I read from the effects of this bill, or this amendment?
Please proceed.
Removes the provisions related to the right to access learning environment with historically and scientifically accurate information from the student rights. I'm curious. I'm a scientist. Went through a lot of science classes in grade school and high school. Why would you remove historically and scientifically correct information from this bill? I'm just curious. I'd have to say no to this amendment because this is a student's right. We need to make sure historically and scientifically correct information is taught in school.
Are there further remarks? The member from the 19th, Representative McIntyre.
Mr. Speaker, I remembered my second point. That is, it is subjective. Who gets to decide what is scientifically and historically accurate? We have historians that can't agree on what happened. Was there talking, Mr.
To the body, I respectfully ask members to take your conversations to the wings. Please proceed.
Thank you. Masterful call, Mr. Speaker. So we can't allow the subjectivity of those things, right? We have scientists that disagree all the time. We have historians that disagree all the time. Those words are simply too subjective. Can you or I, Mr. Speaker, really say what is scientifically or historically sound? It's very much up for debate, and so that makes it problematic. To answer the good lady's question about why we wouldn't want this in the bill, that was already mentioned. It's not that we don't want history and science and that to be a part of our curriculum and part of the environment. We do. It's just it can't be an enumerated right in there because we don't have something like that in statute. It's not defined. It doesn't make any sense. So please, Mr. Speaker, vote yes.
Are there further remarks? The member from the 19th, Representative Walsh.
Thank you, Mr. Speaker. Yes, good amendment. Vote yes. Mr. Speaker, when the state gets in the business of determining what is historically accurate, you often end up with everyone agreeing that Oceania has always been at war with East Asia. Vote yes on the amendment, and let's avoid that stuff, Mr. Speaker.
Are there further remarks? The good member from the 20th, Representative Barno.
Thank you, Mr. Speaker. I didn't intend to speak, and I am no scientist, and I'm not going to get into the subjective world of what the effects statement says. But what I will say this, as an attorney looking at a statute, if the statute is inconsistent and it says it's not creating any new rights and then it creates a new right, you're going to find a lot of litigation in this because the purpose of this is not to create any new rights. So when it does, it's inconsistent. There's going to be a lot of litigation, and it definitely is the intent of the legislature not to create a new right because that's what this bill does. So for that reason, I urge a yes.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 436. We will proceed with a voice vote. For those in support, say aye. Aye. For those opposed, say nay. No. The nays have it. The amendment is not adopted. There are further amendments. Amendment number 391. Clerk will read.
On page 5, beginning line 23, and strike section 101, 201, and 202, and insert section 101.
The member from the 35th, Representative Couture.
Thank you, Mr. Speaker. Move amendment 391.
It's been moved and seconded that amendment number 391 be adopted. Remarks.
Thank you, Mr. Speaker. Permission to read for accuracy.
Please proceed.
All this amendment does is removes all provisions in the underlying bill related to the statement of student rights. And why that's important, Mr. Speaker, is because these student rights that have been just essentially just kind of made up and put in here are very inaccurate and could cause a lot of problems. We heard a little while ago that we wouldn't want to put any unfunded mandates into our schools, yet if we don't accept this amendment, that is exactly what you will be doing with the whole new host of enumerated rights in this bill, some of which are ill-defined. Vote no on unfunded mandates, Mr. Speaker, and vote yes on this amendment.
Are there further remarks? The good member from the 37th, Representative Santos.
Thank you, Mr. Speaker. Asking for your no vote on this amendment. First of all, we know for a fact students have rights. That the state constitution issues the highest positive right to an education to our students. Mr. Speaker, the section that the amendment seeks to remove removes all of these rights, not only from the state constitution and from state statute, but from the federal constitution and from federal statutes. Mr. Speaker, I ask why. This is only to balance the rights that we are articulating that are given to or taken by our parents or given to our parents in law are balanced by the rights that are given to students also by the Constitution and law. Please turn this amendment down.
Are there further remarks? The good member from the 35th, Representative Couture.
Thank you, Mr. Speaker. It is true. Students do have rights in our state. They have a right to a free and appropriate public education. But the underlying bill, as we heard earlier, if you don't comply, OSPI, Chris Ragdoll, is going to come after you and take away your school's money because the school and the duly elected school board isn't going to follow Chris's, very deeply held ideological beliefs. Students do have rights, Mr. Speaker. They're in our state constitution. They're in our current state law. And you know what? Parents have rights too. It's called Initiative 2081, the Parents' Bill of Rights, which is current law. Parents have those rights. But this underlying bill seeks to undermine those rights and undermine students' rights and destroy families. Vote yes on the amendment.
Are there further remarks? The good member from the 19th, Representative Walsh.
Thank you, Mr. Speaker. It's safe to vote yes on this amendment. This amendment only deals with statutory proposals. Any right enshrined in the Constitution, either state or federal, is not touched by any of this. Please vote yes to get back to the policy point that was originally addressed by the Parents' Bill of Rights and take some of this other material out of the underlying proposal. Please vote yes.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 391. We will proceed with a voice vote. For those in support, say aye. Aye. For those opposed, say nay. No. The nays have it. The amendment is not adopted. There are further amendments. Amendment number 384. Clerk will read.
On page 14.
Last line.
Strike meeting as in RCW 28A.150.010.
The good member from the 4th, Representative Schmidt.
Yes, thank you, Mr. Speaker. I'd like to move amendment 384.
It's been moved and seconded that amendment number 384 be adopted. Remarks?
Yes, Mr. Speaker. This amendment basically puts the private right of action back into the underlying bill. There are several points in the underlying bill that don't sit well with me, and I believe they take away from a well thought out items that were in Initiative 2081. Initiative 2081 gave parents private right of action. The underlying bill removes this right for parents, leaving no remedy. Private right of actions provide a direct avenue for individuals to seek remedy to alleged wrongs rather than relying solely on the government. Parents' rights are meaningless if they can't be enforced. Please vote yes on this amendment.
Are there further remarks? The member from the 3rd, Representative Hill.
Thank you, Mr. Speaker. I am encouraging a no on this amendment. Section 3 of the proposed striker seeks to clarify the conflicts that were created in 2081 and that are existing in law that were modified through the adoption of that initiative. So what this does, and why it's important to note that no right of private action is created, is to restate and clarify the existing law. Please vote no.
Are there further remarks? Representative Defoe.
Thank you, Mr. Speaker. Without a remedy, there is no right. In this bill, there is no opportunity for parents who are being obstructed, whose rights are being violated by the Office of Superintendent of Public Instruction, by their children's school district, by their individual schools, by an individual teacher. There is no way for the parent to enforce their rights unless we add this amendment. In the Parents' Bill of Rights, we need to have a remedy, or this is all empty. The will of almost 500,000 signed voters, the will of the people as expressed by a unanimous vote in the body across the rotunda and a supermajority vote here in this chamber, will be totally empty and totally nullified. Vote yes.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 384. An oral roll call vote has been requested. The clerk will call the roll.
Abarno. Abel. Barkas. Barnard. Berg. Berquist. Birnbaum. Berry. Bernosky. Burnett. Caldier. Callan. Chase. Connors. Corey. Cortez. Couture. Davis. Dolio. Donahue. Dewar. Defoe.
Defoe votes aye.
Dye. Engel. Entenmann. Farvar. Fitzgibbon. Fossey. Goodman. Graham.
Graham votes aye.
Gregerson. Griffey. Hill. Hunt. Jacobson. Keaton. Clicker. Kloba. Levitt. Lekanoff. Lee. Lowe. Macri. Mangeris. Marshall. McClintock. McIntyre. Mena. Mendoza. Morgan. Nance. Obras. Orcutt. Ormsby. Ortiz Self. Parsley. Paul. Penner. Peterson. Paulette. Rommel. Reed. Reeves. Richards. Rude. Ryu. Salahuddin. Santos. Schmick. Schmidt. Scott. Shavers. Simmons. Springer. Stearns. Steele. Stokesbury. Stonier. Street. Stevie. Taylor. Ty. Theringer. Thomas. Timmons. Voles. Wallen. Walsh. Waters. Wiley. Yabera. Zahn. Madam Speaker.
Clerk will take the record.
Mr. Speaker, there are 39 yeas, 54 nays, 5 excused.
The nays have it. The amendment is not adopted. There are further amendments. Amendment number 458. Clerk will read.
On page 14,
last line.
References accordingly and correct the title.
The member from the 4th, Representative Schmidt.
Thank you, Mr. Speaker. I'd like to move Amendment 458.
It's been moved and seconded that amendment number 458 be adopted. Remarks. Remarks. The good member from the 35th, Representative Couture.
Thank you, Mr. Speaker. What this amendment would do is it would get rid of any of the provisions prohibiting school district employees, school district directors and employees and directors of public schools from taking adverse employment actions against employees. This provision in the underlying bill is just simply unnecessary. Our school district employees and teachers already have protections in law. not only duplicative, but more than duplicative. We don't really need this. I think this is a helpful amendment just to clean things up. Please vote yes.
Are there further remarks? The good member from the 49th, Representative Stonier.
Well, thank you, Speaker Shavers. The bill before you is about ensuring that students have a right to a safe school environment. The adults in that school environment have a right to uphold the law without retaliation. I have stories of actions taken by school district officials who wish to uphold policies that are not reflective of what we ought to be doing in schools to make kids feel safe, welcome, so that they can learn. If I, as a teacher, if No Emergency Michelle at the front desk, if paraeducators are in a position to support a student when they need it, they ought not be retaliated against if they choose to follow the law. Vote this amendment down.
Are there further remarks? The good member from the 19th, Representative Walsh.
Vote yes on the amendment, Mr. Speaker. We're getting kind of lost in triple and quadruple negative propositions here. Basically, what this amendment does is it removes some duplicative language, redundant language that's in the underlying proposal. Mr. Speaker, there could be retaliation in all kinds of scenarios here. We're sort of borrowing trouble, Mr. Speaker, to assume that the implementation of good law would somehow result in an illegal retaliation. It's so convoluted, it's even hard to articulate, as both of the previous speakers have had trouble even saying what the language that this amendment gets rid of would do. It is late at night, Mr. Speaker, it's true, that could be a factor here, but I believe beyond that, this amendment simplifies and clarifies a complex and unclear section of the underlying proposition. So please vote yes for clarity's sake. And employees already have protections against retaliatory actions. So we can remove this without creating any harm for anyone. Please vote yes.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 458. We will proceed with a voice vote. For those in support, say aye. Aye. For those opposed, say nay. Nay. The nays have it. The amendment is not adopted. There are further amendments. Amendment number 367. Clerk will read.
On page 15.
Last line.
On line 17.
The good member from the 7th, Representative Engel.
Thank you, Mr. Speaker. I move amendment 367.
It's been moved and seconded that amendment number 367 be adopted. Remarks?
Thank you, Mr. Speaker. This issue before us today is largely as a result of an initiative signed by more than 400,000 people, which was then adopted by this body last year. And I've heard from people every corner of my district, parents concerned that this bill is undermining their rights, and they're concerned about how this could impact their children. I believe that it's only right that we remove the emergency clause to make this able to easily go back to the people for a vote should they choose to start that process. I urge the adoption of the amendment.
Are there further remarks? The good member from the 49th, Representative Stonier.
Thank you, Mr. Speaker. Asking for a no vote on the amendment. You've heard me this evening already a number of times talk about the confusion that has been a result of the passage of the initiative, despite our very sincere efforts to be as clear about what the initiative did and didn't do, despite our work to try and clarify that again tonight. If I had not spent the last year hearing the stories of harm done to children and their families who may not feel represented in the community of their schools, I would not be worried about accepting this amendment. Harm has been done. It must stop. Vote no.
Are there further remarks? Representative Defoe.
Thank you, Mr. Speaker. There's no emergency. We know there's no emergency because this bill has languished. The Parents' Bill of Rights has languished for almost an entire year now. If there was an emergency, Mr. Speaker, OSPI could have issued some clarifying language. If there was confusion, OSPI could have issued some clarifying language. What did OSPI do? It obstructed implementation of the entire Parents' Bill of Rights for almost a year. Individual school districts, individual administrators, individual teachers obstructed unambiguous language of the Parents' Bill of Rights. If this is such an emergency, Mr. Speaker, why didn't each one of those agencies, institutions, individuals take steps to clarify it? There's no emergency, Mr. Speaker. What an emergency clause does is it prohibits a vote of the people by initiative, referendum. The emergency clauses in this chamber have there have been so many emergency clauses that have come out of this chamber for things that aren't emergencies. This is an egregious example of that exercise, Mr. Speaker, in this bill. That over 400,000 voters would sign an initiative saying, we want this Bill of Rights. That almost an unanimous Washington State Legislature would say, we want this Bill of Rights. The impact of the emergency clause in this bill will prevent voters from saying, we want this Bill of Rights. Taking away the voice of the voters on something they have already said we wanted, both with their own signatures and through their duly elected representatives. This is unacceptable. This is disingenuous and it's obstructionist and it needs to be stopped.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 367. We will proceed with a voice vote. For those in support, say aye. For those opposed, say nay. No! The nays have it. The amendment is not adopted. There are further remarks. Correction, further amendments. Amendment number 358. Clerk will read.
On page 15, beginning of operation.
The good member from the 8th, Representative Connors.
Thank you, Mr. Speaker. I move amendment 358.
It's been moved and seconded that amendment number 358 be adopted. Remarks.
Mr. Speaker, I dare say to me, this might be the most important amendment of the night. The initiative was passed by over 450,000 registered voters in Washington State from places like Seattle, Spokane, Tacoma, Vancouver, Yakima, Bellingham, Kennewick, Wenatchee, Ellensburg, Longview. All across Washington State, people put their names on that initiative because they cared about having parental rights for their children. This amendment puts that right back into the voters' hands. It gives a referendum, it adds a referendum clause to send this back to the people of the state of Washington to let them decide what rights parents have with their children. Mr. Speaker, on March 4th last year, this parental Bill of Rights was good enough for me. And it was good enough for a lot of us, Mr. Speaker. It just went into effect by OSPI here shortly after the legal ramifications that just happened. We haven't even given it time to see if it's going to work. So we're telling the people from all of the cities and more across Washington state that I said tonight that this is not good enough. Mr. Speaker, it's good enough for me. I'm encouraging you to vote yes tonight for all of the parents across the state of Washington who signed that initiative.
Are there further remarks? The good member from the 46th, Representative Paulette.
Thank you, Mr. Speaker. Mr. Speaker, you and I are elected representatives of the people in our district. We are accountable to the people who voted in our district, and we will return to be accountable to them. That's why we are here at 1:06 a.m., speaking, debating, and being accountable to our constituents. And this is where decisions are made at 1:06 or 1:07 a.m. We will take a vote, and people will decide whether or not we should be accountable for voting aye or nay. We know that passing an initiative is different than collecting signatures. Mr. Speaker, I've been the author and director of 3 initiatives and a referendum, and I know full well that the easy part is collecting the signatures, and many of the people who sign an initiative change their mind after hearing both sides of a debate. This legislature adopted an initiative because under the state constitution, we had a choice in front of us. As an initiative to the legislature, we could adopt it, or we could let it go to the ballot. We adopted it, and now we are faced with trauma. We are faced with confusion, and we found ourselves having to change it and amend it significantly to ensure that students and parents understand what their rights are, and our educators understand how they can protect those rights without fear of retaliation. And therefore, it's incumbent on us to take this vote. And I ask for us to reject the notion that we have to send it to the voters instead of us standing and taking a vote tonight. Thank you.
Are there further remarks? The good member from the 39th, Representative Lowe.
Thank you, Mr. Speaker. We are accountable to the voters, and that's why we're all here tonight. But you know, we're also accountable to each person who voted to put us here too. The voters wanted this initiative to be on the ballot. They've signed 400,000 plus times over and over and over to send it to us to make that decision. And instead of putting it on the ballot for the voters, we decided to vote it in as law last year. That was the right decision. But here we are, a year later, making this debate on the floor for hours and hours and hours under the cover of darkness, when the news media isn't here anymore, when the public is in bed sleeping. The voters deserve the opportunity to have the final say in this. What are we scared of? What are you and I scared of? If we're doing the right thing here tonight under the cover of darkness, we should not be afraid to let the voters have the last say in this. Thank you.
Are there further remarks? The good member from the 15th, Representative Corey.
Yeah, thank you, Mr. Speaker. I too agree with the good gentlelady from the 8th. This is probably the most important amendment of the evening, and one we should fully adopt. While it is true, obviously, we are sent here to draft, debate, advise, and make legislation. Our state constitution gives this power to the people. And with the emergency clause, obviously, the option of a referendum is taken away. So making sure that we have the ability and telling the people we want to hear from you, I think is extremely important. The good gentleman earlier talked about the fact that he had worked on, I believe, 3 initiatives and 1 referendum. That referendum would have been a response to something we did here. And I would like to ask that good gentleman, I guess I'd like to ask you, Mr. Speaker, what would have happened if there was an emergency clause and that referendum option would have been taken away? That referendum would not have happened. We're not saying that the people will agree, yes or no, with how you and I think, Mr. Speaker. We're saying we want to know where the people stand on this issue. And it's true, 400,000 plus people sent this initiative to us, and we passed it into law. But before it was even fully implemented, this bill we're now debating was introduced. So the confusion has really been around the process to even get to the point where this bill, the initiative, the initiative could be implemented. So I think it's more than fair to give people the final say on something as important as this underlying policy. Please vote yes.
Are there further remarks? A good member from the 20th, Representative Orcutt.
Thank you, Mr. Speaker. Rising in support of this amendment. There's no secret here. I've offered many amendments to many bills to add a referendum clause. And as much as I believed in all of those, I doubly believe in this one. Let me tell you why. Initiative 2081 was an initiative to the legislature. Had it not passed here, it would have gone to the voters. Had it not passed here, and the bill before us had been in the session then as a replacement for Initiative 2081, it too would have gone to the ballot. That is something that the people expect when an initiative to the legislature is changed, that will be put in front of them as well as the original initiative. And it gives them an opportunity to vote on the alternative. Well, it's a year late, but it's still a change to that initiative, different than what they sent to us. And while it's a year late and maybe we don't have to do it, I believe we owe it to the 430-some-odd thousand people who signed that initiative, who expected the ability to have that on the ballot or to have that and an alternative on the ballot. This is the alternative. It should be on the ballot. It's only the right thing to do.
Are there further remarks? The good member from the 25th, Representative Keaton.
Thank you, Mr. Speaker. Just to clarify, the initiative gathered 454,372 certified signatures. I was sent here to represent my district, people that watch the legislature extremely well, told me to be careful, watch out what's going on. The parents and guardians in my district were worried that the reason that Initiative 2081 was passed just this last session, matter of fact, 1 year and 1 week ago today, 82-15 from this floor, was to be able to change it. And that the only reason it happened was because it was a trick, is what they told me. I'm here to make sure that I fight for my parents and guardians and everybody else in the district, and that's why I stand before you today. By passing this, we tell them, no, we do care what you have to say. We're willing to have another referendum if we need to. If we're not following the will of the people of this state, we want to hear from you. We want you to let us know about it so we can represent them properly. Thank you.
Are there further remarks? The good member from the 16th, Representative Rood.
Thank you, Mr. Speaker. I just wanted to point out something I don't think has been mentioned. The only reason that this vote does not require a 2/3 majority is because of action taken last year by the legislature to pass this. My intent in voting for it last year was not to come back and gut it. Please vote for this amendment.
Are there further remarks? Seeing none, the question before the House is adoption of amendment number 358. We will proceed with a voice vote. For those in support, say aye. Aye. For those opposed, say nay. No. The amendment division has been called. The speakers have to open a roll call machine. The speaker has opened the roll call machine. Has every member voted who wishes to vote? Does any member wish to change their vote? The speaker is about to lock the roll call machine. The speaker is locked the roll call machine. Clerk will take the record.
Mr. Speaker, there are 37 yeas, 51 nays, 5 excused.
The amendment is not adopted.
There are no further amendments. The question before the House is final passage of adoption of Amendment 204 as amended. Remarks. The good member from the 49th District, Representative Stonier. Oh, Representative Santos, one of you should stand. Representative Santos.
Thank you, Madam Speaker. I ask for your support of the striking amendment as amended, and I will save my remarks for final passage.
Further remarks. Representative Rood.
Thank you, Madam Speaker. I will also save my remarks for final.
All those in favor of adoption of the striking amendment say aye. Aye. Opposed say nay. No. The amendment is adopted. There are no further amendments. The question before the House now is final passage of engrossed substitute House Bill 1296. Remarks. The good member from the It'll be advanced to third reading. Hearing no objections, so ordered. I'll get there. Engrossed substitute House Bill 1296 on third reading and final passage. The good member from the 43rd District, Representative Macri.
Thank you, Madam Speaker. This bill is essential to ensure that our state provides student-centered, success-focused education for all of our students. That means we need to create the conditions where people can both learn and teach in a way that we can thrive. This can't happen if our students are afraid to be themselves, if they feel like they can't get the help that they need or confide in somebody who they trust. I want to tell you a story, Madam Speaker, because I have heard a lot of stories over this past interim before we came here back in session about the conflict and confusion that the law has created. There is an educator who was approached by some students who wanted to start a gay-straight alliance in their school. The educator said, "Great, let's do it." But then pressure came from community, and administrators said, "No, forget it, let's not do it." The pressure caused that educator to leave the school. There is no advisor for the Gay-Straight Alliance, and the students do not have the support that they sought. We know when confusion and conflict seep into our laws, it has real effects on real people and real communities. I'm voting yes tonight for this bill, Madam Speaker, because this confusion is hurting my community and communities around this state, and I ask you to join me in voting yes. Thank you.
Further remarks, the good member from the 19th District, Representative Walsh.
Thank you, Madam Speaker. Please vote no on this proposal. Madam Speaker, the Washington Parents' Bill of Rights is good law. Our own state courts have concluded this, and more importantly, families and parents, and yes, even educators around the state have concluded this. Madam Speaker, our school system, our public school system in this state is in crisis. Its performance metrics are at historic lows. You've heard the numbers, of course. Something like 70% of the students in our public school system can't do math to grade level. Something like 50% can't read or write to grade level. Madam Speaker, enrollment is in decline statewide and particularly in hot spots around the state. Families are removing their children from the public school system. And Madam Speaker, when you talk to those families who are removing their children from our public schools, they will tell you it's because the family has no sense of contact or communication with the system that would teach their children. What the Parents' Bill of Rights does is it creates clarity, not confusion. It creates certainty, not obtuse evasion. It creates a system by which parents know what they can know what they can expect out of our education system, out of even health care and mental health care in certain circumstances. And that gives them the confidence to be engaged. They know what to expect. They know what they can request. They know what can't be hidden from them. This clarity, Madam Speaker, creates trust, creates goodwill, creates positive interaction, engagement, involvement. And when you talk to educators, Madam Speaker, as you know, they will tell you that the best way to make sure that a child receives a great education is that the parents are involved. Don't gut the Parents' Bill of Rights. Let it stand, as the courts are letting it stand, and vote no on this proposal.
Further remarks, the good member from the 37th District, Representative Santos.
Thank you, Madam Speaker. I'm very proud to stand and ask for your support tonight for this legislation that will clarify the confusion and the chaos in our communities that were created by the Initiative 2081. Contrary to what you might have heard tonight, this bill will not diminish parental rights. Rather, the policy before you both upholds and even expands through the adoption of several amendments, even this evening, the right of parents to support their students. But, Madam Speaker, we have to recognize that there are places in this state where parents have not always had the support of the law. For example, in Spokane, parents had to sue their son's middle school because the school did not contact the police to protect their son from horrific bullying and assault. So this is why this bill is supported by the PTSA. But more important, Madam Speaker, this bill supports students. It recognizes the individual rights that each and every student is endowed with to safe and supportive schools. I have to tell you, this is about this Walla Walla LGBTQ student who had to listen to a high school teacher say on record that he believes LGBTQ students should be lined up and shot. This student was shocked because he had played with this teacher's own children when he himself was a child. Madam Speaker, this policy communicates a clear policy that every student will be safe and supported. That's why this bill is supported by the Washington bus. Madam Speaker, finally, I have to say that this bill protects the rights of educators who are doing their job so that they will not have the fear of retaliation in supporting students in the exercise of their legal rights, in instructing students in accordance with the law. That's why this bill is supported by teachers, by counselors, by bus drivers, by paraeducators, by administrative staff. And Madam Speaker, this is why this legislation should be supported by you, because this is student-centered legislation necessary to help foster the conditions of teaching and learning so that students can thrive. Thank you.
Further remarks, the member from the 15th District, Representative Defoe.
Thank you, Madam Speaker. The remarks from the good lady from the 37th are informative to me. She talked about educator rights. She talked about student rights. The 450,000 people who signed the initiative, the legislators who represent the voters of Washington State almost unanimously voted for a parent's Bill of Rights. Not an educator Bill of Rights, not a student's Bill of Rights, a parent's Bill of Rights. I've been pretty fired up tonight, Madam Speaker, because I'm standing here as a dad, as someone who signed that initiative, as someone who voted for the people who voted in favor of that initiative, and now as a state legislator representing dozens of thousands of people in Yakima and Benton County. And I stand here with the other good members, the other good people in this chamber, Madam Speaker, asking you for a no vote on this bill, because it places the government between parents and their kids in matters of their education, in matters of their medical care, and in matters of imagery of them. We introduced amendments that would address each one of those things to preserve, rather than gut, the parents' Bill of Rights that the people asked for and that their legislators voted for. Instead, Madam Speaker, we blocked those. You and I blocked those amendments. Well, I didn't, but Madam Speaker, it's very important that we make sure that our parents have the rights to control and know about the curricula, the textbooks, the education, the medical care, when their children's images are being used, every time, every day, 100% of the time. Madam Speaker, please vote no on this bill so that we can preserve that right, so that we can give clear guidance, the clear guidance that is in 2081, that gives 9 delineated specific rights that a state court has upheld as crystal clear and implementable, that we are at risk of undermining here tonight. On behalf of all the tens of thousands of parents around Washington State, many of whom are watching at this late hour, let's stand for them. Let's stand for strong families. Let's stand for parents' rights. Vote no.
Further remarks, the good member from the 49th District, Representative Wiley.
Thank you, Madam Speaker. It's late at night, and I'm a little bit nervous at this point. This is a very important bill. When we're parents, we teach our children about our values, about our beliefs, and most of us try to be better people when they're watching us. In fact, when I had surprise twins, I stopped swearing until they were in middle school. That's how long that lasted. But you understand, that's why you're laughing. Today we're talking about what kind of environment we want our kids to be educated in. I believe that we all want what's good for our children. We want to be good parents. And tonight, I think this discussion is about what's good for children. We have to respect our parents. We have to respect our teachers. But this is all about safe kids. May I read, Madam Speaker?
Please proceed if it's relevant.
I'm going to read part of this. This is not my story. It says, for my son's entire high school career, he chose to express his chosen pronouns, he, him, to a select number of friends, family, and teachers. By and large, the teachers were supportive and made an effort to use the correct pronouns. But by his junior year, the administration decided to target trans students and the teachers who supported them. My son is tall and did not personally get bullied, but he witnessed younger and smaller LGBTQIA kids being bullied. Unfortunately, he also saw his favorite teachers being harassed online and retaliated against by administrators and our school board. He was afraid that if he told his teachers about the bullying, the teachers might get fired for doing anything about it. This is how the administration has institutionalized bullying, by making the victim afraid to talk out of fear of being outed to their parents, and by tying the hands of any adults who could help. We're grateful our son could come to us, and they're 1,000 times grateful for the staff who risked their jobs to create a safe environment for him and his friends. That's somebody else's story. I'm going to tell you my story. A lot of the people in this body are new. They weren't here when we passed Nikki's law. A few years ago, we had a member go over to the other body, and he left behind a bill that he'd introduced late that banned the trans panic defense.
You have 15 seconds remaining.
We had to pass a law to make it illegal to say it's okay to murder a trans person because they're trans, and you were surprised. Tonight, this is about our heart. We need to do what's right for our kids.
Further remarks, the member from the 16th District, Representative Rood.
Thank you, Madam Speaker. I've appreciated the stories that I've heard. They've been informative, and I just appreciate people sharing their hearts. I'm happy to use folks' preferred pronouns. That's a way that I feel like I can show respect to them. There are a variety of students in Washington State that include students who have other than traditional gender identities, and it is the state's duty to provide a safe learning environment for all students. A lot of these subjects are sensitive, and I think what I'm hearing in this chamber today is a lot of concern for student safety, and really that's based out of, I've heard that from a lot of parents, and those remarks are based out of love for their families and some pretty fierce defense of their children. I've worked on some issues related to bullying since I've been here. The harassment, intimidation, and bullying bill that came out a few years ago. That specifically mentioned it was directed toward trans students. One of the amendments that I was pretty disappointed in that failed tonight was the opportunity for parents to request a safety plan for their students. That kind of amendment is essential and supportive of loving parents that might not know that their child is experiencing some of these challenging issues and might face bullying. Bullying is a problem in schools, and that was a way that we could support families that are experiencing those. Ultimately, most parents, I believe, want to be engaged in their child's education. They want to stand alongside them when they're experiencing the challenges that life brings. And unfortunately, a bill like this creates a wedge between educators and parents and their own children, when young people don't know that all the time that their parent is there for them when these issues arise. So unfortunately, I feel like the consequence of this is quite a bit of division in the school system and in families. So I'm asking for your rejection.
Further remarks, the good member from the 30th District, Representative Reeves.
Thank you, Madam Speaker. I'm standing up tonight to vote in support of parents' rights. I'm standing up in support to vote for my rights as a parent, Madam Speaker. I'm the proud mom of a 4th grade daughter who, you might be surprised to learn, has as much attitude from her father as I have attitude in this building. I'm proud to be the mother of a 6th grade son who is thriving in middle school, Madam Speaker. And I'm voting yes tonight, Madam Speaker, because my #1 job as a mom is to protect my kids. My job, Madam Speaker, I think as a legislator, is to protect the kids in my community. Most importantly, Madam Speaker, I feel like my job is to ensure that I'm looking out and protecting kids who grew up like I did, without parents who were there to watch out for them, to fight for them, to love them. Madam Speaker, I'm standing up tonight in support of this Parents' Bill of Rights because another important job that I have as a parent is to provide. It's to provide safety and security for my babies. It's my job to provide safety and security for the 5th most diverse school district in the country that I am proud to represent, Madam Speaker. My job is to provide for every single kid in the state of Washington, all 1.1 million of them. And Madam Speaker, I'm standing up in support of this legislation tonight to continue to partner with our educators to ensure that they can prepare our children for the future. Madam Speaker, for a future that I believe is worth fighting for a future that includes every single one of those children. I'm standing up in support of this legislation, Madam Speaker, because I believe that our public schools have the ability to save lives. So I'm asking you, Madam Speaker, to join me tonight in saving our kids' lives.
Further remarks, the good member from the, I can't remember district, Representative Barnard, the 8th.
Thank you, Speaker Jenkins. It's been a long night, and I've appreciated hearing from everyone. Truly, it's been enlightening. And as this body knows, I have given birth to 6 children, so I have some experience in this area, some really lived experience in this area. I had those kids so that I could raise them. I had those kids because I wanted to nurture and love them. I don't want someone else taking that responsibility for me. I do feel part of my job as a legislator is to make sure that children have what they need, all children. I'm not just talking about mine. But my children, the ones that I gave birth to, I want to raise them. I don't want them to hand them off to the state or the school for their nurturing. And I understand that sometimes that's the only place other children get nurtured. But I am their parent. I want to be involved. I have a solemn responsibility as the mother of those 6 children to make sure that they are nurtured, loved, fed, provided for, taught. Yes, I say that to you, Madam Speaker. I want to teach my kids things like morals and values and civil service and how to serve and love other people and to not judge and to help those in need and to reach out and lift others up. And those are the kind of things that I want to teach my children. Now, I'm not going to teach them calculus. I'm going to depend on our schools to do that, and we do need to depend on them, but I don't want the schools to take control of raising my children. You know, it's been talked about tonight that this is confusing, that the Parents' Bill of Rights is confusing and it causes confusion. No, I think just the opposite. It provides so much clarity about responsibilities and roles that parents want to play. And I think as legislators, we must strengthen families. That is one of our primary responsibilities, is to strengthen the families and give parents and help parents be better and to do right by their children. And I'm urging a yes. Thank you.
Further remarks, Representative Chase.
Thank you, Madam Chair. When I had heard that Senate Bill 5689 had passed, I got involved with Referendum 101 to overturn that measure. And I became the Spokane County coordinator for signature gathering for Referendum 101. So I went for the low-hanging fruit. I went to the churches. I went to Catholic, Protestant, non-denominational, Slavic, Korean, Vietnamese, Hispanic, and black churches, a pretty diverse group. But they were all involved. They all mostly signed because they could see this wasn't about a tax levy or tax exemption. This is a moral problem that they were addressing. And so I even went to some of the churches that they didn't want to get involved, and it wasn't because that they thought we were wrong. It was because they were afraid of losing their 501c3 status. And I would quote Dietrich Bonhoeffer to them. Dietrich Bonhoeffer was probably the most foremost German theologian.
Representative Chase, it does not appear that you're speaking to the policy before us. Please speak to the policy before us.
Okay. The policy is that it seems like government solutions are replacing the church, and that's where a lot of the signatures came from that I had gathered. Those same signatures, we didn't make it quite enough. We fell a little bit short, but that made the basis for getting the initiative to pass too. So I think people fear that government is becoming like the church. It's replacing it. As government is providing us with our solutions, with our answers, with our sustenance. But I think it's more than that. It's we want to be able to raise our kids as we were taught, in our traditions, and this is replacing that. It should be up to the parents, how the kids are raised, because, I think we all want to provide sustenance to our kids, take care of them, take them to soccer games, but a lot of people worry about their eternal souls, too. That's another aspect of this whole debate. So I rise against this measure, this bill, this totalitarian bill, and thank you, Madam Chair.
Further remarks, the good member from the 21st District, Representative Ortiz-Self.
Thank you, Madam Speaker. I'm going to vote yes on this bill for all the parents that did not sign the initiative because they told me that they felt like their parental rights were already there, who told me that they believe that they are the prime caretakers of their children, but that they don't believe that their beliefs and the way they parent their children should be mandated on every other parent. I am standing up for the parents that signed the initiative and said, oh my God, what did I do? I didn't know it was going to cause these ramifications. I'm standing up for the teachers who don't know what to teach anymore. Is it okay to teach history? Is it okay to teach science? Is it okay to talk about people's ancestors without, at best, getting yelled at or at worst, getting sued? I'm standing up for the counselors who say to me, I don't know how to care for children anymore. I don't know if I'm allowed. Am I allowed to hear their pain? Am I allowed to sit with them in their hurt without getting in trouble? I am voting yes, Madam Speaker, on this bill for the students who don't want to see their history erased, who want to celebrate their ancestry. And Madam Speaker, I'm standing up for the 7 trans students I just met with, who said to me, I didn't know it was so hard. I just want to be able to exist. Madam Speaker, one of them told me, I don't know why we hate so much. I just want to be me. And Madam Speaker, all 7 of them told me that at one point in their life, they considered ending it because the burden was too big, because they didn't feel like they can handle the hate that was coming their way in all directions. Madam Speaker, I am standing up for them and letting them know that I see them, that I hear them, and that they are worthy of so much more. Please join me in voting yes, Madam Speaker.
Further remarks, the good member from the 19th District, Representative McIntyre.
Thank you. Good morning, Madam Speaker. I'll be voting no today. As you recall, I was a school teacher, and I think I have some knowledge on what we've been debating tonight. I remember having students that came from all different walks of life, and I had some students that were just on it. They had a good home that they came from. Things were going well. 2 parents, always got their homework done, straight A's. Others came from tougher circumstances, and they really struggled. And so you really got to see a bell curve in the classroom of the scores coming in. And, I always wondered if it was possible, if there was something I could have done that would have gotten everyone pushed to the right of the scoreboard, that everyone would have got straight A's, 100% down the line, that I could have gotten everyone where they were at. And I tried all kinds of different things, and some things worked for some students and some worked for others. Like I said, they came from different backgrounds, and there was a spectrum. But I always wondered, could I have done more? I really, really tried. But I have to ask, now that we can zoom out and look at the whole state and look at the whole statistical analysis, Madam Speaker, don't you ever just wonder? Don't you wonder if we're going the right way? Do you wonder if maybe we could do something different, something more? I've been in this legislature just a few years, but I've heard, if we do this, it'll work. If we do this, it'll lead to better well-being. If we do this, the scores will come up. And Madam Speaker, more students than ever are taken from school. The scores are at their lowest. And the mental health is at its lowest. That's the real myth, that, well, if we don't do X, Y, and Z, these students will be worse off. They are considering ending their lives. Madam Speaker, if that was true, the state of Idaho would be just covered with horror stories. But they do things differently there, and it yields different results. How is it, Madam Speaker, that just one state over, they blow us out of the water with their student achievement scores and do it for half the price? So it leads me to believe that there's something about policy. There is something happening in policy in Washington State which is leading to the horrible outcomes that we have. We can't blame it on COVID any longer. It's over. Other states have bounced back and have done better. And where are we? We're worse off than ever before. And so the arguments can sound as wonderful and as clean and slick as anything. I don't really care, Madam Speaker. I just want things to work, and they're not working. I feel like this is taking us further down the wrong road. Let's go back to something that works. Vote no.
Further remarks, the good member from the 7th District, Representative Abel.
Thank you, Madam Speaker. Madam Speaker, rising as a strong supporter of public education this evening, I'd like to talk a little bit about some of the issues underlying this bill as it pertains to rural Washington, and then talk about what I believe is one of the most pressing challenges that we face in our state and our country today, and that is the widespread decrease of public confidence in a number of our institutions. So as I believe you know, Madam Speaker, I grew up in Inchelium. I went K through 12 there in Inchelium. It's a small rural school. When I was there, I remember leaving school and heading out to get on the school bus. And at that time, we had 5 different school bus routes there, so 5 different buses waiting outside the school at the end of the day. Life has gone on, went back a number of years ago, and I was shocked in talking to some of the teachers to find out not only the decrease in the overall number of students, but we are down now to a single bus route. In other words, at the end of the school day, a single bus pulls up to take kids home. I talked to some of my contemporaries, people who I went to high school with, to find out where are the kids. And I found out from them that a lot of them are being homeschooled or attending small private academies that are there in the area. And asking why, I heard a lot of similar concerns to what were articulated by proponents of I-2081, concerned about the reach of public schools deep into the realm and the sphere of the family, and in some cases supplanting the proper roles of parents. That was concerning to me, Madam Speaker, and I heard a lot about that on the campaign trail. Now, admittedly, a lot of that was anecdotal, so I spent a little bit of time trying to do some additional research to see if we could find hard answers. And that leads me to my second point, Madam Speaker, about this crisis of decreased public confidence in our institutions. The Gallup polling organization issues an annual confidence in institutions poll, which shows the trend lines of public confidence in a wide variety of institutions. 4 years ago, they asked the American people, how much confidence do you have in our public schools? At that time, 41% had a great deal or quite a lot of confidence in our public schools. Last year, we're down to 29%, and that number appears to be going lower by the day. I believe the reason for that is some of the same concerns that are articulated by the proponents of I-2081. Madam Speaker, I would ask that we build confidence in our public schools, preserve I-2081, and reject this bill. Thank you, Madam Speaker.
Further remarks, the good member from the 49th District, Representative Stonier.
Thank you, Madam Speaker. The title of this bill is promoting a safe and supportive public education system. Support comes from in a number of ways, but one of the basic needs that we are not meeting is the sense of belonging. Students deserve an inclusive school environment where they see themselves reflected in the curriculum and they are able to participate fully in their community. We have playgrounds now that allow for wheelchairs and texture walls. We have history that tells true history, like the impacts of redlining on the ability to own a home, the real story of Executive Order 9066, and the real story of Indian American boarding schools. This is the kind of school environment kids deserve, where they can see themselves no matter who they are or where they come from. Social studies teachers and current events teachers that use real statistics about our immigrant population and how low the crime rate is in that population relative to the rest of the American population. I am a parent. You are a parent. Our rights were not undermined in the discussion of this bill. In fact, we discussed tonight how my right as a parent can be upheld in my ability to perhaps access language support if necessary to support my child in school. And this bill supports educators, staff, in making sure that those kids have this supportive environment that we're talking about tonight. But let me just talk to you about one more thing. What is it truly that our kids are experiencing? A boy in Everett was relentlessly bullied and ruthlessly beaten because he was gay, and his school environment did not protect him. Here in Olympia, a teacher believed a student to be suicidal and supported that student. The suicide rates, the depression, and the self-harm that some of our students are experiencing just because they do not feel that they belong is a problem, and yes, Madam Speaker, is an emergency. I ask you to vote yes, to provide a safe and supportive public education system.
Further remarks, the good member from the 25th District, Representative Keaton.
Thank you, Madam Speaker. I'm blessed to be able to represent Puyallup School District, having been also on the board for 8 years. That is a very safe and supportive school district. We started this last school year with "We Belong" was the theme for the entire district. And we mean that, and we love our kids, and we support our kids. I've been sharing the perspective from a large school district. May I quickly read a perspective from a small school district?
Please proceed if it's relevant.
This bill implies the educators don't already recognize the dignity and worth of every child, a notion that disregards the dedication of teachers, paraeducators, and administrators who already ensure all students are seen and supported. This legislation fosters division and mistrust, hindering bipartisan cooperation essential for nonpartisan school boards. Madam Speaker, in my district, we had to put a policy in place that politics were not allowed in the classroom. The reason for that was these politics were causing division and causing angst and fear amongst the children. We had to change our district strategy and put academics first. A school district had to come out with a new strategy to put academics first. We care about all these kids, no matter who they are, what they look like, who they love. We love them all. In an effort to be really caring, we focus so much on the social emotional learning part that we have not given any credence toward academics, where students feel that they can overcome obstacles and they gain pride in themselves and their ability for accomplishment. We don't focus on career pathways anymore like we used to. Not to the level where we get in there, we find unlock their passion in 7th or 8th grade so that they have a career pathway to the future, which gives them hope. Hope and academic achievement will change around our schools. They have to belong. We have to make sure they feel belonging and welcome. After that, politics needs to be out of the schools. We need to focus on academics, and we need to focus on career pathways so that they will become successful, so we can reverse the trend that we're showing right now, where 4th grade students have dropped 10% in math and English, and 8th grade students have dropped 10% in math and 20% in math and 8% and 10% in English. Thank you. Vote no on this bill.
Further remarks, the good gentleman from the 20th District, Representative Abarno.
Thank you, Madam Speaker. I think my favorite title is Dad. It definitely is my favorite job. I rise for all the little girls who are afraid of being assaulted going into a bathroom with men. And I rise for all the girls who fear being assaulted and intimidated, changing in a locker room with boys. As a dad of a young daughter, I know even my own feelings as we walk through SeaTac Airport and their new bathrooms. I remember her years ago. She would just walk into the bathroom, into the ladies' bathroom, and I would just wait outside for her. Now she goes into the bathroom, in a unisex bathroom, and there's all these men going in with her. And I'm fearful, and so is she. And there are stories across the nation of assaults that occur in such settings. And I rise and stand in opposition of this bill for those little girls. And Madam Speaker, I also rise for all the parents like myself who are fearful. It's not unwarranted to be fearful. It's not unwarranted to want to be involved in my child's life and her relationship with her school, to access her medical records easily, to access her curriculum and her schoolwork easily. And Madam Speaker, to be able to be part of my daughter's life in the most sensitive times, the uncomfortable times between a parent and their child is when the strongest bonds are built. It's where trust is built. The Parents' Bill of Rights helped strengthen those bonds and that relationship. At least it gave an opportunity and a pathway for it. Today, I feel it's weakened. I feel that those opportunities are fading away in this bill. And then the opportunity to gain access, to build that relationship, are slipping. So I rise for all those girls who are fearful, the bathrooms, the locker rooms, the parents who just want more access and a better relationship to build those bonds so that they're not taken away from them, but that hand is extended between the school district and the parent and the child in a partnership. And that's why I'm asking for a no vote.
Further remarks, the member from the 2nd District, Representative Marshall.
Thank you, Madam Speaker. I too want to have my children and all the children of Washington to have a safe and supportive learning environment. But I reject the notion that in order to do that, we must strip rights away from parents and guardians. I have trouble believing that the best way forward for a child's mental health is to make sure that the parents don't even know what's going on. I have trouble saying as young as 9 years old, a child can excuse themselves from school into this dangerous environment. Those are some of the policy issues I have with this legislation. But I also have grave issues with the procedural manner in which this got here. I have trouble rectifying how 450,000 plus people's votes and then the adoption by this body can be outweighed by agencies in our government who have issue with the underlying policy. I have trouble saying that we're going to block the people from even having the chance to run a referendum on this policy and have it go to a vote. We gave the chance tonight, and unfortunately, the people are being cut out of the decision. This is going to affect our state for a long time. We need to be rebuilding trust. The underlying policy that we're changing with this legislation today stems from years of distrust in the system. Years of distrust. If there was so much issue with this policy when it came up before, it should have gone to the people for a vote. And if it was really the wrong policy, the people would have rejected it then. And if this is the right policy, we really should send it to the people. I urge you to vote no with me. This is the wrong way for Washington.
Further remarks, Representative Ibarra.
Thank you, Madam Speaker. And I don't know if I ever told you, Madam Speaker, how I got here, and it'll be relevant. It'll be relevant to the bill in a second. When I got to the legislature, well, before that, I had a daughter. She was in elementary school, and there was an issue with some of the forms that they filled out. And I went to the principal's office at that time and talked to the principal and asked her about the procedures and policies of the school. And she said, well, my policy is so-and-so. And I said, okay, well, what's the number of your policies? She said, well, it's so-and-so. So I looked it up, just went on the website and looked it up. I said, I can't find that procedure or that policy. And I went back to her the next day and I said, hey, I couldn't find that policy. I didn't find a school policy. And the reason I bring this up is, so what happened the next day, I went over there and said, where's the policy? And she said, well, there's no policy for the school district. It's my school policy, this school. I said, okay, how's a parent like me supposed to know that? And she said, well, I sent the email to all the teachers. And when I said, okay, so she forgot that my wife at the time was on her staff. So I asked my wife and said, did you get a policy procedure for this issue? And she said, I've been looking for 2 years, no policy. So then I said, hey, we checked, there's no policy. And then what she did as a parent, and my rights as a parent, I said, well, then what's going on? How come you told me this when it's not true? And she said, well, you're out of here. And she did one of these. She goes, there's the door. And she threw me out of her office. And that's parents' rights. For my daughter, I'm there for my daughter to help. And she threw me out of her office. And as I walked out, I said, you know, that's never going to happen to me again. And the first thing I said was, well, how the heck is that not going to happen again? And so I said, I know, I'll become a school board member, and that will never happen to me again. So I became a school board member, and next thing you know, I'm sitting on the EOG committee, working for the rights of people of color, trying to get their grades up, working on curriculum with OSPI. I'm on every meeting at OSPI. I'm here in Olympia, working for the rights of kids and parents. We were making lots of progress in my pockets in my hometown. Our schools were doing really well. Started working in Olympia, trying to make progress here. Came here, became the ranking member of K-12. Thought we're making progress, but I'm also a statistician. And I was looking at the scores that we had across the state, finding that the policies that were getting passed in this House were not doing what they should be because the scores are low. I don't think this policy is going to do what we think it's going to do. It's going to keep the scores lower. We should vote no.
Further remarks, the member from the 6th District, Representative Graham. Representative Graham, it looks like you do not wish to speak. Is that correct? Okay, great. Further remarks. Representative Barkis.
Thank you, Madam Speaker. You know, Madam Speaker, it's been a long debate. And I was sitting here tonight just kind of thinking about, all the different things that were said about our schools, about parents, about guardians, about family. And I thought, Madam Speaker, last year was a really proud moment for me, Madam Speaker, here in this body, in my time serving in this body. I watched the people of Washington State rise up on an issue and meet with their friends and neighbors all over the state to sign an initiative on an issue that is truly important to so many. And Madam Speaker, in that short session, we had so many different issues to deal with on this floor. But you, Madam Speaker, and this body chose to bring that before this body for a vote. And we passed it. And I was proud of that moment. And then I went back this year, Madam Speaker, in the interim, and I went out to my school districts and I talked to so many different educators and superintendents about the problems that they were having in their districts. The problems with money, the problems and concerns about not being able to pass levies because of the issues that were stemming from many of the things that we heard tonight. The loss of community, the lack of community. You see, I think it's kind of the opposite. I told one superintendent, I said, you should hold a meeting and bring every parent, everybody you can to talk about the restoration of community and to put it back to the parents, not to the schools. But Madam Speaker, I just kept hearing over and over again, they're going to change it. You guys are going to change it. And I said, no, don't think so. Because we did last year, we voted it. We voted for it. We passed it. We put it into play. But here we are after 6 hours tonight? We're doing exactly what I said to the people who I talked to that we weren't going to do. We're voting for this. And Madam Speaker, I'm going to vote no, so when I go back and talk to those same schools and parents and people, I can say, you know what, I'm sorry. And I am. And I would encourage you, Madam Speaker, to join me in voting no on this tonight.
Further remarks? The member from the 35th District, Representative Couture.
Thank you, Madam Speaker. Madam Speaker, I've been, ever since I saw this bill, upset. I've been angry, maybe even a little combative. Madam Speaker, I've had people, parents in my district, email me thousands at a time, afraid of this bill. They were actually hopeful. I stood in the same exact spot last session, excited. We passed the Parents' Bill of Rights Initiative 2081. And a father in my district told me that when that initiative was passed, he had previously removed his 5 kids from public schools, but now he was going to put his 5 kids back into schools, into our public schools again. It was hope. It was hope in the beginning of rebuilding some trust with that family. But now with the threat of this bill, if it weren't to die tonight, that family is going to pull their 5 children out of the schools. That's almost $20,000 per pupil per year. We know that the trust is waning in our K-12 system. It's not only driving a wedge between families and the slow erosion of parents' rights in the state of Washington, but also it's harming our schools, which harms our communities. It harms them financially, as well as it harms the trust that the public has in them. Madam Speaker, I think that there's a lot of people probably afraid of this tonight, but probably not surprised. Like the good member from the 2nd said, there was a lot of people that probably predicted that we would be back here again. And that's sad. It's sad because parents have the absolute right for the education and upbringing of their children, unless there is child abuse and neglect that has been litigated over and over in the U.S. Supreme Court over decades. I don't co-parent with the government, and the schools have concerning secrecy policies where we're hiding curriculum and mental health records and so many other different things. Pierce County itself, Madam Speaker, over $50 million in payouts for sexual assaults in schools. Madam Speaker, the state doesn't own our kids. Please vote no on this bill.
Further remarks? Seeing none, the question before the House is final passage of engrossed substitute House Bill 1296. The Speaker is about to open. The roll call machine is having a technical issue. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted? Representative Entman? Does any member wish to change their vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Will the clerk please take the record?
Madam Speaker, there are 56 yeas, 37 nays, 5 excused.
Having received a constitutional majority, engrossed substitute House Bill 1296 is declared passed. With the consent of the House will now adjourn until 1 p.m. Thursday, March 13th, the 60th legislative day. Hearing no objections, so ordered. The House is now adjourned until 1 p.m. Thursday, March 13th.